Recording in progress.
Good morning, Judge. This is video. We are ready to begin. Your Honor?
Yes.
There we go. All right,
you.
perfect.
Excuse me?
See the defendants, are they ready to be sworn in?
Are the deceased defendants ready to be sworn in?
Los diputados están preparados para prestar juramento.
Okay.
Please see the jail.
Yes. Yeah. All rise.
¿De pie?
All rise.
De pie.
Please raise your right hands.
Por favor, levanten sus manos derechas.
Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
¿Juran o afirman que su testimonio será la verdad, toda la verdad y solamente la verdad?
Thank you.
Everybody, sit down, sit down.
Okay, so the first defendant is
Oh,
McCollum Regard.
Magdalene?
Sorry, Ashley Welch. Ashley Welch.
Last name was Welch, right, Your Honor?
Welch, yes.
And ASA Albert President, we have the state.
ASA David Lena, on behalf of the state, Your Honor.
Okay. Point the public defender for this case.
Good morning, Judge. Assistant Public Defender Crystal McCollum.
All right. All right. Let's see. So my apologies. First time. Miss Welch, you've been charged with battery under Florida Statute 784.03. Any probable cause argument? Public
None at
defender?
this time, Judge.
Okay, find probable cause. State, any prior convictions or anything else I should be aware of?
No, Your Honor, other than the state just asking for a stay away order and standard bond on this, Your Honor.
And Judge will be requesting PTS. She has no priors.
State,
The state's gonna defer to Your Honor.
okay, yes, okay, standard bond of 1,000 and release to PTS, pretrial services.
PTS alternate 1,000.
Excuse me?
PTS alternate 1,000.
Yes.
Judge, that's pretrial alternate 1,000?
Yes, I apologize.
Okay, thank you.
Yes, pretrial alternate 1,000. Okay, stay away order, standard stay away order. If I can have the, is it here?
I gave it to you, Judge. That's it.
Okay,
So each one of those judge, each one needs you to read, and if it's applicable, need you to initial. If it's not, just put in a.
okay, thank you.
Or sign at the bottom. Sure.
Judge, are you finished with this defendant?
No, I apologize. This is a little disorganized, so let me get my bearings straight.
Okay.
Um, Just try. Figure it out. Okay. I'm all over the place, so.
This is your calendar. This is your price. Stairway order. Your case history. So with this stairway of the judge, you need to let the defendant know before they leave. Who they need to stay away from, and
I don't really know.
go through all of those things, let them know they can't possess a firearm.
Is it a
can't,
felony one or?
You know, more crimes. So you just read that and initial if it applies. If it doesn't apply, then put in a.
Okay, I mean, we're not even at the felony stuff, so, yeah, I just prefer you don't have their stuff, just. Okay.
Do the parties, excuse me, does the defendant reside with the victim?
You live with him? No. No. No, Judge.
No, okay. Okay, so I'm gonna enter a stay away order. Ma'am, please do not engage in any criminal activity. I'm ordering you not to engage in any criminal activity. Do not use or possess any illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. The defendant is prohibited from having any direct or indirect contact with the following persons. The victim, Marcus Calixte, including contact in person, in writing, by telephone, through social media, or any other electronic means, or through third persons. Defendant must stay at least 500 feet away from the victim's house, place of employment, and or school at all times. That's it. Really?
It's a pre-trial order, so
Hold on a second.
initial everything. Did that apply just the NA?
Thank you.
That's the pre-trial order there.
Lord, I sent this.
Middle.
We have Ms. Mullins.
Hi, good morning.
Thank you.
Actual pay form and basis, yes. That goes to me.
That's it.
On the front, you sign where you wrote pre-trial. Okay, thank you, Judge.
Thank you. This is Rashida Mullings. Morning. Provisionally appoint the Public Defender's Office.
No PC arguments at this time, Judge.
Okay, probable cause found.
And we'll be requesting an alternate bond of PTS.
State.
No objection, Your Honor.
Okay, any, so no standard bond?
No, Your Honor.
Okay, any, prior history, prior convictions?
No prior, Your Honor.
Okay. I apologize. What was the, Public Defender's request for,
For PTS?
PTS? Okay, pretrial services,
Yes, Judge.
alternate 1,000 state? Are you asking for that?
Yes, Your Honor, and just to stay away order as well, Your Honor.
Okay, alternate of $1,000, pretrial services, and the stay away order, which I'll enter in a second. And of course, Ms. Mullings, you were charged with battery domestic violence under section 784.031A1. Okay. All right, ma'am, do not engage in any, excuse me, actually, does the defendant reside with the victim?
No, Judge.
And is it a familiar relationship? What is the relationship to the parties?
Son?
Son?
That's what we have here on the form as well, Your Honor.
Okay. Okay, Ma'am, do not engage in any criminal activity. Do not use or possess any illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file receipt with the court. The defendant, you are prohibited from having any direct or indirect contact with the following persons, minor, so PB 10/26/2010, including contact in person, in writing, by telephone, through social media, or any other electronic means, or through third persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and/or school at all times. That's it. Thank you. All these are transferred to DV, correct? Transferred back to TV?
These are the.
Garcia, it's your turn.
Stay away.
Thank you very much. Defendant Glass Garcia, appointing the Public Defender's Office. You've been charged with battery domestic violence under section 784.031A1. State.
Yes, Your Honor. So the state has no objections to PTS. There's no priors. We'd ask for an alternate of 1,000 and a stay away order, Your Honor.
Is there a probable cause argument?
No, Judge, not at this time.
Probable cause found, excuse me?
Identify her yet, so I can't tell whether she has priors or not. And she would have ordered her into future services.
Do we have any priors on her record?
I do not see any priors, Your Honor.
Okay, and you can confirm there are no priors, or you still do not know at this time if they have she has priors?
From base what we were provided this morning, Your Honor, there are no priors.
Okay, there are no priors. Okay, so, and again, pretrial services and the alternative standard bond?
Yes, Your Honor.
Defendant, any other requests? Public defender?
No, Judge, just the PTS alternate bond 1,000.
Okay, alternate standard bond. Give me a second. Okay, standard stay away order, do not engage in any criminal activity, do not use or possess any illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file receipt with the court. The defendant is prohibited from having any direct or indirect contact with the following persons. The victim, Luis Gonzalez, including contact in person, in writing, by telephone, through social media, or any other electronic means, or through third persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and/or school at all times. Does the victim live with the
No, Judge.
defendant? No? Okay. All right. That's it. Thank you very much.
Mr. Flanders is here.
Okay, Mr. Flanders. Morning, how you doing? Thank you. Mr. Flanders, you've been charged with making phone calls, threatening phone calls under section 365.161D. I'm provisionally appointing public defender's office. Any probable cause argument?
Not at this time, Judge, no. Sorry, Judge, not at this time, Judge. So I'm sorry, you didn't hear me. Not at this time.
Okay, probable cause found. State.
Your Honor, state would be asking for standard bond in this case and a stay away order from the victim, Your Honor.
Okay, what are the priors? Any priors I need to be aware of?
Yes, Your Honor. So there's priors for drug possession, so cocaine possession, which was convictions back in '98, but the most recent that we have, Your Honor, was gonna be in 2012 for child abuse, no harm.
Child abuse, no harm. Okay.
Judge, if I may, his priors are more than 10 years old. Additionally, Judge, he was given PTS in the felony, so we would also be requesting, since he does qualify for PTS in the misdemeanor as well.
State. They qualify.
So no, Your Honor. Well,
No objection or
yeah, we're objecting based on the open felony, Your Honor, so.
open felony from 2012?
No, Judge, he has an
Oh,
open felony currently,
Your
and in that
Honor?
open felony, he was given
Hello?
PTS per corrections.
Your Honor,
yes.
on his open felony, which is related F25-16400, he has pretrial alternate $5,001.
$5,001. Is that the standard bond?
No,
Yes, Your
that's
Honor.
with the related felony that he has open.
Okay. My apologies.
So yes, Judge, we can do dollar bond on a misdemeanor since he's gonna be held on the on PTS for the felony.
Okay, dollar bond,
Straight dollar bond.
straight dollar bond.
Your Honor, would you like to add this to pretrial? He has supposed to bond?
No, just straight dollar bond. Any
That's fine,
issue?
Your Honor.
Any
And the
issues?
stay away order.
Okay, yes, sorry, stay away order. Okay, Mr. Flanders, do not engage in any criminal activity. Do not use or possess any illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, any concealed weapons permits to the nearest police department and file receipt with the court. The defendant is prohibited from having any direct or indirect contact with the following person, the victim, initials MF, born January 2nd, 1981, including contact in person, in writing, by telephone, through social media or any other electronic means, or through third persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and/or school at all times. Is this, what's the relationship between the parties?
His sister, Judge?
Sister, do they live together? Or had they lived together?
No, Judge.
Okay.
They have lived in the past, but not currently.
Okay. Okay. Nothing else applies. Thank you very much. Get these back. Wait, no, sorry, Flanders.
Judge, that's person.
Oh, thank you. Appreciate that.
Mr. Brutus is here, Judge.
Thank you. Give me a second. Sorry. All right, Mr. Wilkerson, or sorry, Mr. Brutus, you are being charged with petty theft under section 812.014.
Judge, this is specifically for the petty theft will be addressed later. Right now, it's for the battery. It's
Okay.
M25-16645.
All right, thank you very much. Battery domestic violence, section 74.03, public defender's office is appointed.
No PC arguments at this trial, Judge. Time to time, Judge. Will be requesting PTS.
Okay, probable cause found. The eligible PTS
No.
is not qualified. Okay.
We'd be asking for standard bond, Your Honor.
Okay, what's the standard bond for this?
$1,000, Your Honor.
Okay, standard bond, I've been told by corrections that he does not qualify for PTS. So I'm gonna issue a standard bond of $1,000. Okay. Stay away order. Excuse me? There's no stay away order requested for this one?
Yeah, so we unfortunately don't have the arrest form. It's not provided to us. We worked on the docket.
It didn't have the victim's
No,
information on there.
Yeah,
Your
we're
Honor.
trying to tell you that there's two A forms. There's a petty theft and an arrest form. The arrest form's not online. And we don't have a physical copy either, so we're not able to make a stay away order at this time.
Okay, so you're not requesting one at all?
We are requesting one, Judge, so if you could issue a verbal stay away order, we don't have information accessible online or in person to be able to issue a stay away order ourselves.
Does the defendant live with the victim?
Yes, Judge.
Okay. All right, I'm gonna issue an oral stay away order. I can have the form so I can kind of follow the language. Thank you. All right, so I'm gonna order you to stay away from the victim, but do not engage in any criminal activity. Do not use or possess any illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. Again, you are prohibited from having any direct or indirect contact with the following persons. I'm not sure she's identified by name in the arrest form. But you are prohibited from direct or indirect contact with the victim, including contact in person, in writing, by telephone, through social media, or any other electronic means, or through third persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and/or school at all times. You appear to share a child, I believe. Is that correct? Share a child, and you live together. So I will give you, if you make bond, the defendant may return to the victim's residence one time only within 48 hours of the entry of this order, accompanied by a police officer to retrieve his or her personal clothing, personal health items, medication, personal and business-related paperwork, and work tools. Going to the home or remaining at the home without the police will subject the defendant to arrest. The police officer shall request all keys and garage door openers to the home from the defendant and turn them over to the victim. That's it. Thank you very much.
John, I'm sorry, what was the bond?
Standard bond, $1,000.
Thank you.
Judge, could you please ask the public defender for the name of the victim? Since we don't have that information, I don't know if we've already passed this case.
Public defender, do you have the name of the victim for Mr. Brutus?
Judge, he just left, and additionally, it's not on the A form, so we do not have that information.
Okay.
And Judge, we have Mr.
Judge,
Kyrie Antoine here.
Give me a second.
Judge, I'm not sure why this issue is happening. I don't know why we weren't provided an A form. I don't know why it's not online. The clerk also doesn't seem to know why that happened. I guess it's a paperwork issue.
No,
And
we have the A form. You're saying that the name is not on the A form.
we don't have the A form.
I gave us the A form to.
I'll show you what we have. We don't have the A form.
No, he's saying that he has an A form, but on the A form, what he has no victim information. Or the battery. Yeah, he has it. He has the A form.
I have the A form and I do not have the victim name.
So, same problem.
Excuse me?
We have the same problem. It's
Is this the next case you have the same problem with?
No, it's the same problem with that case. I don't know how to fix that problem. I don't think we can, Judge.
Okay. Mr. View, is that correct?
Yeah.
Okay, Mr. View, you've been charged with battery under section 784.03, appointing the public defender's office.
No argument at this time, Judge, but we will be requesting PTS. No priors.
Okay, no PC argument.
Not at this time, Judge, no.
Okay, and who is the victim? Can we get the victim's identification in this case?
I'm sorry, Judge, what was the question? I apologize.
Victim's name. Can we get the victim's name?
I have it listed as Jasmine Blackman, Your Honor.
Where's that on the A form? Is that on the A form?
It's on the one of the last pages, Your Honor, where it has all the witnesses and officers' information.
Okay, so you have the victim name, okay. All right, state what are you seeking for the bond or a PTS?
No objections, PTS, Your Honor, no priors, as
Corrections?
stated.
Qualifies, okay. All right, so release the pretrial services and the alternative standard bond. What's the standard bond, $1,000 for this one?
Yes, Your Honor.
Standard bond of $1,000, or, you know, the alternative PTS?
Your Honor, that was PTS alternate 1,000?
Yes.
Thank you.
And you're requesting a stay away order?
Yes, Your Honor.
Assuming? All right, stay away order. Mr. View, do not engage in any criminal activity. Do not use or possess any illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. The defendant is prohibited from having any direct or indirect contact with the following persons, which is the victim, Jasmine Blackman, including contact in person, in writing, by telephone, through social media, or any other electronic means, or through third persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and or school at all times. I understand from the A form that you no longer live together. Is that accurate?
Yeah.
Okay. So there's no need to return home. Okay. That'll be all. Thank you.
And Your Honor, I'm sorry, this is video first appearance. What was your name again for the record?
Sorry, Judge Perez Santiago, Jorge Perez Santiago.
Thank you so much.
Mr. Tyler. Good morning.
Good morning.
All right, give me a second, sorry. You've been charged with battery domestic violence, section 784.031A. I'm appointing the public defender's office. Any probable cause argument?
Not at this time, Judge.
Okay, I'm making a probable cause determination, finding. State.
Yes, Your Honor, no objection to a PTS with an alternate of 1,000 and a stay away order, Your Honor.
Okay, and it qualifies. All right, Peralta says they qualify, or he qualifies, so I'm gonna order PTS, the alternative, $1,000 bond. That's, excuse me, it's a standard bond, $1,000.
Yes, Your Honor.
Want to make sure, thank you. And the stay away order, give me 1 second. Does the victim live with the defendant?
Yes, Judge.
Okay. Do not engage in any criminal activity. Do not use or possess any illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, any concealed weapons permits to the nearest police department and file a receipt with the court. The defendant is prohibited from having any direct or indirect contact with the following persons: Dwayne Brownfield, including contact in person, in writing, by telephone, through social media, or any other electronic means, or through third persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and or school at all times. The defendant may return to the victim's residence one time only within 48 hours of the entry of this order, accompanied by a police officer to retrieve his or her personal clothing, personal health items, medication, personal and business related paperwork, and work tools. Going to the home or remaining at the home without the police would subject the defendant to arrest. The police officer shall request all keys and garage door openers to the home for the defendant and turn them over to the victim. Thank you very much. Good morning, Mr. Brailsford. We're here for the 2 counts of battery. State.
Yes, Your Honor.
2 counts of battery. All right.
Does not see any priors, Your Honor. No objection to PTS with the standard bond set of 1,000 in the alternate and a stay away order, Your Honor.
Okay, Public Defender's Office is provisionally appointed. Any probable cause argument?
None at this time, Judge. We're just requesting the PTS.
Your Honor, that's PTS altered in 1,000 on both counts.
State, yes. I'm gonna PTS, standard bond. Both counts. I'm gonna read the stay away order now. Do not engage in any criminal, excuse me, these are, do you live in the home with these individuals?
I live
No.
in there by myself, sir.
No, Judge, he does not.
Okay. Do not engage in any criminal activity. Do not use or possess any illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file receipt with the court. The defendant is prohibited from having any direct or indirect contact with the following persons: Malika Ivy, including contact in person, in writing, by telephone, through social media, or any other electronic means, or through third persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and or school at all times. Thank you very much. Sorry, there's another one. I apologize. Can you bring him back? Mr. Brailsford? Thank
Here.
you, Clerk. Sir Clerk. Thank you. All right. Mr. Brailsford, sorry, there's a second victim. So do not engage in any criminal activity. Do not use or possess any illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file receipt with the court. The defendant is prohibited from having any direct or indirect contact with the following persons: Hubert Ivy, including contact in person, in writing, by telephone, through social media, or any other electronic means, or through third persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and or school at all times. And this, Hubert Ivy, do you live with this individual?
I live by myself,
He
sir.
lives by himself.
Lives by himself, just making sure. All right, thank you very much. Now, he may. All right, Maurice Bernard.
He's here, Judge.
Yes.
All right, Mr. Bernard, you're being charged with battery, domestic violence. Sorry. Battery domestic violence under section 784.031A1. I'm appointing your public defender.
No argument at this time, Judge.
All right, finding probable cause. State,
Yes, Your Honor.
pretrial release conditions.
Judge, he does not live in the state of Florida. He does live in New Jersey, so he would not qualify for PTS. So
Okay.
standard.
Qualify. Corrections agrees. Okay, standard bond of
Yes.
$1,000.
Yes, Your Honor.
And stay away order. Let me see where it is. All right. And the victim has returned to New Jersey, or does the victim? Anyway. All right, do not engage any criminal activity. Do not possess, use or possess any illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, any concealed weapons permits to the nearest police department and file receipt with the court. The defendant is prohibited from having any direct or indirect contact with the following persons: Yasha Munson, including contact in person, in writing, by telephone, through social media, or any other electronic means, or through third persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and or school at all times. The protected party live with you? Does the victim live with you, sir?
Yes, yes, Judge.
All right. The defendant may return to the victim's residence one time only within 48 hours of the entry of this order, accompanied by a police officer, to retrieve his or her personal clothing, personal health items, medication, personal business related paperwork, and work tools. Going to the home or remaining at the home without the police will subject the defendant to arrest. The police officer shall request all keys and garage door openers to the home from the defendant and turn them over to the victim. Thank you. See. DV warrant. Okay, the DV warrant for Joel Joseph.
Yeah, with that. Got a warrant, so, or the warrant, set aside the warrant. We're gonna set aside the warrant on the second one. We're going to, our artist, gentlemen. Set aside the warrant, we're gonna set it for civil contempt. On 8/12, 1 p.m. for room 2A.
Okay, so I just have to announce that?
Yes, and I need you to sign the document. Also, I need to verify his address, make sure we have the correct address.
Okay. So is Mr. Joseph part of the Zoom hearing? Or?
Yeah, he should be.
Mr. Joseph here?
Yes, Judge.
Yes, how you doing, sir?
Oh, sorry. Okay, all right. So, what's your contact information, Mr. Joseph?
My contact information is 786 414-7403.
What's your address? Sorry.
My address is 314 Northeast 115th Street, Miami, Florida, 33161. Just want to know the follow-up so I can obtain that.
331, excuse me, with the last zip code?
33161.
33161.
Yes, sir.
House one.
Is it a house or an apartment?
It's a triplex, but it's a duplex house.
Yes.
Miami Shores, Barry University.
Okay.
Yes.
All right.
Judge, in these instances, I believe, they get ROR'd and then they get a date
Yes.
for them to appear.
Yes, so, yes, I'm gonna release on recognizance and set on civil contempt calendar on August 12th, 2025 at 1 p.m. in courtroom 2A in the courthouse center.
All right, thank you, Judge. One more.
One person. And I need you to write ROR, set aside DV warrant. Step for civil, the same thing that you just wrote out. So, my column. This column is here. They are here. Thank you.
Thank you very much. Thank you. You too. That concludes the domestic violence calendar. Thank you very much.
And Judge, just to confirm, for the courtroom, it's in the Lawson building.
Lawson Building, Courthouse Center? Yes, Lawson Building.
Thank you, Judge.
Morning.
Good morning, Your Honor. This is Joanne Hennessy. I'm here with the City of Miami Beach for the misdemeanor, the jail arraignment calendar.
Thank you very much.
Thank
Your
you.
Honor, this is video. I'm going to stop the domestic violence record, and as soon as you're ready, I can begin the misdemeanor one.
Thank you. I'll let you know.
Recording stopped.
have the accused
Recording in
been sworn
progress.
in?
Yes, Judge, we're ready whenever corrections is ready.
Is corrections ready?
Yes, Judge, they're ready.
We are also ready and on record.
Okay, I'm Judge Jorge Perez Santiago. Can I get appearances from the state and the public defender's office?
Yes, Your Honor. ASA David Linares on behalf of the state.
ASA Albert President on behalf of the state.
Assistant Public Defender, Chris McCollum.
Okay, someone else in the courtroom?
I'm private counsel looking for felony case.
Okay, sorry. All right, and I believe offline, the city of Miami Beach.
Your Honor, Joanne Hennessy for the city of Miami Beach for the jail arraignment calendar.
Okay, and to the extent we need a court reporter, can the court reporter please enter an appearance?
Your Honor, are you referring to me?
Court reporter, excuse me, not court reporter, I apologize, the interpreter.
Morning, Your Honor. Arturo Suarez Silverio, certified interpreter, Spanish. Thank you.
Thank you very much.
I can also announce if you'd like, Bianca Fajardo as Cites Video Court.
All right, thank you very much. All right, first individual, Corey Green.
Judge, that's a bond out.
That's a bond out. Okay.
Martina Caballero is also a bond out.
Wait, excuse me, public defender, can corrections do their job, please? Thank you.
Thank you.
Judge, there's a stay reorder filled out in the case of Green. Do you want us to pass that out?
Yes,
All right.
It's a bond. We don't need that. If it's a bond out.
never mind. Never mind, thank you. And you said Caballero is also a bond out?
Yes, Your Honor.
Martina Caballero?
Yes, she's a bond out, Your Honor.
Valeria Marcela Lafauci or Lafauci?
Bond out.
Please let me know if I need to slow down or.
No, it's good.
All right, thank you. All right, Christina Moreno.
She's here, Judge. This is a bench warrant for Ms. Moreno for.
Your Honor, she also has an open felony. She'll be back on your bond hearing calendar.
Okay.
Right, Judge. So, for context, Miss Moreno received a bench warrant for failing to appear at trial because she bounced out of pretrial diversion. She is homeless. So once she bounced out and then notice was given to the court issued notice, there was no way for her to get any subsequent notice because she has no mailing address. So failure to appear was not willful. We'll just be asking for an ROR or a dollar bond.
Okay, and she's here for the bench warrant misdemeanor?
Specific, yes, Judge.
Okay, sorry, I need to follow the process.
That's
The public defender's office is appointed. No probable cause argument?
No, Judge. So for bench warrants, there's no PC. I'm more so arguing whether failure to appear was willful or not. It's not willful in this case. Like I said, she had PTD. She bounced out of PTD. Notice was issued. She is homeless, so she's unable to receive any notice. So she was not aware that she had any court dates. So we're arguing that failure to appear was not willful. We'll be asking for an ROR, or in the alternative, a dollar.
Your Honor, the state would argue that this is a willful, wanton, and failure to appear when someone enters PTD. It's a diversion program. They provide their contact information to the program. Program has a way of contacting them. This is a willful, wanton, and failure to appear. We would ask that you convert the bench warrant amount to bond amount.
Judge, specifically, I believe if you could double check, but the PTD was court options. I believe she might have been in the jails division when that was extended. I could be wrong. But you would court options is a little bit different, and it's more, I guess, for homeless clients than it is for anything else. So
Your Honor, either way, court options would have some kind of way of contacting them. They don't take people without taking their contact information. There's a sign up process. Their information is taken by the court options program. They have a way to contact this person.
Okay, so what are you asking for in terms of a bond?
We
Or,
can convert the bench warrant amount to bond amount.
okay, what's the bond amount?
Judge,
Bond amount is 3,500.
Judge, 3,500 for someone with that's unhoused, it's tantamount to no bond. Additionally, once a PTD bounce out happens, it's the court that's noticing, it's supposed to notice the defendant, not the pretrial diversion services. So again, we would be requesting ROR or a dollar bond. Additionally, she has a felony open already, Judge. I don't think it would be necessary to convert it to $3,500 bond.
Okay, so I'll do a dollar bond. When's let me see the hearing date, homeless calendar date. Since you're telling me you're homeless, to the extent you do happen to get released, the homeless calendar date is September 10th, 2025 at 8:45 a.m. Courtroom 6-8. Excuse me, only ROR. I apologize. Thank you very much for correcting me. Appreciate that. All right, dollar bond. Anything further?
That's it, Judge. Thank you. You'll be.
Did you write anything? No.
Yes, I don't know if I signed it. Did I?
This the bench warrant.
Aha.
Just scratch it up. That's why, yeah. No.
Thompson's here, Judge.
Yes. Thank you.
Shaquandra Thompson.
Yes.
Miss Thompson. I believe you're here for the 2 counts contributing delinquency to a minor under section 827.041A and another violation under 812.014 2E. I'm going to go ahead and point the public defender's office.
No PC argument at this time, Judge.
No PC arguments. Okay, so probable cause is found. Release conditions state.
Your Honor, the state would be asking for standard bond on both counts. Defendant previously in 2020 completed PTD for a petty theft, so this would be their second, Your Honor.
Okay.
Judge, we would be requesting an ROR or PTS in the alternative. One PTD offer. There's no extensive criminal history here, Judge, and it was in 2019 that this case happened. So it's been a significant amount of time since then.
Issue the standard bond of $500 for both counts. Okay, and this is a stay away order. This cause, the defendant shall stay away from the following address area: 11401 Northwest 12th Street, number 4454, Sweetwater, Florida 33172. This order shall remain in effect until case is closed, modified by the court, or for a period of 6 months. Please write on this form. Please write. You. All right, next matter, Diana Martinez Cruz. Is that the defendant here?
No, it's a bond out, Judge.
It's a bond out.
Don't worry, I try.
Thank you. Oh, is this? Summer Smith?
Ms. Summer Smith is a bond out, Your Honor.
What do I do with this? Okay. Alexander Obregon? Is this
Judge,
Alexander
there was an
Obregon?
add-on.
I'm sorry, who did you call, Your Honor?
Alexander Obregon?
Your Honor, we have a
An
add-on, Miss Dorleen. First name is Jade.
Give me 1 second. At the end.
Yes.
Sorry. This is the bottom pile too. Sorry, looking for the documents. The file. Okay, Geraldine Dorleen.
Yes, Your Honor. She also has a fugitive warrant from Seminole County. It's a VOP, total bond 500.
Yeah, my apologies. Give me 1 second. Do I have that file? Other than this? Other than this, I have anything else?
No, that's the traffic.
Oh, it's a picture. Okay, public defender's been appointed.
Yes, Judge, this is a bench warrant case, based off of my conversation with Ms. Dorleen. The address that's on file with the clerk of courts is not the correct address. She has not lived there for more than 7 years. Her correct address, which we can update right now, for her to receive proper notice. So we'll be asking for an ROR.
Date.
Your Honor, for the record, could we get the case number for this one, Your Honor?
Sure, it's A7Y 69XE.
Yes, Your Honor. So if they'd be asking in this situation to convert the bench warrant to the bond amount.
And the bond amount is
Your Honor.
$1,000.
Judge,
Your Honor,
again,
we have 3,000.
I understand your argument. I heard your argument. She has a notice provision elsewhere. What is the operated without a valid license? Okay, where is their current address? You said you had it updated?
Judge, it's 115121. Oh, sorry, 11512 Southwest 254th Street, Homestead, Florida 33032.
Okay, and so the argument from defendant is that the address where she received the notice to appear was the incorrect address?
Yes, Judge. So failure to appear was not willful because the notice that it was sent to was not the correct address.
Do we have any evidence from the state on willfulness?
No, Your Honor, no objection.
No objection, so ROR. Okay, ROR. And just sign. Put the address information on the little yellow tag.
Okay. Here, it's fine.
ROR. Thank you. That'll be all, ma'am.
Want to put it next to you, John?
Yes. Sorry.
You got it, but I have to be able to follow.
Okay. This is Alexander Obregon. Sir,
Your
you've been
Honor,
charged.
he's a bond out.
Mr. Obregon is a bond out too.
Yes, Your Honor.
Okay. So who's this individual?
That's the next defendant on calendar, Mr. Savoy. I might be mispronouncing the name.
Your Honor, Joanne Hennessy for the city of Miami Beach.
Right, camping prohibited. Mr. Savoy, you've been charged with a Miami Beach ordinance violation, camping prohibited.
Yes, sir.
Statute 70-45.
Yes, sir.
All right, Public Defender's Office is appointed. Any argument on probable cause?
Not this time, Judge.
Okay, Ms. Hennessy?
Your Honor, we'd ask for a standard bond in this case. Mr. Savoy has open, I think, an open misdemeanor, as well as several priors. In 2025, he's had multiple arrests and convictions, and then prior to that, burglary and battery in 2022 convictions. We'd ask for standard bond.
Okay, Public Defender's Office?
Judge, we will be asking for a dollar bond and a date certain on the homeless calendar. If any other bond judge will be tantamount to no bond, he is currently homeless.
I understand the argument. I'll issue a standard bond of $150. Is the next defendant Joshua Shepard?
Here, Judge.
Is it Joshua Shepard?
All right, sir.
Okay. All right, Mr. Shepard, you are charged with trespassing property after a warning under section 810.09(1)(a)(1). I'm appointing the Public Defender's Office. Any argument, probable cause?
No, Judge, not this time.
All
No,
right,
Judge, not this time, sir.
probable cause found. State, any release conditions?
Your Honor, no objection to PTS and alternate bonds set at 500.
Public
Judge, we
Defender's
will be requesting an ROR. He is homeless, with a date certain on the homeless calendar.
Okay, I'm gonna order pretrial services.
Judge, pretrial
And
services wouldn't be applicable here. He does not have home housing, so that's why we're asking for an ROR with a date certain.
state,
No objection, Your Honor.
okay. ROR, what's the date certain? This is a homeless calendar, correct? And it's ROR. Mr. Shepard, the next calendar date for you is September 10th, 2025 at 8:45 a.m. Courtroom 6-8. Do you have any relatives or anybody we can contact otherwise to let you know or reach out to you somehow?
Judge, we have we're gonna give him this paperwork with the notice information for it.
Understood, but is there anybody else that we can also notify if we can't track you, find you?
Judge, he can provide us with his cell phone number.
All right,
Get in
that's
contact.
fine. That's fine. All right, again, homeless calendar date, September 10th, 2025 at 8:45 a.m., courtroom 6-8.
Grant's present.
Mr. Grant, Judge Perez Santiago, this is, you've been charged with petty theft. 812.014, section 3A. Appointing the public defender's office, any probable cause argument?
Not at this time, Judge, no.
Your Honor, Mr. Grant is held on two ACs, no bond, F-25-105, F-24-26766.
He's held on two ACs, you said?
Yes, Your Honor.
Okay, I apologize. I don't speak criminal code. What is AC?
Arrest capias.
Arrest, what?
Capias.
Arrest capias. All right, thank you very much. I apologize.
Alias capias, sir.
Capias?
I'm used to dealing with bench warrants. I'm still in county court, so that's alias capias.
Alias capias. All right, thank you. See, look at that. We're all we're all rookies here, I suppose. All right, alias capias. And what was the rest? I apologize. Corrections?
He has two AC cases,
Mhm.
F-25-105, F-24-26766. He's held no bond on those two cases.
No bond in those cases. Okay. All right. State.
In this case, Your Honor, we'd just be asking for standard bond.
Public Defender's Office.
Judge would just ask for a dollar bond. He's already being held, no bond.
No objection, Your Honor.
Okay, dollar bond. Did they write that in the action? Mr. Balafas? Or, correct?
Yes.
All right, this is 3 counts of, 3 counts, 1 count of petty theft, 2 counts of resisting officer without violence.
Yes, Judge,
appointing the
I
pub-
have a PC argument, sorry.
Sorry, okay, I'm appointing, Public Defender's Office. What's the probable cause argument?
So for the first charge, which is petty theft, at best, it could be an M2, not an M1. The dollar amount listed on the arrest form is below $100, so that's an M2. And for the 2 counts, at best, it could be 1 count.
Only one.
1 count of resisting an officer without violence, considering that it is a continuous chain of events that's happening, and I'm not sure where the separate resisting events come into play. So I bet it best will be 1 count of resisting without violence.
They,
Yes, Your Honor. So no objections as far as the initial argument as far as the petty theft being an M2. But as far as the resisting, Your Honor, it's 2 different officers. I understand that, yes. It's 1 continuous event potentially, but I mean, it's 2 officers given 2 commands and the defendant wasn't listening to those commands, Your Honor.
okay, give me a second to review the A form. Okay, I agree with the argument on petty theft, and disagree with the argument on resisting 2 separate officers. So I'm gonna find probable cause on the 2 resisting charges. So what release conditions are we seeking here?
Your Honor, so the state would be asking for an elevated bond, 1,000 on each. The defendant has recent convictions in 2024 for retail theft, petty theft, and grand theft, Your Honor.
PD?
Judge, we would be requesting, well, At this time, we'll be requesting, I guess it's on a standard bond. A lot of the priors, I do see there are no action or some of them are null prost. So yes, Judge, we'll be requesting a standard bond.
Standard bond for the,
And if he does qualify, PTS.
okay, the standard bond is $500 for the 2 resisting charges, so $1,000 total
Yes,
in
Your
the
Honor.
in the M2.
And the
Is a lesser
M2
included, I assume. What's the standard bond for
That'd be
M2,
100,
PD?
Your Honor.
$100?
Yeah.
Okay,
Your Honor, I'm
standard,
sorry, can you tell us the bonds for each count, please?
excuse me, all 3 counts, $100 for the petty theft M2. The $500 for the resisting officer without violence, and $500 for the second count for
Judge,
resisting officer
for,
without
yeah,
violence.
for the petty theft M2, it's 150. It's standard.
150 standard, excuse me. 150. Count 2 $500 and count 3 $500. And any argument from the state on the PTS?
Just based on the priors that I mentioned, Your Honor, these. he
Okay,
has
so you're
several-
still objecting to PTS?
Yes, Your Honor.
Okay, so I'll just go to standard bond amount.
5,500 and 500.
Yes, I'll write that here.
Yes, Judge, in the same area.
This is Tyrone Sands. Is this Tyrone Sands?
Yes, Judge.
Okay, so Mr. Sands, you've been charged with trespassing property after warning under section 810.091A. I'm appointing the public defender's office. Any probable cause argument?
Judge, I would argue that this is a trespass property after warning. The warning specifically is not specified. It just states in the arrest form, a records check revealed. There is no citing to a police case number or case number referencing said warning. It just says from the business July 2nd. So I'll argue that there is no PCN to release outright.
State.
Your Honor, 1 second, please. As we're reviewing the A form, no objection, Your Honor.
Okay, so no probable cause.
Your Honor, that's no PC, release outright.
Release outright.
And Judge, can we get a date certain for the homeless calendar?
Yes, ma'am. The homeless calendar date. Excuse me? No, not for this. Okay, because he's released. Yeah, he's released. Not ROR. Yeah, gotta be on your toes with me. Gotta be on your toes with me. All right, this is Mr. Brutus. Oh, no, sorry. It's Mr. Sandstill. Thank you.
Your Honor, on his DV case, you gave him a bond of 1,000.
Yes. Someone will open it.
Okay, Mr. Brutus, this is a petty theft, M2. Section 812.0143A. I'm appointing the public defender's office for this charge as well. Probable cause argument.
Judge, it's a bench warrant. We will be arguing that failure to appear was not willful. Again, this was an address issue. We updated his address for the DV case.
Oh, he has a stay away order now for the DV, correct?
Correct.
So that's
Yes,
not
Judge.
his address for now.
No, so Judge, the charge here is petty theft.
Correct. I understand that, but I said it, stay away order.
Oh.
So his address for time being while the stay away order is in place.
Apologies, Judge, wrong defendant.
No worries. Is the wrong defendant? Excuse me?
No, I'm sorry. My argument was for the wrong.
Ah,
I apologize.
no worries. Do we already, no probable cause argument then?
Judge, we'll be asking to ROR him on the petty theft or a dollar bond.
Your Honor, the state would be objection. We'd be asking for a standard bond of 1,000 in this case.
Is this a similar issue with bench warrant?
Yes, Judge.
Okay, so there's no argument on willfulness.
And Your Honor, the
Sorry,
defendant
Judge,
has
I'm
a
asking
current
for-
open misdemeanor case for petty theft. I can give you that case number, Your Honor.
Okay, so he has an open case for petty theft as well?
No, Your Honor, that is this case. He was picked up on the bench warrant for the battery domestic violence where there was a bench warrant issued. The petty theft is the brand new case. He happened to have a bench warrant open for the battery. So we're just asking for standard bond on the petty theft.
State, you have it backwards. The bench warrant is on the petty theft.
Okay, but sorry about that, because the prior sheet that is in front of us, it shows that the bench warrant is on the battery charge. It just shows. Okay, then Judge, we have no objection to ROR if this is the same address issue.
No, I understand that this is a different argument, that she was, public defender's office is making an argument on the wrong case file.
Oh. On the, are you saying that she was making the argument on the battery instead of the petty theft? Or a
No,
completely
the
different-
battery we've already addressed. I'm discussing the petty theft right now. That's where the bench warrant is issued on.
Right, and you made an argument previously about the address issue
And that's why I said it was the wrong defendant that I made that argument for.
Correct.
It
That
was a
was-
mistake
that's-
on my end.
clarifying the record. So there's no address issue with this file.
Okay. So no objection to the ROR, Your Honor.
Okay, no objection to ROR. We're gonna do an ROR on this count.
You Judge, yes.
And there's a stay away order for non-domestic violence. The court orders the defendant to stay away from the following address, area Walmart at 1425 Northeast 136th Street. This order shall remain in effect until the case is closed, modified by the court, or for a period of 6 months. Mr. Cedric Ladler, you've been charged with trespass of a structure that's unoccupied under section 810.082A. I'm appointing the public defender's office. Any argument on probable cause?
Judge, this is a bench warrant case as well.
This is also a bench warrant case? Okay, sorry. So this is a bench warrant case. Any argument on that?
One moment, Judge.
by day, I would have.
Judge, so we would argue that failure to appear is not willful, in this case, because he did not receive notice. Mr. Ladler indicated that he was not in, the state of Florida at the time when the notice was sent to his address. So we would be asking to ROR.
Where was he?
He was in North Carolina.
State?
Your Honor, so the state would be objecting, I mean, the defendant knew that he had an open case and he should have been receiving mail wherever he was at, Your Honor. So that, in our opinion, is willful, Your Honor.
Okay, so what are the release conditions you'd like?
So the state would be asking for the bench warrant to be converted to the bond amount, Your Honor.
And that bond amount is
$100, Your Honor.
$100, okay. I'm gonna convert the bench warrant to a standard bond of $100.
Judge, Mr. Wright's present.
Okay, Eli Wright, Mr. Wright, you have been charged with trespassing property after warning under section 810.091A1. Appointing the public defender's office. Any argument on probable cause?
Judge, no PC arguments at this time.
This is mine, this is, okay. I apologize, I didn't hear that, if you made an argument on probable cause or not.
Yes, Judge, no PC arguments at this time. He is, Mr. Wright is homeless, so we will be requesting ROR with a date certain on the homeless calendar.
Okay, probable cause found.
Your Honor, state would be asking for a standard bond. In this case, defendant has numerous prior convictions.
Okay, and standard bond's $500.
Judge, the previous convictions, I do see one, the last one was from 2023, and it has nothing to do specifically with the trespass. None of those other priors have anything to do with the trespass convictions or not. Again, he is homeless.
Okay,
A
and
bond
you're
in this case
seeking,
will be tantamount to no bond.
okay, what are you seeking? Sorry?
ROR, and a date certain.
Okay, I'm gonna release ROR, and I give the homeless calendar date, Madam Clerk. Okay, just making sure that's this is proper. All right, so the calendar date, Mr. Wright, is September 10th, 2025 at 8:45 a.m. Courtroom 6-8. I'll warn you, I suppose a failure to appear, will be we'll be right back here.
Sir,
Yes.
I don't know what my mother address is. I think it's 5300 Northwest 23rd or 24th. All right,
Have it right here.
all right.
You're on hold.
Okay, you gave the information to Mr. Wright, and have you taken the address or other contact information?
I gave the information to Mr. Wright. We could speak with him at a later time about any other address.
Okay. All right, thank you. So right down there, I'll put the home phone information. Okay, Mr. Gervais.
Did he refuse?
Your Honor, he refused court. Mr. Gervais also has a fugitive warrant from F Corps. No bond.
Okay, so Mr. Gervais is not present.
No, Judge, I was asked to reset till tomorrow.
Okay.
reset tomorrow, say 8/3/25.
Okay, we're gonna reset for tomorrow, 8/3/2025. What time? More or less?
No, and it just comes to correction.
Oh, okay, so we'll reset for tomorrow. But can I put that in the?
Yeah.
Much. Is this Mr. Thompson?
Yes, Judge.
Your Honor, Mr. Thompson also has an open felony. He'll be back on your bond hearing calendar.
Okay, and so we're here for the resisting officer without violence and petty theft.
Yes, Judge.
Okay, I'm pointing to the public defender's office. Any argument on probable cause?
No, not at this time.
Okay, release conditions state.
So they'd be asking for standard bond in this case, 150 and 500, Your Honor.
Excuse me?
150 and 500, Your Honor.
Okay, public defender's office.
Judge, I do not see a list of priors if he disqualified for pretrial services or TAP. I do see it's indicated that he is homeless, then I would request TAP as an alternative to PTS.
Okay, state. Have his felony bond hearing later today.
Yes, Your Honor. I mean, at this point, it's still reaffirmed setting the standard bond in this case.
Okay, in the interim, we'll set a standard bond of 150 for count 1 petty theft and standard bond for count 2 resisting officer without violence of $500.
Your Honor, may I ask a question?
Yes, Mr. Thompson.
Yeah, I just want to say I'm like really sorry. I know like that won't like get me out of trouble or anything. I just want to say the only reason I really did.
Yep. You have the right to remain silent, Mr. Thompson. Right. Thank you. Mr. Diaz. Henry Diaz.
He's present, Judge.
Okay, so Mr. Diaz, you're here on a charge for criminal mischief. I believe that's what that is. Under section 806.13, 1B2, I'm going to appoint the public defender's office.
Judge, he would require assistance of the Spanish interpreter.
Señor Díaz, ¿usted se encuentra aquí en relación a un cargo de causar daños? Le nombro a los abogados de la Defensoría Pública para que lo representen a usted.
Okay, is there any probable cause argument?
¿Hay algún alegato en relación a la suficiencia de indicios?
Okay, give me a second here.
Judge, I do have a PC argument as to there not being a dollar amount on the premise.
Señoría, tengo un alegato en relación a la suficiencia de indicios del cargo de causar daños porque no se indica el monto de la pérdida.
State.
Yes, Your Honor. So the state in this case would be asking for the standard bond, Your Honor. The defendant has numerous priors open, and we'd also be asking for a stay away order from the victim in this case.
Señoría, en este caso, la Fiscalía pide que se imponga la fianza estándar. El acusado tiene numerosos casos pendientes y también pediríamos que se expida una orden de alejamiento en relación a la presunta víctima.
What is your argument about the lack of a reference to the dollar amount in the A form?
¿Qué alega usted en relación al argumento que tiene que ver con que no aparece el monto de la pérdida en el formulario de arresto?
Judge, we will be requesting a dollar bond for a day, because he is unhoused, so any type of bond or elevated bond or standard bond will be tantamount to no bond.
Understood, he's homeless, but yeah, was there a probable cause argument from the state?
Yes, Judge, I'm sorry.
You made the probable cause argument, I'm
Yes.
asking the state now.
Yes, Your Honor. So yes, the amount is unknown on this time based on the A form, but it meant it's clear there, Your Honor, as far as
Damage?
the rear view driver side causing a dent to the vehicle, Your Honor.
Okay,
No,
I'll make
no figura ningún monto de dólar, señoría, pero se dice que se le hizo daño al espejo retrovisor.
I'll make a probable cause determination. I'm observing from the courtroom some behavioral issues from the defendant. Do we know if he has a mental illness?
Voy a fallar en relación a lo siguiente. Estoy observando aquí en la sala ciertas acciones distintivas del comportamiento del acusado. ¿Sabemos si él tiene algún tipo de antecedente de enfermedad mental?
Judge, I can't confirm that definitely right now. That's something that we could readdress at a later date.
Señoría, no puedo confirmar eso en este momento, pero eso lo podemos ventilar en una fecha posterior.
Your Honor, so with the defendant not being present, we'd ask this be reset. I mean, the defendant should be present for this entire process, Your Honor.
Okay, we'll reset this for 8/3 tomorrow, but so the folks know, I'm considering whether he needs to be evaluated in mental health court. All right, so reassess.
I'm sorry, Your Honor, for Mr. Diaz, you're not giving him a bond?
And at this time, I'm gonna reset. He left the room. I saw some issues there in the next to the public defender.
You could give him a bond and do an evaluation.
No, we don't do that.
Right.
Okay.
All right, reset for August 3rd, 2025. Thank you, State.
Your Honor.
Yeah, like that. I'm flying through this, but does anybody need a break of any kind?
Absolutely not.
We're good, Your Honor.
Okay.
Yeah.
Mr. Huertas is present. He speaks he needs the services of the Spanish interpreter.
Well, is Mr.
Mr. Palmerino, Michael is a bond out.
Michael Pomerino is a bond out? Okay.
Yes.
Last name of Marino, good?
Pumarino.
Marino, thank you.
Pumarino. Mr. Huertas, you are being charged with bench warrant, or you had a bench warrant for a petty theft charge.
Señor Huerta, a usted se le acusa de lo siguiente. Bueno, de hecho, tiene una orden de búsqueda y captura vinculada a un caso de hurto de menor cuantía.
I'm going to appoint the public defender's office.
Le nombra a los abogados de la Defensoría Pública para que lo representen.
Any argument on probable cause or the willfulness of the violation of the bench warrant?
¿Algún alegato en relación a la suficiencia de indicios o la intencionalidad de la que resultó en la expedición de la orden de búsqueda y captura?
It's just that he is homeless, so I'm not sure about his current ability to appear to court on the date that the bench warrant was issued, which was 7/2.
Señoría, él no tiene vivienda, entonces no tengo idea de que si él pudo haber comparecido ante el tribunal en relación a aquel caso.
I will argue just for a date certain, once again, an ROR.
Yo le pediría una fecha precisa y le pediría que le permita salir bajo palabra. Fiscal.
Okay, I'm going to give an ROR. The homeless calendar for your next appearance, Mr. Huertas. is September 10th, 2025 at 8:45 a.m.
Señor Huerta, Huertas, le voy a permitir salir bajo palabra y le voy a permitir comparecer en relación al calendario que tenemos para personas sin viviendas. Su próxima cita ante el tribunal será el día 10 de septiembre del 2025 a las 8:45 de la mañana.
It'll be in courtroom 6-8.
Será en la sala 6-8.
Do you have any means to contact you other than that? I understand you don't have an address, but is there anyone we can reach you at?
¿Hay alguna manera que nos podemos poner en comunicación con usted, caballero? ¿Alguna forma que podemos contactarlo a usted? Sí. Interpreter did not understand. My interpreter asked for a petition.
Oh, no, he said Camilla's house.
Oh,
So
él dijo Camilo's house.
Okay, so there are no relatives or anybody we can contact?
Entonces no habría ningún pariente suyo ni ninguna persona que podría contactar a usted.
No.
No.
All right, thank you. Again, I've advised you of the hearing date. You have an obligation to appear on September 10th, 2025 at 8:45 a.m., courtroom 6-8.
Caballero, ya le he indicado la próxima cita que usted tiene. Está obligado a comparecer ante el tribunal el día 10 de septiembre del 2025 a las 8:45 de la mañana en la sala 6-8. Okay.
All right, thank you.
Mr. Fernandez, here, judge, and needs assistance of the Spanish interpreter.
We can give him a stay away order.
Oh my God, come on, Steve.
I didn't issue it. Rydell.
Judge, there was already a stay away order issued in that case for Mr.
Mr. Huertas?
Yes.
Okay. Mr. Fernandez, or Rydell de los Fernandez?
Señor Raidel Delis Fernández.
Raidel René Fernández de las.
Raidel René Fernández de las.
Okay, you've been charged with drug paraphernalia possession under 893.147(1), and alcohol consumption in a store. That appears to be a local ordinance.
Caballero, se le acusa de posesión de parafernalia para uso de drogas, de acuerdo con la ley 893.947, subsección 1, y también con consumpción de alcohol. Parece que eso tiene que ver con una ordenanza de un municipio.
This is not Miami Beach, correct? No, it's Hialeah. Okay.
Esto no es Miami Beach, correcto, no es Hialeah.
Appointing the Public Defender's Office, any probable cause argument?
Le nombra a los abogados de la Defensoría Pública para que lo representen. ¿Algún alegato en relación a la suficiencia de indicios?
No PC argument this time, Judge.
No tenemos alegatos en relación a eso, señoría.
Okay, reasonable release conditions?
Condiciones de libertad condicional razonables.
Your Honor, the state would be asking for standard bond in this case. The defendant does have a prior from 2015. That's a conviction for cannabis possession.
Señoría, en este caso pedimos que se imponga la fianza estándar. El acusado tiene antecedentes, una condena por posesión de cannabis.
Judge, I actually do have a PC argument for the drug paraphernalia possession.
De hecho, señoría, tengo un alegato en relación a la suficiencia de indicios, en relación a la posesión de parafernalia para uso de drogas.
Okay, what's the argument?
So, Judge, the A form sets a crack pipe with unknown black substance. Even though crack pipes could be typically and primarily associated with crack, it doesn't have to be, and it doesn't specify specifically if the substance is drug residue or the A form doesn't reference that it's drug residue or that the item was in proximity to any drugs. It just says a black residue.
Señoría, observo que se le acusa de tener una pipa para fumar crack, pero las pipas para fumar crack se pueden confundir con cualquier otra cosa, y además se señala que había un residuo negro, pero aquí no dice que ese residuo negro era alguna droga o estaba próximo o cercano a ninguna otra droga.
Specifically for this charge, it has to, it requires the defendant to knowingly use drug paraphernalia or had it in his possession and intended to use it. So if there is no reference to that substance actually being drugs, we'll argue that there is no PC for that charge.
Específicamente, para que el cargo venga al caso, se tiene que saber que el acusado usó la parafernalia para usar drogas o la tenía en su posesión con la intención de usarla con ese fin, y aquí no se alega que ha habido ninguna droga por ahí.
State.
Yes, Your Honor. So if you look at the last page of A form, it reads, Mr. Fernandez, and in his front pocket what appeared to be a crack pipe with unknown black substance subsequently taken. The crack pipe had fallen on the floor and also broke, significantly trespassing from the property. So, Your Honor, the state would argue that, based on the officer's description in the A form, there's probable cause to find that this crack pipe was drug paraphernalia. The black substance, whether it's known or unknown, is the intent to use it as a crack pipe, Your Honor.
Si usted se fija en la última página del formulario de arresto, aquí dice que él tenía una pipa para fumar crack en el bolsillo de vidrio que se cayó al suelo y al caerse se rompió y al romperse expidió una sustancia negra. La fiscalía alega que esa sustancia negra es la intención de usar, con el fin de usarla para drogas.
Judge, per case law, holding, there's a first DCA case, Nixon versus State. Presence of a homemade crack pipe in defendant's boot and pocket was insufficient to convict the defendant of possession with intent to use, absent evidence of any drug residue that was found on those items. Black substance is insufficient, an unknown black substance is insufficient to state that that is drug residue or to infer that.
Señoría, de acuerdo con el precedente que viene al caso, específicamente el caso de Nixon contra el Estado del primer circuito, aquí el tribunal falló que el acusado tuviera una pipa en el bolsillo no era suficiente para sustentar este cargo cuando no había ningún tipo de droga o residuo de droga.
Any argument to resetting for testimony?
No objection.
¿Algún alegato en relación a pedir otra cita para recibir testimonio? No nos oponemos.
No objection, Judge.
Okay, let's reset for 8/3/2025. Testimony from the arresting officer.
Bueno,
And
fijemos la próxima
additional
vista para el 3
evidence.
de agosto del 2025 para recibir pruebas y testimonio del policía que lo arrestó.
Make a determination on the other two tomorrow.
Tomaremos una determinación en relación a los otros dos cargos mañana.
Or the other charge, the one remaining charge in alcohol consumption.
O el otro cargo que queda pendiente, el de consumo de alcohol.
Judge, we have Mr. Ortega. Need the assistance of the Spanish interpreter.
El señor Ortega se encuentra presente, necesita el intérprete.
Okay, Mr. Ortega, you've been charged with trespassing property after warning under 810.09.
Señor Ortega, se le acusa de intromisión ilegal en alguna propiedad o predio de otro, de acuerdo con la sección 810.09 de la ley.
And alcohol curbside drinking under section 562.453.
Y también por consumir alcohol en la vía pública, infringiendo la sección 512.543.
I will be appointing the Public Defender's Office.
Le nombra a los abogados de la Defensoría Pública para que lo representen.
Any probable cause?
None, Judge.
Suficientes indicios, no, juez.
All right, I find probable cause. State.
Your Honor, so the state be asking for standard bond on this one. Defendant has priors for disorderly intox. And despite having the same charge on null pros, this seems to be a pattern of behavior, Your Honor.
Determino que hay suficientes indicios. ¿Hay algún alegato por parte de la Fiscalía? Pedimos la fianza estándar. Su señoría, este acusado tiene antecedentes por alteración del orden público mediante embriaguez. Parece que este es su patrón ordinario de comportamiento, señoría.
Public Defender's Office.
Judge, he is homeless. We would be requesting a date certain, RR with a date certain, or in the alternative TAP. Any type of bond will be tantamount to no bond, considering he is homeless.
Señoría, este acusado carece de hogar. Pedimos que se le permita salir bajo palabra con una fecha precisa para regresar al tribunal como alternativa TAP y le indico que cualquier monto de fianza sería equivalente a retenerlo sin fianza porque él no tiene vivienda.
Does he have any history of bench warrants or failures to appear on prior charges?
None that
¿Tiene
I
algún
know, Your Honor.
historial de órdenes de búsqueda y captura o faltas de comparecencia?
Judge, he's indicated that he has not. I cannot make that representation because I don't know the history of his cases.
Okay, and any of his
Dice que no.
priors involve any?
Your Honor, so I see a probation violation back in 2002. I know it's far out, but that's something to consider, Your Honor.
Señoría, veo que él no cumplió con libertad vigilada en el 2002. Yo sé que eso es algo bien remoto temporalmente, pero debe tomarse en cuenta.
Okay, so I'm going to issue a bond, standard bond only on the alcohol curbside drinking of $150. I will not issue a bond on the trespass property after warning. So only count 2 will have a $150 bond.
Bueno, voy a imponer una fianza estándar, pero solamente en relación al segundo cargo, el de consumo de alcohol en la vía pública, en relación al cargo de la intromisión ilegal después de haber sido advertido que no lo haga, allí no le voy a poner ninguna fianza.
Your Honor,
Fianza en
the
el segundo
bond
cargo.
as to count 1, is it RR, no PC?
No, I'm finding probable cause for count 1, but just under these circumstances, I don't see the necessity for a bond for that count. I think the bond for count 2 is sufficient.
Judge, it's either an elevated bond.
Your Honor, you have
and it
to,
is a misdemeanor.
$1 bond. I'll give $1 bond for
Thank
the trespassing property.
Le voy a poner una fianza de $1 en relación al cargo de intromisión ilegal.
Your Honor, the state would also be asking for a stay away order.
La fiscalía pide una orden de alejamiento.
Okay. I'll enter the stay away order. Mr. Ortega, you are ordered to stay away from the following address.
Voy a dictar una orden de alejamiento. Señor Ortega, se ordena que usted se mantenga alejado de la siguiente dirección.
Sophie's Beauty Salon, 1904 West 60th Street.
Sophie Beauty Salon, 1904 Oeste 60 Calle.
Hialeah, Florida, 33012.
Hialeah, Florida 33012.
This order shall remain in effect until case is closed.
Esta orden seguirá en vigor hasta que termine el caso
Modified by the court.
o que sea modificada por el tribunal
Or for a period of 6 months.
o por un plazo de 6 meses.
Brown's present, Judge.
All right. This is Mr. Tommy Brown. You are being charged with trespassing property after warning. I'm going to appoint the public defender's office. Any probable cause argument?
Yes, Judge, specifically for the trespass warning. The form just states the defendant was taken into custody after he was issued a trespass warning on July 6, 2025. and nothing else further referencing either the police case number or the case number for the trespass.
Your Honor, so state be objecting, I mean, it has the officer's information, it has the time, so that's sufficient notice as far as being trespassed.
Okay, I find probable cause. Release conditions state.
Your Honor, so we'd be asking for elevated for 1,000 bond on this one. The defendant has two current open cases for the same exact charge. He has convictions in 1917 and more than 5 in the 90s, Your Honor, for the exact same thing.
For trespass?
Yes, Your Honor.
Any history of violence?
No, Your Honor.
Judge, for Mr. Brown, we will be requesting an ROR on a date certain. He is homeless, Judge. He's been homeless for some time. Most of his priors date back. I guess the most recent prior was in 2020 and there was no action. And other cases are from 2019 and then all the way back. It's been a couple years for a lot of these cases, Judge. I'll just be asking for an ROR on a date certain.
Okay, I'll grant an ROR. Mr. Brown, your next date in the court proceedings is September 10th, 2025 at 8:45 a.m. in courtroom 6-8. You have an obligation to appear at that hearing. I'm going to read a stay away order. Hold on.
I need you to speak up a little faster because we people are halfway out the door.
My apologies, Mr. Brown. I am going to read you now a stay away order. You are ordered to stay away from the following address: the Marathon on 4699 Northwest 183rd Street, Miami Gardens, Florida 33055. The stay away order will remain in effect until the case is closed, modified by the court, or for a period of 6 months. All right, thank you. Is this Mr. Marshall?
Yes, Judge.
Okay, John Marshall, you are being charged with possession of drug paraphernalia under section 893.1471. I'm going to appoint Public Defender's Office. Any probable cause argument?
Yes, Judge. Similar to the previous argument about possession of drug paraphernalia, the A form only states I removed the pipe. It doesn't reference a crack pipe. It doesn't reference any of those types of paraphernalia. It could be a smoke pipe from the pocket, and it had burnt residue. Again, does not specify what that burnt residue is. I would be asking for release outright. I think this is more so a clear an argument to be made for releasing outright and no PC.
Your Honor, so state be objecting, I mean, it's a glass pipe, a pipe, it's clear there in the A form, and again, Your Honor, it mentions burnt residue on the front end. So based on that and the officer's finding and training and experience, we'd argue that that's sufficient, Your Honor.
Understood. What do you make of that first TCA case that Public Defender's Office referred to earlier?
State wouldn't be objecting to that case law, Your Honor.
Okay.
And so the court is aware, Your Honor, the defendant does have an open prior, and the most recent conviction would be in 2013.
Okay, so I'm going to reset this case for probable cause determination tomorrow, August 3rd, 2025, taking evidence on probable cause.
Mr. Bailey's here, Judge.
Okay, Mr. Bailey, you are being charged with trespass on property after warning under 810.091A1. I'm going to appoint the Public Defender's Office.
No PT arguments at this time, Judge.
All right, public cause found. Release condition state.
Your Honor, so the state wouldn't be asking for a standard bond in this case.
Okay. Public Defender's Office.
Judge, we will be requesting ROR. He does have prior arrest. Most of these were no pros, no actioned. And he does have a previous other case, but it was a withhold. He doesn't have a significant criminal history, Judge, either in ROR or pretrial services.
And your Honor, the state's also asking for a stay away order from the incident location.
Okay, so what are his priors or prior arrests?
So prior arrest, Your Honor, for crim mis, burglary, disorderly conduct. The only conviction that I'm seeing here, Your Honor, is from 2015, which is the same charge that we're here for today, is trespass after warning.
So all the other ones are no withholds or no actions?
Correct, they were either no action or no cross, Your Honor.
Yeah,
All right.
and Judge, we're not certain as to exactly if that's the same location. The trespass was in 2015. It might not be the same location. It's an older case. Again, the rest of his priors, no pros, no actions.
All right, ROR. I'm going to issue stay away order. Mr. Bailey, you are ordered to stay away from the following address area while you are released on your own recognizance. Marathon 4699 Northwest 183rd Street, Miami Gardens, Florida 33055. The order shall remain in effect until the case is closed and modified by the court or for a period of 6 months. Victor Flores.
Mr. Flores, present, Judge.
All right, Mr. Flores, do you need translation?
Señor Flores, ¿necesita un intérprete?
No.
Okay, so Mr. Flores, you're being charged with petty theft under 812.0143A. I'm going to point to Public Defender's Office. Any probable cause argument?
No probable cause argument at this time, Judge.
Honor, the state be asking for standard bond in this case.
Public Defender's Office.
I don't have any priors for Mr. Flores. So this would be his first criminal charge. I'll be asking for an ROR or in the alternative PTS.
No priors, state?
No, Your Honor.
This address is current 13400 Southwest 2nd Street for Mr. Flores?
Yes.
Okay, so no history of violence. How long have you lived here, Mr. Flores?
How long have you lived?
How long I've been living in that address?
Yes.
Like before the pandemic, like 6 years.
Okay, and again, no prior history?
No, Your Honor.
Okay, ROR. And I'm going to issue a stay away order. Mr. Flores, you are ordered to stay away from the following address area. The target at 3825 Northwest 7th Street, Miami, Florida 33126. The order shall remain in effect until the case is closed, modified by the court, or for a period of 6 months.
Mr. Salas is present, Judge. And
Okay,
needs the
Mr.
services
S-
of the Spanish interpreter.
Okay, Mr. Salas, you are being charged with. Sorry,
Señor Salas, se le acusa un momento
with petty theft.
de hurto menor.
I'm gonna appoint the public defender's office.
Le nombra a los abogados de la Defensoría Pública para que lo represente.
Judge, for the charge of petty theft, it needs to indicate that he exited all points of sale. And with making no attempts to pay, but this, based off of the A form, it references that, I mean, he was approached inside of the store. And that the store manager specifically requested different charges. But
One second. Su señoría, aquí se indica que él se acercó a todos los puntos de salida y se alejó de la tienda sin pagar, pero dice aquí anteriormente que en la tienda se le confrontó a alguien.
But as it pertains to the charge in front of us, there would be no PC because specifically, as referenced previously, there was no indication on the A form that he attempted to exit all points of sale, which you'd need for that specific charge. Pass
Pero
all
en relación-
registered or left store without making any attempt to pay.
Pero aquí,
Objecting the second.
No,
excuse me, Your Honor. Se alega que, pero no hay suficientes indicios porque no se indica que él se fue sin tratar de pagar.
State.
Yes, Your Honor. So on the second or the last paragraph, the first page, and then going into the second page of the A form, Your Honor, it says the store manager explained that he observed the defendant consume food items and attempt to conceal a pair of slippers from within the store. When confronted, the defendant claimed that he did not have the means to pay for the items. And then going down a few lines further, Your Honor, consumed and unusable items were returned to the store manager.
All right, so he
Y-
consumed items. Sorry.
Señoría, aquí al pie de la primera página y pasando a la segunda página, dice que el administrador de la tienda observó al acusado consumir comida dentro de la tienda y tratar de esconder algunas sandalias o zapatillas en algún lugar, y cuando se le confrontó más adelante, se indica más debajo, él aceptó, indicó que no tenía dinero para pagar por esas cosas.
All right, so he had no intention of paying for the items he ate, consumed.
Your
No tenía
Honor,
la intención de pagar por las cosas que había consumido.
Your Honor.
Bueno,
Mr.
Yes.
Salas Martinez also has a hold for immigration.
señor Carlos Martínez también tiene una orden de retención por parte de las autoridades migratorias.
Judge, specifically for the charge of petty theft, it has to allege, the A form has to allege the defendant passed all registers or left the store without making any attempt to pay for an item.
En relación al cargo de hurto de menor cuantía, se tiene que alegar que el acusado pasó por todos los puntos de pago sin tratar de hacer ningún esfuerzo para pagar.
Okay,
Your Honor, that's an inaccurate statement of the law.
I'm gonna find probable cause on the petty theft. Okay, release conditions.
Determino que es suficiente indicio en relación al cargo de hurto de menor cuantía. Las condiciones razonables de salir,
No priors, Your Honor, so we'd just be asking for standard bond in this case, 150.
teoría no hay antecedentes, pedimos la fianza estándar, en este caso 150.
Standard bond is fine, Judge.
La
All
fianza
right.
estándar está bien.
All right, standard bond of $150.
Fianza estándar, $150.
And we're gonna issue a stay away order.
Pedimos una orden de alejamiento.
Mr. Salas Martinez, you are ordered to stay away from the following address or area.
Señor Salas Martínez, se ordena que se mantenga alejado de la siguiente dirección o zona.
The CVS on 4000 Collins Avenue,
La tienda CVS en el 4000 de la avenida Collins.
Suite C,
Habitación C,
Miami Beach, Florida 33140.
Miami Beach, Florida 33140.
The order shall remain in effect until the case is closed,
Esta orden sigue en pie hasta que termine el caso
modified by the court,
o que sea modificada por el tribunal
or for a period of 6 months.
o por un plazo de 6 meses.
Thank you.
Muchas gracias.
Your Honor, for Mr. Akeem Davis, this is Joanne Hennessy for the City of Miami Beach. This is the state's case at this point. I'm just announcing my appearance.
All right, thank you very much. All right, state, excuse me, I apologize, Mr. Davis, you are being charged with cannabis possession, 20 grams or less, and a local ordinance for Miami Beach, smoking cannabis, marijuana. All right, I'm pointing the public defender's office. Any probable cause argument?
None at this time, Judge.
All right, probable cause found. State.
We'll just be asking for standard bond in this case.
Judge, we will be requesting an ROR. He has no priors.
They can confirm no priors, Your Honor.
Okay, and I'm gonna order a standard bond in this case. $500. A $1 bond for the local ordinance.
Yeah, and count one is 500, count two is $1.
Yes. Is it Mr. Evans?
Your Honor, Mr. Ramon Evans is a bond out.
Okay. Is this Mr. Everett?
Yes, Judge.
Okay, Mr. Everett, you're being charged with contribution to delinquency and dependency of a child and petty theft. I'm appointing public defender's office. Probable cause.
No PC arguments at the time, Judge.
I'm finding probable cause.
Yes, Your Honor. So it's gonna be asking for a standard bond in this case.
Public defender's office.
Judge, we will be requesting an ROR or in the alternative PTS. He has no priors. I do say that there is a null pros from 2014. Other than that, Judge, he has no criminal history. So we'll be requesting ROR or PTS as the alternative.
What was the no pros for?
So from Your Honor, he was no pros for completion of PTI, but that was for grand theft and as well as in this case, Your Honor, this was conducted in the presence of a minor, Your Honor.
Correct. Saw that. So I'm gonna issue standard bonds for both counts. Count one is $500 and count two is $500.
Your Honor, we're also asking for a stay waiver in this case.
Go ahead and issue it now. Mr. Everett, you're ordered to stay away from the following address area. The Children's Place at 11401 Northwest 12th Street. Number 4454 Sweetwater, Florida, 331. I believe this is 72. 33172. The order shall remain in effect until the case is closed, modified by the court, or for a period of 6 months. Thank you.
Your Honor, Mr. Alberto Enrique The last name I can't pronounce. Is a bond out?
Yamail Yarpas, I'm guessing as well, but
Yes, he's a bond out.
all right, bond out. Madam Clerk. This is case history. Should I put it here?
Yes, you can put it. What was that second bond out?
The bond out here right now?
The one after Mr. Yamail
Same person, same person.
Same person?
Same bond out. Yamail Yarpas, Alberto Enrique. That's the one we're still on.
Okay.
Thank you. Micah Tilley. Mr. Tilley, you
Order.
are charged with, hold on a second. Several counts, obstruction, disguising your person, possession of cannabis, disorderly conduct, threatening a law enforcement officer, ASA, first responder, assaulting a police officer, resisting officer without violence. I'm gonna appoint the public defender's office. Probable cause.
Judge, this is the bench warrant case. I'm trying to see, after speaking with Mr. Tilley, if his failure to appear was willful.
Okay.
Judge, he's indicating to me that he appeared on 5/15. I'm not sure why there is a bench warrant in this case. I cannot advise the court specifically or make any representations, but he did indicate that he did appear. And he has regional counsel appointed on this case.
Okay, so is anybody for regional counsel here?
No, Judge.
My notes reflect revoked bench warrant, $3,000, no bond on May 15, 2025. State, any insight?
The state would just be asking that the bench warrant be converted to the bond amount, Your Honor. The defendant has another case set for August 11th for trial. So the current address should be on file.
Okay, so the notes say no bond. Bench warrant, no bond. That's what it says here.
Your Honor, we have a total bond of 3,000.
Okay, well, all right, so. And I have also in the file a motion to revoke bond. Madam Clerk, do we have any information other on the docket or anywhere? Other
Your
than
Honor, on the jail card, it states count 1, 250, count 2, 250, count 3, 250, count 4, 250, count 5, 1,000, count 6, 1,000.
right, I understand the amount of the bond. I'm just seeing in the notes, is there a order, notes from Judge Cuervo, County Court Judge, indicating no bond, and that followed a motion from the state.
Judge, is that by Judge Rita Cuervo or?
Rita Maria Cuervo.
And Judge, if she granted a motion to revoke bond by the state, that is a deliberate action by the judge in this case.
Judge.
We must have had another case where she decided to revoke his bond for, in this case.
Right. Judge, per CJIS, there was no ruling on the motion to revoke bond, and a bench warrant was issued 5/15, and that the counts that the corrections listed is what the bond was set for. So I have a bench warrant amount, and that's 5/15. But there was no ruling on that motion.
So Judge, Was that no ruling issued because that was the date that the motion to revoke bond was going to be heard and he didn't appear for the motion to revoke bond?
I have a May 6th, the next day, no ruling, so,
Right, Judge. so
reset
that's
five
typically-
nineteen.
That's typically how it goes when the state files a motion to revoke bond. It's either heard the same day or the next day. If the motion was filed on 15th and then it was scheduled to be heard the next day, he failed to appear the next day for his motion to revoke bond, where the judge gave him oral notice the day prior, and then he failed to appear the next day for his hearing on the motion to revoke bond.
As you see, that's on May 5th, there was a motion to revoke bond, and it was no ruling.
So there's no ruling, so we should, at this point, Judge, we can't really go into whether there is a.
I'm gonna let Judge Cuervo, then, this is assigned to her, correct? Her division?
Yes, Judge, but it's gonna be transferred to jails, if you would
Okay.
want for it to be readdressed in jails, then that's typically what happens. It doesn't.
Okay,
go to Judge
so look,
Cuervo.
on the current understanding of the docket, I'm gonna issue a standard bond for all counts. So $3,000 standard bond, for count 1, 2 through 6, $3,000 total.
I'm sorry, could you repeat that, Your Honor?
Excuse me?
You have to give us the breakdowns of each amount per count.
Can you repeat the breakdown, corrections, please?
Count 1 through count 4 is 250. Count 5 and count 6 is 1,000 each.
Okay, so count 5 and 6, $1,000 each. And counts 1 through 4, $250 each.
That's a total of 3,000.
That's a total of $3,000. Yes. We're ready to proceed to the next case? Yes, sir. Madam Clerk? Are you ready to proceed to the next case? Okay, all right, thank you. Next case?
Mr. Ross is present, sir.
All right, Mr. Ross, you are being charged with loitering or prowling and resisting officer without violence to his person. I'm going to appoint the Public Defender's Office.
Yes,
Probable
Judge. We have
cause?
to seek arguments for this, for both charges. For the loitering or prowling, the fourth TCA indicated in the TT versus state, the officer must observe what he believes is criminal conduct prior to confronting the defendant and asking him to explain his presence in the area. Based off of the A form, the officers just state that they were conducting surveillance in the community due to an increase of low-level street gang violent crimes. The officers do not allege that they specifically witnessed Mr. Ross or have to confront Mr. Ross to ask him anything about explaining his presence. And then Mr. Ross, based off of the A form, then fled. But there was no indication that the officers believed that he was engaged in, specifically for the first element, the incipient criminal behavior, which law-abiding people do not usually engage in due to time, place, or manner, or the conduct involved. He was just walking. There's nothing indicating in the A form that he was engaged in that type of behavior.
So, Your Honor.
Additionally,
Go ahead. No, go ahead. Continue your probable cause argument. I thought you were done.
No, I'm sorry. And then pursuant to 856.0212, it makes it clear that prior to any arrest for loitering, the officer shall afford the defendant an opportunity to dispel his alarm or concern by requesting him to identify himself and explain their presence and conduct. I do not see anything when the officer references that he, once Mr. Ross was stopped, that he attempted to have Mr. Ross dispel any concerns. That is one of the elements. Additionally, for the resisting an officer without violence, you need a legal duty. And there was nothing specifically that Mr. Ross engaged in that would give rise to a resisting an officer without violence charge. Specifically, there's no founded suspicion of criminal activity, and there's no indication that there is actual suspicion of criminal activity. They're just in a high crime area, specifically when it pertains to Mr. Ross. And essentially, Judge, there's no PC for both charges.
So Your Honor, I guess I'll just go backwards from your arguments. As to resisting without violence, it's more than clear that he resisted without violence. It clearly states that he took off running at the sight of police. That's simple. That's resisting without violence. That meets the statute. He saw uniformed police officers and took off at the sight of them. Additionally, as to loitering or prowling, time, place, or manner, these are detectives with the special investigation section. So these aren't regular patrol cops. These are cops that are conducting surveillance in an area where there is high gang violence. It specifically states in the A form, these detectives have specifically interacted with this specific defendant before as an associate of a Miami-based gang. So as to loitering or prowling, he was in a time, place, or manner consistent with loitering or prowling. They tried to interact with him, but they weren't able to dispel any suspicion. If anything, their suspicion was heightened by his immediate taking off at the sight of police. So there is no way the officers could have given him an opportunity to dispel their suspicions when he simply took off running at the sight of police.
All right, so consideration of both factors of both causes together, I find probable cause for both.
Judge, we would specifically request a reset then, specifically to address those charges, because for loitering and prowling, the officers specifically have to state that they had they asked him questions to dispel their concerns. There was no indication that those concerns were dispelled or that they asked questions based off of the four corners of the arrest form. I'm going based off of the four corners of the arrest form. Essentially that, there are elements that for loitering and prowling that need to be met that the officers have not alleged specifically in the E form, the arrest form. And if that's the basis of the criminal activity or reasonable suspicion, then there would be no legal duty for the RWAs.
Thank you. I find probable cause for both counts. Release conditions?
Standard bond with a stay away order from the incident location, Judge.
Public
And
Defender's
if
Office?
you're requesting an ROR, he has no priors. Or in the alternative, PTS.
If he qualifies for PTS, Judge, we have no objection.
Okay. ETS, the alternative standard bond for both counts.
So that's PTS alternate 150 and PTS alternate 500?
Yes.
Thank you.
All right, stay away order. Lejeune Gardens, Mr. Ross, you're gonna stay away from the following address, area. Lejeune Gardens, Northwest 181st Lane and Northwest 40th Place, Miami Gardens, Florida 33055.
Judge, apologies, that's his neighborhood. That's where he lives. He lives in Miami Gardens. That area is around Miami Gardens. It's in his neighborhood. So I'm not sure if you're telling him to stay away from the intersection. Because
That's a specific address, Northwest 181st Lane and Northwest 40th Place.
right, that's his neighborhood. It's an intersection of a place, unless it's like a plaza. It's the street. I'm not.
It's kind of like.
They.
I mean, Judge, that's the address that's on the A form. You can inform him to stay away from that specific area, because if that's where he's committing the loitering or prowling, you can order him to stay away from that area.
All right, again, I'm gonna order him to stay away from that specific intersection. Lejeune Gardens, Northwest 181st Lane and Northwest 40th Place, Miami Gardens, Florida 33055. The order shall remain in effect until case is closed, modified by the court, or for a period of 6 months.
I have Mr. Hernandez here, Judge.
Mr. Hernandez, do you speak Spanish? Excuse me, English?
Do Your Honor.
Yes?
Yes, I do, Your
Speaks
Honor.
English, Judge.
Mr. Herrera Hernandez, you are being charged with driving while license suspended knowingly and resisting officer without violence. And I appoint the public defender's office, probable cause,
No argument, Judge.
probable cause found, state, release conditions.
Yes, Your Honor. So I could see some open felony cases here, Your Honor. So I believe they're possibly the felony hold. But as well, we'd be asking for a standard bond amount in this case.
Corrections, is there an open felony? Hold.
We don't have one listed on the jail card. Is the state placing a hold?
So I can give you the case number, Your Honor.
Sure.
It's F 25-015-429.
What's the felony for, or the charge?
It's a second-degree felony, Your Honor. Escape by detainee before October 1st, 2019.
Okay, all right, so that's
It's set for 8/19 in courtroom 2-4.
That's correct. Set for arraignment.
so he's being held until 8/19? Or at
Your
least
Honor,
until
you can
8/19?
place a hold on this case so he could go to his judge on Monday.
Yes, we'd be asking for a felony hold, Judge, so that he can appear before his felony judge on Monday.
All right, we'll do that. We'll do a felony hold unless public defender's office has an argument against that.
Not at this time, Judge. If there is going to be a felony hold, then we just ask for dollar bonds and the cases in front of Your Honor.
Any objection, state?
No objection.
All right, dollar bonds on both counts.
I think it's a dollar bond, Judge, as well as misdemeanor.
Excuse me?
A dollar bond for each case?
Yes, dollar bond for each case.
Your Honor, this is Joanne Hennessy for the City of Miami Beach. I'm here just for the jail arraignment portion of the calendar. Can we confirm that the remainder of the calendar is traffic?
One more misdemeanor, Judge.
One more misdemeanor.
Oh, okay, thank you.
All right. Thank you. Timothy Quito,
He's present, Judge. It's this bench warrant issue.
it's bench warrant issue for both the petty theft and false name. Appointing the public defender's office.
Yes, Judge. We would be arguing that failure to appear was not willful. Mr. Quito was in custody in Broward County. He was sentenced.
Sentenced to prison.
He was sentenced to prison in
I
Broward
just came
custody
out
at the
three-
end, and he
came out 3
recently
weeks ago.
he came out 3 weeks ago recently. So he was in custody when the bench warrants were issued.
So that's why I didn't.
Okay.
Should be asking for ROR.
No objection, ROR?
Yes, Your Honor.
Okay, ROR, we're gonna have a hearing on September 10th, 2025 at 8:45 a.m. Courtroom 6-8. I see there's a notation here that you are homeless. Is that correct?
Your Honor, you
He's
issued
currently
an RR on which 2 cases?
This one?
What's that?
Is your address?
Yeah.
Okay.
Yeah, 2 cases. This is the first case number.
Oh, okay.
The misdemeanor is the files on the paper, it's the traffic.
Okay, sorry. The,
Just call out the case number, please.
where is it? Up there?
Yes.
B 240-15545. We're gonna ROR that. Right.
And also 15544.
Yes.
Sorry to interrupt again, Your Honor, but if this is the end of the calendar, if I could be excused.
You can be excused. This is it for misdemeanor.
Yes. Be excused.
Thank you. Good day.
You too.
And Judge, there are traffic cases that I do see here.
One moment, we get in there.
Yeah, we got a pile.
We have not addressed it.
It's fine. This time, okay, now you can read out the case numbers here.
Case number ALXOYHE. It is a no driver's license, never had one issued. Have we had argument on that one yet?
No, Judge, we have not.
ROR? No objection, ROR, all right.
Open it up. Right.
Here.
Right inside. You keep leave it in that case number, that's for possession of pregnancy.
All right. ALXOX9E, no motor vehicle registration. For out-of-state driver. ROR.
Now, we're in the traffic now.
Okay, we're going to the traffic calendar now.
Here's the case number. You'll see it highlighted here.
Understood. All right. Mr. McCoy. This is, where's the case number? ALXOUDE.
I'm sorry, Your Honor, who you calling?
Mr. McCoy, Travis McCoy,
Mr.
Tavares McCoy.
Mr. McCoy is a bond out.
Okay, bond out. Put it in this form.
So if you don't have to put anything, so just bond out, you don't have to put.
All right, thank you.
Just package. Thank you.
Okay, this next. Cesar Augusto Marino.
Your Honor, he's at Ward D reset for tomorrow. He also has related felonies.
Okay. Thank you. Is this Trinell Wendell Clark?
Yes, Judge.
Okay, no driver's license.
Mr. Clark is also a VFOX violent felony offender of special concern.
So, Your Honor, since this defendant this is Mr. Clark?
Yes.
So, Your Honor, I understand while this is a driving offense, he is a VFOS. He's not entitled to bond, any other release, so Your Honor should place a felony hold, or issue standard bond on any misdemeanors.
Okay. Appointing the public defender's office.
Yes, Judge. I have no PC argument for the reckless specifically. The felony APD would address the other cases.
So, this is not reckless. This is no driver's license, I believe.
For the bench warrant.
Are you looking at the same defendant?
This is Wendell Clark, though?
Yes, this is Trinell Wendell Clark. Or Wendell Trinell Clark. I have a charge being no driver's license.
Oh, yeah, just Judge. So there was one, that's the bench warrant case. I was addressing another case, which is the reckless. Oh, wrong case.
Yes.
Judge, yeah, for no valid driver's license. The address is on CJIS is 400 Northeast 177th. His actual address is 288 Northwest 47th Street, Miami, Florida. No way. Judge, apologies. No PC argument for the Nevada driver's license, Judge.
Okay.
Your Honor, I'm sorry for Mr. Clark. He's out on probation on F15-8457 Alpha.
He's on probation, so he's a violation of probation.
Right, so Your Honor, that violation of probation is on a punishable by life felony. It was an attempted first-degree murder on a law enforcement officer where he served 5 years in state prison, followed by 5 years of probation, which he's currently on. Since he's on probation and violated the conditions of probation, we would ask that you place a felony hold, and issue a standard bond on the traffic case.
Public Defender's Office.
Judge, we will be requesting $1 bond if there's already a felony hold. He's going to be held on the felony regardless. So $1 bond on the traffic.
Your Honor, that would be over state's objection. He's a violent felony offender of special concern. He should have a felony.
I'll issue a standard bond and a felony hold.
So his bond is $150, Your Honor?
Yes, it is. Standard bond $150 for the no license. Thank you. Is this Mr. Muhammad?
Yes, Judge.
Okay, so Abdullah Muhammad, this is a reckless driving charge. I'm going to point the Public Defender's Office.
Excuse me, Your Honor?
Yes.
Can you ask the misdemeanor clerk to call corrections when she get a chance, please? Thank you.
What's the number?
5498.
Okay.
Thank you.
Judge, after speaking with Mr. Muhammad, he indicated that he reached out to the judge and judge's chambers about court. Apparently the court date, to his knowledge, it was canceled. He reached out to them to find out exactly the court date, and he was told August 25th. I'm not unsure as to why exactly that court date of 7/14. He received notice that it was canceled, but he's indicating that he was given a new date.
So Judge, we would be objecting, this case came from Judge Raul Cuervo's courtroom where he issued a $10,000 bench warrant. Judge Raul Cuervo does not issue those bench warrants by mistake, Judge. That's a very high amount. Additionally, this defendant requested a special set in-person date for trial back on April 2nd of this year. The judge granted him a special set date. There was a subsequent court continuance where they then issued a subsequent trial date. This defendant failed to appear for a special set trial date that he specifically requested. That is why the judge issued a $10,000 bench warrant amount. We would ask that you can convert the bench warrant amount to bond amount.
Public defender.
Judge, first of all, I'm not sure as to the amount why that's $10,000. I would probably request to look into it. But Judge, that's an excessive bond amount for a reckless driving charge. That will be tantamount to no bond. Additionally, Judge, it's clear that he has had conversations with the court if he asked for a special set date. And he probably did follow up with the court. Judge, I do see that he tried to set aside the bench warrant when it was issued.
I thought it was set aside for E25.
Right, I do said that I do see here that he put it on calendar to set aside on 7/9. So he made an active effort to get that taken care of.
Do we know the
That's super
circumstances?
standard.
Yeah, do we know the circumstances why Judge Cuervo issued a bench warrant for that amount?
Judge, typically, I've appeared in front of Judge Cuervo multiple times, Your Honor. He typically issues bench warrants in that amount when the state is ready at trial. And additionally, in circumstances like this, where the defendant has specifically requested a special set in-person trial date at a branch court. In-person trials don't happen at criminal branch courts very often, Judge. So for him to have asked for a special set in-person trial date, the judge granted him that and informed him of the date, and he still did not show
And the
up.
warrant the bench warrant hasn't been set aside by Judge Cuervo?
It is not, Judge. It's not the
No,
bench
Judge,
warrant.
it gets set aside when he's taken, well, technically he's in custody now, so that takes care of that. But he did request a special set date and he did indicate that he did not receive the notice for that special set date.
Judge, this is also his second bench warrant in the case. He's bench warranted previously in this case. This is a case from May of 2024. He last bench warranted in June of 2024. He cleared it a month later. That's also likely why Judge Cuervo issued this high bench warrant amount, even though he's bench warranted in the past. He then asked for a subsequent in-person trial date and then failed to appear on the trial date.
Okay, look, I don't have enough information to disregard a prior court order bench warrant issued for 10,000. I'm being asked to convert it to a standard bond, or excuse me, to a bond. So I'll issue a bond in $10,000 pursuant to Judge Cuervo's prior issuances of multiple bench warrants, indicating that there's a difficulty in getting Mr. Mohammed to comply with court orders or appear court dates. So I suppose that's why Judge Cuervo did it, and I will not, without absent more information, I will not undermine Judge Cuervo's prior order. All right, this is Lamont Cure Rodney.
Your Honor, Mr. Cure, Rodney is a bond out.
Bond out. Okay.
Also, Mr. Murdos Jose is a bond out.
Is this Mr. Williams, Jasper Williams?
Yes, Judge.
Okay, this is case number ALMDWQE. Are there multiple cases here? I think there are multiple cases for Mr. Williams. ALMDWPE and AL98VGE. Okay, let's start with the ALMDWQE. I'm pointing the Public Defender's Office.
I'm sorry, Judge, I'm looking for the arrest form. I don't have that one.
No worries. Take your time.
Judge, we can proceed without it, I guess.
Okay, no probable cause argument.
Unfortunately, I'm unable to make one without the arrest form. So, no, I don't, so I'd request a reset if we want to address the, PC argument for the arrest.
Excuse me?
He has one. Oh.
You said he has one, he has an
Yes,
argument?
he gave me the arrest form. Judge, I have no PC arguments at this time. All just request is an ROR dollar bond.
Okay, and ALWMGWQE?
Yes, Judge, we have no issue with dollar bond
Dollar bond?
for the case ending in QE.
Okay. Dollar bond for the case ending in QE?
All right, Judge, also, he has a bench warrant, an AL98
Yes,
PCE.
give me a second. We have a PE, a case ending in PE as well. Failed to pay traffic fine. Suspended indefinitely, failed to pay traffic
Dollar
fine.
bond, Judge.
Dollar bond, any issue with public defender's office?
That's fine, Judge.
All right, $1 bond. And finally, with the arrest warrant for $50,000 issued by Judge Bach-Armis, I think on July 23rd, 2025.
I have an argument to be Judge. So failure to pay was not willful. The address that's listed on that he would have gotten notice at, technically, it's not the address that is correct. He does have a different address, and it's now updated into CGIS. But the precipice, which he would have received notice on, does not show his correct address.
What is the address that he received it at, and what is his correct address?
1 second, Judge. So the address that's on the precipice is 18975 Southwest 320th Street. Another address is listed on there because they would send it to the addresses that they have on file. It's 1240 Northwest 6th Avenue. So that's where they would have sent notice. The address that he does currently have is 740 Northwest 12th Street, Homestead, Florida, 33030.
What is the 303, sorry, zip code?
33030.
Okay, so he claims he didn't get notice. Hey,
So Judge, we would object. We would ask that you convert the bench warrant amount to the bond amount. Judge Bach-Armis does not issue bench warrants in general, Judge. He issues them very lightly, considering he didn't issue a bench warrant here. He issued an arrest warrant in the amount of $50,000. I think that speaks very highly to what this judge is trying to do in this case. He's not someone who regularly upholds bench warrants additionally. So the fact that this is $50,000, Judge, I don't know why specifically this judge did that. I do see the current offer on this case is a jail offer because Mr. Williams's license has been suspended for a significant period of time and he has several prior convictions.
for driving with the license suspended?
Correct, Judge. He's served time previously for other charges, but most recently, back in 2010, he did serve 24 months for DWS habitual. Judge, I understand $50,000 is a lot. We have no issue with a downward departure, but it should not be less than $10,000.
Judge, first of all, we're trying to determine whether failure to appear was willful. My indication is that this was up for arraignment. The first time up, he did not receive notice for the court date because it went to 2 addresses that I listed and indicated earlier. He has a valid address that it was up on 7/23 for arraignment. He failed to appear at arraignment. That's not long ago, and he did not receive notice. So our argument is failure to appear was not willful. He did not appear because he did not receive notice to his address, 740 Northwest 12th Street, Homestead, Florida, 33030. His address has now been updated into CJIS into the court system. He updated it previously before being arrested, so he can make efforts to come to court if this is ROR. These are ROR.
So has he failed to appear previously in this case?
No, Judge, it's up for arraignment. This was the first time I was up for arraignment.
Okay.
And that was 7/23.
So I'm just first time up for arraignment, and Judge Bach Armas issued an arrest warrant for $50,000.
Again, Judge, I have no idea why he did that. Judge Bach Armas, again, this is not something Judge Bach Armas does lightly. He rarely issues bench warrants. As the fact that he issued an arrest warrant here, Judge,
Judge, he does in fact issue bench warrants, and it depends on the different circumstances, and he does in fact issue a bench warrant for an arraignment issue. That's not what we're trying to assess right now, Judge. It's whether or not he received notice. Our indication is that he did not receive notice because, again, his address was not up to date with the clerk of courts, and he did make it up to date after the fact. So now it is clear, and if he for ROR, Judge, he will receive proper notice next time. But this is first time up arraignment.
Okay, I mean, what's the assuming he didn't receive notice, what's the remedy to have him appear in court before Judge Bach Armas?
Judge, there's simply no guarantee to make sure that he appears before the court. If he's ROR'd, it's up to him whether he decides to show up to court or not.
And with his new address, Judge, he will be showing up to court. It's been, I'm looking at CJIS right now, the address is up to date. What would happen is if he's ROR, it gets reset in a normal course, and it will go in front of Judge Bach Armas.
Okay, seeing it, I understand he's an habitual, violator of DWLS, but on the information provided to me, that this was sent to a different address, and he's not residing there currently. I can't find that he intentionally failed to appear. I don't know what other notice he has of, or would have had of his hearing date,
Okay, so Judge, I was able to contact the ASAs in Judge Bach Armas's courtroom. Apparently, it was because of his extensive priors for DWS. That is the reason for the arrest warrant and his failure to appear at arraignment. So that was the reason.
Understood.
That's fine, Judge. That still doesn't make it
Right,
right.
we're not, yes, correct. So again, without proof of notice, given that his address is different based on what I hear today, I'm gonna ROR him. And he'll have to get a different date with Judge Bach Armas. Hopefully, Mr. Williams, you've convinced me here today based on what you've told me. Obviously, you don't appear to respect the requirement of a license. You continue to do so. Judge Bach Armas obviously believed that there was enough to raise the bond to $50,000 or arrest warrant for $50,000. Again, I don't have information to say it was willful, so I won't. I'll give you an ROR, but ROR release outright, or are we talking about a release on recognizance?
Release on own recognizance, Judge.
Okay, release on recognizance.
Your Honor, that's for case number Alpha Lima 9-8 Victor Golf Echo.
Yes.
And the other 2 cases remain $1.
Yes.
Thank you.
Yeah, to put ROR on this page.
each one.
Yeah, well, yeah, but the other dollar bonds on those also were.
There. And. That's one.
And
Judge,
the
we
other
need the
ones.
assistance of the Spanish interpreter for Mr. Perez.
$1 bond, I have the information. We have. Flip. Sorry. It's very possible did it wrong. All right, is this Mr. Perez Castellanos?
¿Usted es el señor Pérez Castellanos?
Sí.
Yes.
Okay, you are here, charge of no driver license for the operation of a motor vehicle, and you may have multiple cases.
Se encuentra aquí en relación a un cargo de operar un vehículo motorizado sin licencia de conducir y usted podría tener varios casos.
An arrest warrant for $1,000, I believe, or bench warrant.
Una orden de búsqueda y captura expedida por un juez en monto de $1,000.
All right, let's address the bench warrant first. AJSYY2E.
En relación al caso de la orden de búsqueda y captura AGSYY12.
If Your Honor could inquire as to why he failed to appear for court.
Su señoría, ¿le podría preguntar usted a él por qué él no vino al tribunal?
Sure, first I'm going to appoint the public defender, okay, Señor, Mr. Perez Castellanos, can you explain why you failed to appear at the 5/19/2025 court date or the court date that issued by Judge Melendez?
Sí, primeramente nombra a los abogados de la Defensoría Pública para que lo representen. Señor Pérez Castellanos, ¿usted podría decirnos por qué usted no vino al tribunal el 19 de mayo del 2025, el día que lo había citado ante la jueza Meléndez?
Yo no tenía conocimiento de eso. De hecho, no sabía que tenía ni la licencia restringida.
I had no knowledge about that date. I didn't even know that my license was restricted.
Yo fui primero a uno, lo hice, y de hecho después hice un curso que me mandaron que fue como 2 por Zoom, y ya, después pagué, creo que fue después del curso, creo que pagué como 300 y algo, y yo hasta donde yo sabía ya había terminado todo.
I first, in fact, did it. I went to a class. I did it, I believe it was 2 times on Zoom. And after that, I paid an amount of money. I believe it was a bit over $300. I thought it was all done.
Okay.
Your Honor, so on this, Your Honor, the state be asking that we convert the bench warrant to the bond amount, but as the defendant clearly indicated, I mean, he was doing a course, Your Honor. He knew that he had this going on. As well, looking at the traffic printout for the defendant, it's the same address that's listed on the A form, Your Honor.
Su señoría, pedimos que se le imponga la fianza estándar. Y es cierto lo que dice el acusado. Él estuvo haciendo la clase o el curso. Su señoría, le dirijo su atención al formulario de arresto. Esa dirección que aparece en el formulario de arresto es la misma dirección que aparece en la orden de búsqueda y captura.
Public Defender's Office.
Defensoría Pública.
Again, Judge, we'll be just asking for standard bond.
Señoría, pedimos que se imponga la fianza estándar.
I'll put a standard bond.
Le doy la fianza estándar.
That's case ending in 2E. I'm going to give a $1,000 bond.
Este es el caso que termina en 2E. La fianza son $1,000.
No tengo una forma de hacer como trabajo.
I don't have a way, something like to work.
Moving on to case FE.
Pasando al caso que termina en FE.
No driver license for the operation of a motor vehicle.
No tiene licencia de conducir para operar ningún vehículo motorizado.
No PC arguments, Judge.
No tengo argumentos en relación a la suficiencia de indicios, juez.
Okay, probable cause found.
Suficientes indicios se determina que existen.
Release.
No objection to a dollar bond.
Okay,
No me opongo a que se le permita salir con una fianza de $1.
$1 bond.
Fianza de $1.
The next case ending in DE.
Hay
Operating,
otro caso. Termina de E.
operating while driver license suspended, canceled, revoked.
Operando en lo que su licencia de conducir estaba suspendida, cancelada o revocada.
No PC. Argument, Judge.
No hay argumentos en relación a la suficiencia de indicios, juez.
No objection to a dollar bond, Your Honor.
No me opongo a que se le permita salir con una fianza de $1, juez.
Okay, probable cause found, $1 bond.
Determina que hay suficientes indicios, su fianza es $1.
All right. Um,
An interpreter, can you explain that his bond total is 1,001?
Intérprete, explíquele
Part two.
que la fianza total que tiene que pagar son $1,001. No, de hecho son $1,002. $1,002.
Y eso pues, lo puedo hacer hoy. Pues,
Can I pay for that today?
10%.
10%.
Mr. Cortina.
Señor Cortina.
Bond out, Judge.
Is this Mr. Johnson?
Yes, Judge.
Okay, is this just a, no, this is multiple, right? No, this is just a bond, the bench warrant? Okay, so we have a bench warrant, issued on, I guess for missing a jury trial, issued on, June 19, 2025 from Judge Orpestando. He was originally in charge of a licensed driving while license suspended with knowledge. And, the against bench warrant was failure to appear at the jury trial. I assume that's what JT.
Jury trial, yes, Judge, that's correct.
All right, I'm pointing the public defender's office.
One
For a moment to speak to your client.
Okay. Yes, Judge. So Mr. Johnson indicated to me that he had heart surgery in May 12th.
May 5th and 12th.
May 5th and 12th, and he was in the hospital for a month. That would put him in the June 17th area. So I would argue that failure to appear is not willful. He had a health concern. that kept him in the hospital, and he had heart surgery twice.
Had complications and I just got out of the hospital.
And he just
yesterday
had
morning.
complications, and he just got out of the hospital yesterday morning.
So he's been hospitalized this whole time or just
So in May,
June 17th?
so in May, he was had his surgery. He was hospitalized in the surgery, I guess undergoing treatment and I guess observation for 1 month. He got out after the 1 month, and then he recently had to go back into the hospital again. But for the June 17th court date, he would not have been able to appear because he would have been in the hospital.
June 19th. Court date. He was in the hospital until when?
He remembers that it was the 24th or the 25th of June, because it was his son's birthday.
Your Honor, so the state be objecting, Your Honor. This case is over a year old. The defendant previously bench warranted. He knew how to get in communication with the judge's JA. This is willful, Your Honor.
He also, Judge, his previous bench warrant, he cleared that on March 31st of this year. So he gave an updated address to the court. He would have gotten notice of his court date. I understand he had a medical complication, and that's more than understandable. But he chose not to inform the court that he wasn't going to appear because he had surgery. He was irresponsible about this, Your Honor. He should have contacted the court.
Okay, so in lieu of willful argument versus non-willful, something, you're still asking for $10,000?
Your Honor, we have no issue with a downward departure based on circumstances, but this is a willful wanton failure to appear.
Public Defender's Office?
Judge, if anything, will ask for a dollar bond on RR. It's willful, has to express intention. I mean, he was in the hospital for his heart. I'm not sure if that would be a court date is the main concern versus his health and living for his children. I don't know, but I think that was his concern in that point in time. But I would just be asking for a dollar bond.
Understood, but I guess and to the state's argument, was there no ability to contact the court to inform the court? Is there proof of the hospitalization for over a month?
Judge, well, there would be proof of the hospitalization, but we're currently in the position right
Understood.
now where we're in custody. He's in custody, and we're unable to provide that proof because he got picked up. He had complications.
Did he contact the court after he got out of the hospital to notify the court that he missed the hearing due to?
I did. I called I guess the number that's on the back of the card.
Yeah.
And the lady told me they was going to reschedule the court date, but
Is that it?
just stay low and
Yeah.
tell the court-
So right. So they said that he is advising that he did contact the judicial assistant to get a court date. For that.
Is there a current scheduled court date?
No, Judge, this doesn't have a future hearing date from what I can see. If you give me 1 moment. No, it doesn't have a future hearing date because he's just picked up on bench warrant.
Right, but between June 24th or whenever he claims he called, is there a hearing date established or any notification that there was an attempt to reschedule the hearing?
No, Judge, the only hearing date I see was June 17th.
Okay. Okay, Judge, I think he probably contacted our office to place it back on calendar because this is a PD case. So I'm assuming that's when he's indicating that he probably contacted our office. That's Urbistando. That's my division. So I'm assuming that that's what he was requesting, that we put it on calendar for him. But
all right, I'm not going to convert the bench warrant to 10,000, but let's any lower number state
Judge, standard is 150.
Standard is 150.
That's 5,000, Your Honor.
1,000.
All right, I'll issue $1,000 bond for this case.
Mr. Soto is here, Judge. I need assistance of the Spanish interpreter.
Your Honor, Mr. Soto Shamal has a related felony. He'll be back on your bond hearing calendar. Also, he has a hold for immigration.
Señoría, el señor Soto Chamel tiene un caso de delito mayor pendiente, comparecer ante usted en relación a una fianza por delitos mayores y también tiene una orden de retención por parte de las autoridades migratorias.
Okay, Mr. Soto Shamal, I'm going to appoint the Public Defender's Office. You've been charged with driving with license suspended and knowing of the violation.
Al señor Soto Chamel le nombra a los abogados de la Defensoría Pública para que lo representen. Se le acusan de conducir algún vehículo con su licencia suspendida y sabiendo que estaba suspendida.
No PC argument, Judge, or just ask for a dollar bond.
No hay argumentos en relación a la suficiencia de indicios. Su señoría le pide una fianza, que le imponga una fianza de $1.
No objection, Your Honor.
No me
Okay.
opongo, juez.
$1 bond, and I'll see him this afternoon on the other charges.
Fianza de $1 y en relación a los otros cargos lo veré esta tarde.
Mr. Ramirez is present, Judge.
Okay, Mr. Ruiz Falcon, do you need an interpreter?
Yes, Judge, he needs assistance with the Spanish interpreter.
Señor Farías Falcón, Falcón, necesita intérprete.
Yes.
Sí.
Okay, so the charge is for driving without license and never had one issued.
El cargo es por conducir sin licencia de conducir y jamás haber tenido ninguna licencia.
Appointed the Public Defender's Office. Any issue, probable cause issue?
Le nombro a los abogados de la Defensoría Pública para que lo representen. Abogada, ¿alguna alegato en relación a la suficiencia de indicios?
Judge, this is the bench warrant case. I would just ask that if Mr. Ramirez could confirm his address being 331 Southwest 11th Avenue.
Señoría, este es un caso en el que se pidió una orden de búsqueda y captura. Solamente pediría que el señor Ramírez confirme si esta es su dirección, 331 Southwest de la Avenida 11. Yes, in English.
I'll argue that failure to pair is not was not willful, Judge. Based on the precipice, he received notice of 425 Southwest 5th Street, Apartment 5, and the A-form address, the A-form warrant arrest form, it has the correct address.
Señoría, yo alego que no hubo ninguna intencionalidad en relación a la falta de comparecencia ante el tribunal. La dirección a la cual se envió el citatorio fue el 25 del suroeste de la Quinta, apartamento número 5, y en la dirección correcta, de hecho, figuran en el formulario de arresto y es la que acaba de decir él.
State.
No objections, Your Honor.
No me pongo, juez.
Okay, so not willful, ROR.
Entonces, no ha sido intencional, libertad
Honor.
bajo palabra. Sí, juez.
Sir Trujillo is here, Judge, and he needs the assistance of the Spanish interpreter.
Okay. Thank you. Driver's license, Mr. Trujillo, driver's license operator, operated without license.
Señor Trujillo, usted se alega que operó sin licencia de conducir válida.
So, Judge, there were 3 charges on the arrest form, so it's the DUIs as well for Mr. Junior Trujillo, 2 counts of DUI and then a no valid driver's license.
Señoría, hay 3 cargos contra el señor Junior Trujillo. Hay 2 cargos de conducir en estado de embriaguez y también el cargo de conducir sin licencia válida.
We have no PC arguments at this time.
En este momento no tenemos ningún alegato en relación a la suficiencia de indicios.
Release conditions.
Your Honor, the state will be asking for a $1,000 bond on the case ending in R8P, and then a dollar bond on the cases that end in R9P and space R8P.
Su señoría, la fiscalía pide que se le imponga una fianza de $1,000 en el caso que termina en RAP, $1 en relación al caso que termina en R9P y $1 en el que termina en RAR.
Public Defender's Office.
I'm sorry, Judge, can you repeat the bond amounts?
The requested bond amounts are the case in R8E, I believe it's $1 bond. The case ending in R9P, I believe that is a $1 bond. And the case ending in the property damage case, I believe, ending in R8P, $1,000 bond, the standard.
That's right, you're right.
¿Qué fianza le pide, su señoría? En el caso que termina en RAE, la fianza que se pide son $1,000 por la fiscalía. En el que termina en R9P también es $1. Y en el caso que termina en RAP, que es el caso de daños a la propiedad, se pide una fianza de $1,000.
1 second, Judge.
Un segundo, juez.
Judge, if he qualifies for PTS other than that, or as an alternative to the current bond amounts, if you see it as requested.
Señoría, si él reúne los requisitos para PTS como alternativa a la fianza que la fiscalía pidió.
If he qualifies, no objection, Your Honor, but just for the record, the defendant hit a vehicle that was parked and left the scene.
Si él califica, no me opongo, pero para que conste en el acta, su señoría, el acusado le golpeó a un vehículo y se fue de la escena.
Does he qualify? Or are we just, no one's sure?
¿Él califica para eso o no estamos seguros?
Anybody know? Corrections?
¿Alguien lo sabe?
I'm sorry, what are you
Oficial.
asking, Your Honor?
If he qualifies for pretrial services,
We don't know. It should be a pretrial advocate in the courtroom.
I don't know
Que
if we
si él
have.
califica para servicios previos a juicio, debe haber un vocero del Departamento de Servicios antes de juicio aquí en la sala.
So we don't have anyone. Okay, so if he qualifies, I guess with that qualification, and I guess without the state objecting to that.
Based, he's lived here for more than 2 years, so he should qualify for PTS.
Okay, so if
Bueno, si
if
él
he qualifies
califica,
PTS and the alternative is $1,000 bond.
si él reúne los requisitos para eso, entonces se le permite salir a cargo de PTS, pero como alternativa su fianza son $1,002.
Your Honor, for 8P, that's pretrial alternate 1,000, and the other two cases are pretrial alternate $1.
I don't think we did pretrial services alternate for those. It was just $1 bonds.
Entonces, en relación al caso de la fianza de $1,000 como alternativa es servicios antes de juicio, y también en relación a los casos en los que la fianza es $1, también servicios antes de juicio como alternativa. No, su señoría. Yo creo que en los casos de la fianza de $1 no se le, no, esa no es una fianza alternativa.
Okay.
Muy bien.
Thank you.
Gracias.
We have Mr. De Loyola present.
Does he need interpreter services?
Yes, Judge.
Okay, Mr. De Loyola, excuse me, De Loyola Suarez. You are I'm appointing the public defender, but you are being charged with reckless driving.
Señor de Loyola Suárez, le nombro a los abogados de la Defensoría Pública para que lo representen. Se le acusa de conducir de manera temeraria.
Any probable cause argument?
Argumentos en relación a la suficiencia de indicios, no, juez.
Okay, probable cause found.
Determino que hay suficientes indicios.
State argument for release conditions.
Asking
Claro,
for a
un alegato
standard
en
bond,
But
Your
I'm
Honor.
sorry, he has a related felony. He'll be back on your bond hearing calendar.
Señoría, él tiene un delito mayor vinculado a este, regresará en relación a los casos de fianza en relación a eso.
Understood. So he has a I see the two charges that will be back with me later. Controlled substance, possession, crystal meth, and drug paraphernalia.
Observo que tiene los otros dos cargos vinculados, dos cargos, posesión de una sustancia controlada, cristal y parafernalia para uso.
So, what's the bond you're seeking in this case?
Your Honor.
$500?
Yes, Your Honor.
¿Cuánto pide fianza?
I'm sorry.
$500.
An ROR or a dollar bond.
Yo
Yes,
pido libertad bajo palabra, una fianza de $1.
I'm gonna do a $500 bond for this.
Le pongo fianza de $500 en relación a esto.
All right.
Muy bien.
Mr. Botella need interpreter services?
The judge, he does not.
No, Your Honor. Good afternoon.
Good afternoon. It is afternoon. Anybody need a break? Just making sure. I don't know how this works, so try to make sure no one. All right. Mr. Botella, you are charged with driving with license suspended, knowing a violation. I'm appointing the public defender's office. Any argument on probable cause? Bench warrant. This is a bench warrant for failure to appear.
Yes, Judge, he did indicate to me that his address changed. The address listed that he received notice based off of the precipice is 20200 Southwest 320th Street. Warrant was issued 7/25. His date was changed prior to that date.
What was his date change? What was his address changed to?
It was 150 Southeast 6th Ave.
Okay, state.
No objection based on that information, Your Honor.
Okay.
All right, yeah. And Judge, he also had court in another case yesterday. He appeared, the judge indicated that he did have a bench warrant, and then he called the clerk to clear the bench warrant, and the judge is out.
Okay, so for the first one, for the OE, based on no objection, it's an ROR. Not willful, so. And then the second case we're here on, driving with license suspended, operating while driver license suspended, canceled, revoked.
That's for $100 bond, Your Honor.
150 or 100? Standard?
My apologies, 150.
Okay.
No PC arguments, Judge.
Okay, probable cause found.
Your Honor, for 5E, that's 150.
Any argument from public defender's office on 150?
Judge will just request a standard, well, yeah, the standard bond is fine, Judge.
Okay, standard bond. Corrections, that's $150 bond for the 5E violation.
Thank you.
Thank you. Okay, this is Pacheco Terran.
He's a bond out, Your Honor.
Okay. Doesn't do anything to it, yeah. Is this Jarrell Menzie?
How you doing?
How you doing? Good afternoon. So you're here for a bench warrant of $1,000 issued by Judge
Your Honor,
Cuervo's.
I just
Gonzalez Cuervo. Oh, Rita Maria. Okay, 6/27/2025.
I had just I just renewed the got the bench warrant lift from the judge. I go to court August the 8th, and it's still saying active in the system. I was telling the officer, I say, look, here goes my court date. I missed my court date. I rescheduled the court date. on August the 8th, the judge said she was gonna lift it. I talked to her on the phone. And then they still end up taking me to jail yesterday.
Okay, public defender's office is appointed. Is that the argument?
1 second, Judge. All right, Judge, so after speaking with him, he did indicate that the notice that he did receive from the clerk of courts came in July when?
July the 2nd.
July the 2nd. That's when he received it. Once he realized that was the case, he placed it on counter, and the date that he got was August 4th.
This Monday?
For when he's for it to be
August
set
the
aside.
8th, yes.
Sorry, August 8th. For it to be set aside.
State? Is there a date in the system?
I'm sorry, Your Honor.
Is there a date for hearing on that?
So right now, Your Honor, there wouldn't be one. Yeah, there isn't a future date on this one, Judge. He may have set that up with Chambers, but as far as his bench warrant is concerned, it is the second one in his case. He previously failed to appear on May 28th, got that cleared the next day, gave a current address to the court, then subsequently failed to appear on June 27th. And got picked up yesterday for that same bench warrant. So in a short span of time, Your Honor, he has continued to fail to appear before the court, despite providing an updated address.
Judge, so back in May, failure to appear was not willful. He updated his address with the clerk of courts, and that's how that was set aside the next day. And he made sure he did that the next day. In this case, a date was set for August 8th, but obviously he was picked up on that bench warrant. So that
I understand, but on 7, the allegation or the argument is on July 2nd. You contacted Judge Cuervo's chambers or received notice of the mistake or missed
that is when
hearing?
he received notice.
I received the notice in the mail July 2nd, but the court date.
The court date was for June 27th.
I understand, but you received July 2nd, today's August 2nd. So when was the effort to reschedule the hearing or to?
I rescheduled it. This is my second time rescheduled. First, you gave it to me for the 11th of July. I mean, the 11th of August. And then she called me back and said it was going to be on the 8th. She told me it was going to be on the 11th. August the 11th, at 11 o'clock at 6:02. Then she called me back 2 weeks later saying it was going to be August the 8th at 9.
Was a public defender's office already appointed in this case or handling this case?
There's no attorney on file.
Okay, so again, what I'm exploring is that you were arrested. I suppose I don't see the date of the arrest for this. I suppose it was yesterday or the day before. Yesterday, so are you stating that the court has been aware of this and somehow didn't wipe out the warrant or didn't?
I'm saying that throughout. He's scheduled it in July and the date he could have gotten was.
When?
See, there were communications received from 7/22. I'm not that he probably. That's just one of the communications, but he's indicating that he communicated with them previously, and he got different dates, and then it was eventually set for August 8th to set aside that bench warrant. And then.
Is there a date in the system, August 8th for the bench warrant?
He may have had that date, but that date would have gotten wiped out by him being picked up on this bench warrant yesterday because that August 8th date was for him to go before the court and see if the court would use its discretion to set aside his bench warrant. That is a moot point now because his bench warrant has been cleared by getting picked up on that bench warrant. The bench warrant's no longer active. We are now asking for the bond amount to be, or the bench warrant amount to be converted to the bond amount.
Okay, and, okay, well, why did you miss it? Actually, is the most important point. Why did you miss the trial date?
He said he received a notice for the June 27th date on July 2nd, the first week of July, so he would have missed the date.
It came late in the
It came late in the mail.
Okay, I'm gonna,
If Your Honor wants to set a bond, I would request standard.
yeah, I'm gonna set a bond, or this be standard.
Yana, what's the bond amount?
A bond for that case, with bench warrant, 1,000, converting the bench warrant to a bond. The is this Macedo Vallejo?
Yana, he has a related felony. He'll be back on your bond hearing calendar.
Does he need interpretation services?
No, Judge.
How many felonies does he have? 2 felonies that he's seeing me for this afternoon? Or tomorrow? When's he's scheduled to see me
He'll be on your felony calendar, Yana.
Okay, all right. So this is the DUWLS knowing a violation. I'm appointing the public defender's office. Do you need interpreter services?
He does not need an interpreter, Judge.
Okay. Any probable cause argument?
No PC argument, so just ask for dollar bond in the driving while license suspended range.
It would be as per standard bond amount, Your Honor.
Standard bond, 150. For the DWLS, is there another misdemeanor or traffic violation for today on that client? No. All right, thank you.
Judge, we have Mr. Rosen.
Is Mr. Rosencrantz?
Yes.
Yes, sir.
Okay, Mr. Rosencrantz, I have you here for a bench warrant for failure to appear from February 15, 2023, for operating while driver's license suspended, canceled, or revoked. I'm pointing to the public defender's office.
Your Honor, he also has an open felony. He'll be back on your bond hearing calendar.
Okay, what's the felony for? I don't have that information.
Life felony, Judge.
Life felony? Okay. No, I guess no argument for probable cause for this one?
Right, Judge. It's just we for the bench warrant.
Judge, just convert the bench warrant on the bond amount. He violated his conditions of release by picking up a life felony.
Public defender's office?
Judge, I'll just be addressing the bench warrant, not the felony as of now. I'm just trying to confirm whether he received notice.
Yeah, I think he's arguing the life felony because it's relevant to the bond amount. Is another charge. Improbation violation.
Yeah, I'm sorry, what was the bond?
I didn't hear argument from public defender's office yet. waiting to see if they have an objection to the standard or the conversion of the bench warrant to the bond.
So Judge, I would argue that failure to appear itself is not willful. The date was, this case is from 2023, June 9th. It's an older case. His address currently is 1410 Northwest 61st Street, apartment
Apartment number 5.
5. So he was picked up on a bench warrant from 2023. This was a recent case. So I would argue that failure to appear wasn't willful. He did not receive notice. The case itself is from February 15th of 2023.
Okay, so when the bench warrant was issued, he wasn't, you're saying he, or sorry, the notice for that case, he was no longer living in Tallahassee?
He's been living in Miami. So the Tallahassee address and the
Is wrong. Okay.
right.
They,
Your Honor, I understand the address may be wrong, but he knew he had this case open for multiple years. This would be a willful wanton failure to appear. The case didn't just suddenly disappear. He knew he had an active case and he chose to do nothing about it. While the address in the system may be wrong, this is an active criminal case, where, again, he chose nothing to do about it. So it would be a willful wanton failure to appear.
so an active case, you mean he had a case prior to this citation?
No, that citation would be the active case that I'm referencing.
Okay, so when he got the ticket, they sent notice to appear to Tallahassee. His claim is it was not living in, right?
That's my
Or is
mistake,
that,
Judge. I didn't hear that part.
is that what
So-
is that the argument? He was, when he got the notice?
Yes, Judge.
Okay, so Judge, based on that, then we would have no objection.
All right, so for the traffic infraction, what, ROR or bench warrant? All right, and I'll see him later for the felony, life felony? Or is there a felony, just a life felony
Judge,
that I'm not seeing for?
Judge, and that's it for the other cases, and I'll have the felony APD come up shortly.
Okay.
Yes, Your Honor, you'll see him later on the felony calendar.
Okay, thank you. See you, Mr. White. No, thank you. Have a nice day. Thank you.
Judge, can you see me?
I can see your image, your like screensaver, but I can hear you, but can't see your face.
I overheard you talking about felonies. I thought you were on the felony calendar. I have a felony, so I jumped in, but I think you're still on traffic, or are you switching gears yet?
We're switching gears as soon as the staff arrives for the.
Is it possible to call my case out of turn, please?
I don't know. I don't have any of the felony cases. I don't have staff here yet.
Well, in the chat, I put my client's name, Judge. So oftentimes, at least especially during the week, the clerk can pull my client and take me out of turn just because I'm private attorney.
Your Honor, I think in all fairness, counsel's been present all morning. I think whoever's on Zoom can be handled after counsel that's been waiting here patiently all morning.
I appreciate that. That sounds like Mr. White's voice, if I had to guess. Is that right?
Oh, yeah. But if someone was there before me, by all means, I'm going to get to the back of the line. So I don't mean to butt anybody.
Jay, is that you?
That's me.
Tell me your client's name. I'll ask the clerk to pull it.
Okay. Jordan, I'll text it to you right now. I'll tell you right now, it's
Go ahead.
It's Anielo, ANYELO, San Martin Ramirez. Anielo San Martin Ramirez.
I'll try and figure out what page it's on.
F25-16448. Thank you. Thank you, Jordan.
Recording
I was
stopped.
impressed that I nailed that on a voice. Not easy.
Your voice is very distinguishable, Jordan. You know that.
Where's that dog in the bottom?
And Your Honor, this is sites. Just as a little PSA to everyone. In order to be seen on Zoom, you have to be accepted as a panelist. So let me allow Mr. White in.
Thank you, Sites.
Yeah, have you found it?
I'm still going. What are you guys looking for? Last name San Martin? Last three digits of the case number?
Yeah, last name San Martin, correct. All one word.
Council, what are the last three digits of case number? No?
I don't, definitely.
Yeah.
No, I didn't write, I wrote the name, I didn't write the case number. Jay, tell them the case number. I found it. It's on the bottom of 13. Yeah.
Is that mine, Jordan?
Yes.
Thank you.
Ramirez?
Yeah, on yellow San Martin Ramirez. Yeah. But he goes after me, not before.
Of course.
1 second.
Yes, thank you, sir.
It was under San Martin? No, so Martinez Ramirez. Bottom of 13, Martinez Ramirez, the sand part is they put it in the middle.
Yes.
Martinez Ramirez, so hold on, give me 1 second. And I believe. All the best for the delay, Your Honor. So.
Who's apologizing? Someone apologizing for delay?
My guy.
Oh, no worries.
Very good.
I'm Judge Peralta Santiago. Nice to meet you, folks.
Meet you, Judge. I'm Eric Benedy.
Nice to meet you. Hi again.
And this is gonna be what I have been told is out of turns for law attorneys and for corrections.
Can anybody hear me?
Is corrections ready?
Yes, yes, Judge, we're ready.
Yes,
Recording
we're
in
ready.
progress.
Okay, so
All rise, raise your right hand.
Stand up, stand up. Stand up.
Do you swear from the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? If so, say I do.
Okay, we ready to proceed?
Yes, sir.
They pulled the,
Yes.
Is your client Mr. Bramblett?
he is, thank you, Judge.
Okay, I'll call Mr. Nicole Ryan Bramblett.
And if you can, Your Honor, for everybody's convenience, on the top left, there's a page number. Say the page number of the case that you're gonna call.
Page number 15.
And I'm sorry, if there's private counsel in the courtroom,
Yes, yes, of course. I am Judge, first of all, I'll say for the record, I am Judge Peralta Santiago. Can I get appearances from the state, public defender, and everyone present in the courtroom?
Yes, ASA Albert President on behalf of the state. ASA David Leonidas on behalf of the state.
Good afternoon, Judge. Attorney Jordan Lewin on behalf of Cole Bramblett, who I believe is on the video feed via Zoom.
Assistant Public Defender Taylor Arthur, Your Honor, is it presumed the Public Defender's Office is appointed unless otherwise stated?
Yes.
Thank you.
La asistente de la Defensoría Pública, Taylor, I missed your last name, counsel.
Taylor Arthur, like the king.
Taylor Arthur, su señoría, en cada caso usted nombrará a la oficina de la Defensoría Pública para representar a la acusada, a menos que usted diga lo contrario. Así es. Arturo Suárez Silverio, Certified Interpreter Spanish. Arturo Suárez Silverio, intérprete de español certificado.
Your Honor, if you'd like, I can also announce.
Yes, please announce.
Understood. My name is Bianca Fajardo, and I am with CITES.
All right, perfect. Thank you. Again, this is defendant Cole Bramblett. Is he on, I don't see him on the video screen. He's on page 15, Cole Bramblett.
He's en route. Your Honor, he's en route. He hasn't made it here yet.
Okay.
Is that possible? Okay.
Do you have any other cases, Mr. Lewin?
I don't, unfortunately, that's the only case I'm here for. Can you just ask that corrections inform you as soon as he arrives?
Yes, corrections, could you please let me know as soon as Mr. Bramblett arrives? I've got a private
sir.
attorney who's been,
Judge, we have Mr. Martinez Ramirez.
Judge, you know, I'd be willing to waive his presence because we have a stipulation on the bond. I am willing at this point, having reviewed the probable cause affidavit, to stipulate that there is probable cause. The A form lays out, in essence, a he said, she said, where both parties are saying that they instigated a fight. My client's charged with aggravated battery. We have a stipulated bond amount. And then if he eventually gets there from the special unit, we could just say his attorney was here and that there was an agreed amount.
That's correct, Judge. I've taken the opportunity to speak with counsel out in the hall. We've discussed the case. He had an opportunity to review the arrest form, take pictures of the arrest form, so that he can clear up any ambiguities. And we have stipulated to a bond amount.
okay, so the, again, with the stipulation and the waiver of the appearance today, we'll go ahead and move forward on this case. Cole Bramblett, what's the?
3,500 is the stipulated to bond amount, though.
Okay. This is a domestic violence?
It is. Direct the bonds.
That's correct, Judge.
It's on back of the very first page.
I'm sorry.
Judge, I can tell you they were living together. It is his apartment. She left and moved out on Sunday. She has not returned. So I think she can stay with her, but it's his residence.
Okay, so he can return back to his residence. Can I get the stay away order?
Yes, Judge. I apologize. These are all.
Does she have any?
I imagine she does. So yes, I think we'd have to inform him that when he should be gone at a time where she wants to come in and retrieve those things, but either a family member, probably a family member could be there to make sure that, of course, nothing outrageous occurs.
You tell him that, right?
Is the state okay with that arrangement?
I apologize, Judge. We were trying to figure that out. Could I have the quick version?
Sure. So it's my client's residence. It's owned by a family member of his. So I imagine the alleged victim would have personal property that's still in the apartment. So I think what we could do is we could schedule my client's family member, like a brother, being present at a time when she would come to retrieve the remainder of her things.
That's fine, Your Honor. I think maybe the presence of a police officer would ameliorate a lot of issues for both parties, and any concerns either of them might have for the other.
Okay, so
I don't mind. I just, trying to get a police officer to accompany the victim creates an extra burden for her.
Right.
So I'm not trying to burden her.
understood. Again, this is domestic violence. Is there any sort of referral to a DV for this?
What do you mean by that, Judge? I'm sorry.
No.
Will their domestic violence division judge handle this? No?
That's just gonna be handled in circuit.
Yeah.
This is just.
Yeah,
Well,
just private.
it is supposed to be a circuit function, but
Yeah. I relay.
I think, I mean, I saw there was already a judge assigned to the case.
okay, just making sure. Thank you, appreciate it. I'll read the stay away order now. Although you can inform him. All right, and again, Okay, when they bring him, I'll read it to him.
Or it could be left for it to be read in division. If you're waiving his presence.
Happy to waive his presence.
All right, read in division. Read in division. This is non-DV. Has no, is nothing here about retrieving personal property from his home, any of that stuff, but so. Now, I understand, understand, but he's gotta stay away from her, so he's gotta leave. So that's gonna be.
Jill said he took care of it.
Nothing in the order is what I'm saying.
Would Your Honor like me to state that explicitly in the order that the victim is?
Why are they talking about this guy's not even there?
Sorry.
Yes, hello.
They have problems with just making the assumptions. They have some.
Picture of those. The defendant has to be present for you to read out the stay away. If they're not present, you could be left for it to be read in division, or you could wait for the defendant to be brought over to him.
I'll read, when will he be brought to division?
His arraignment's not gonna be for 21 days from tomorrow or Monday.
All right, I'll read it to him when he arrives. All right, thank you, Mr. Lewin.
Okay, thank you, Judge.
That'll be all. Nice to meet you as well. All right, do I have Mr. Martin Ramirez?
Second.
Page 13.
Page 13, Martin Ramirez. And this
Judge,
is
good afternoon to you, Your Honor. Jay Watt on behalf of Mr. Ramirez, who speaks English.
The bond amount for Mr. Bramlett, Judge.
$3,500 for Mr. Bramlett. Thank you. Is Mr. Martinez in the courtroom? Yes. Okay, Mr. Martinez, your counsel's here. Mr. White, correct?
Yes, sir.
All right. You are being charged with felony burglary, occupied dwelling, and other charges, but for today's purposes, refer the felony charge, burglary, occupied dwelling. Any probable cause argument?
Judge, I haven't had the ability to review the arrest affidavit, so I'll leave it up. I defer to the court because I really don't know what the facts are. I just got hired literally a couple hours ago.
Okay. State, any argument of probable cause?
There is probable cause, Your Honor.
Okay, I'll look at the A form quickly. It's convincing argument.
Typically the defense that makes that argument, Judge.
All right, find probable cause on the felony charge. Any argument or release conditions?
Judge, I would just ask that you impose a standard bond. I believe there's a misdemeanor battery also that you have to rule on. That I see online having a bond already of $1,000. I'd ask for a standard bond on the burglary. There should be, I believe, 2 charges, if I'm not mistaken, for you to address.
Okay.
Judge, we have no objection to standard bond when you have to, which should be $7,500. That's standard bond on a second-degree felony. And we have no objection additionally to the standard bond on the 2 misdemeanor cases. Sure.
Yeah.
Charges. Thank you.
Okay, so $7,500 standard bond for the felony charge. What are the standard bonds for the other 2?
It's gonna be $1,000.
All right, so standard across the board, $1,000 for count 2, $1,000 for count 3.
And count 1 is 7,500?
Yes, ma'am.
Judge, can I ask corrections whether there's an immigration hold on my client?
It's not on the jail card.
Okay, thank you. Judge, thank you for your time.
Yes, I need to read a stay away order.
Oh, yes, I'm sorry.
We're handing them out now. You want them all at once? No.
Your Honor, can you pass me the A forms and this result cases?
Yes. I remember I need to read that one, just a reminder.
Oh.
Okay.
You have AP there, correct?
AP, what?
The initial-
Yes, AP and JC. Okay. All right. I'm gonna read two stay away orders, Mr. Martinez. The first one is, I'm ordering that the defendant is prohibited from having any contact with the following named person, hereinafter the victim, with initials AP, born on February 14th, 1997, directly or indirectly, in person, in writing, by telephone, pager, fax, or through third persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and or school at all times. Also, electronic contact such as emailing, texting, Facebook messages, or by Twitter is prohibited. This order shall remain in effect until case is closed, modified by the court, or for a period of, how much are we seeking for the amount of time? State? 6 months? Is that, there was hand
Judge, I
signals.
think that the stay away order just travels with the charge, Judge. Once you put it in, it's valid until the case is resolved, in my experience. I think the state will agree.
Okay, all right, thank you. This is, this is a felony. What day is today? The second day of August 2025. Thank you, Mr. White, for correcting me in the kindest way possible. And the next stay away order, the court is ordering the defendant is prohibited from having any contact with the following named person, hereinafter the victim, initials JC, date of birth August 7th, 1991, directly or indirectly, in person, in writing, by telephone, pager, fax, or through third persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and or school at all times. Also, electronic contact such as emailing, texting, Facebook Messenger, or by Twitter is prohibited. All right, thank you very much.
Judge, have a nice weekend.
Thank you, you too. Is that it for you, Mr. White? Is that it for him? I have a couple other ones you took out of order.
Yes, that's for, one's for family and the other one, everything that is for collections.
Okay, Antoine Trenard Griffin, page 12, I think. 12, 13. 13?
Page 13, Judge?
Yeah.
Yes.
Thank you.
He's en route, Judge. He's not here yet.
He's en route. He's en route. I apologize. All right, Edicto Meserene Sanchez, page 15.
Can you repeat the last name, please, Judge?
Sanchez.
Got it. Thank you.
Reset tomorrow.
Reset tomorrow?
Your Honor, I can
Refuse
go
to-
ahead and waive his presence, stand mute as to PC and request standard bond 2,500 is what Judge GLAZER typically issues.
Can I get one 2,500? No objection, Judge.
All right, standard bond, $2,500. The Public Defender's Office and no PC argument. All right, thank you very much. Next case on page 15, last name Moreno Cordova, first name Santos.
Refuse court, reset tomorrow.
Your Honor, I can go ahead and waive his presence, stand mute as to PC and request standard bond of 2,500.
No objection from the state, Judge.
Okay, waiving presence. Hold on a second. Do I need to indicate that anywhere, Mr. Benetti?
Sorry?
On the waiving presence, do I need to indicate that anywhere?
No, just the above.
Okay. What was the bond amount again?
2,500, Judge.
And be sure to write PC found.
PC found, yes.
If you found PC, if you did not. Yeah.
Thank you. I haven't done any other ones, so we'll have to.
Bring it back to me.
Okay, thank you. Thank you. You changed it up the system for me. All right. 16, page 16, Young, Mr. Lawrence Trevon Young.
Refuse court, reset tomorrow.
Your Honor, I can go ahead and waive his presence, stand mute as to PC, and I would request standard bond on both counts.
All right, I'm finding PC. And what are these standard bonds?
Judge,
Grand theft and communication.
we would be asking for an elevated bond here. I understand it is a grand theft, but given the extensive amount of open cases he has and open charges, we would asking that bond be set at $10,000.
How many open cases and charges does he have?
So, Your Honor, he has a total of 5 open cases.
It's an added
I'm
charge,
not-
Judge.
Sorry?
It's an added charge.
It's an added charge.
Oh, added charge. All right, then standard bond, Judge.
Okay, standard bond. Count one, grand theft, how much is the bond?
75, it's enough too. Yeah, 7,500.
Okay, $7,500 for that one. And count 2,500?
Yeah.
Count two, $2,500, thank you. I'll figure it out by the end of the hearings. Case, page 17, Augusto Cesar Marino.
He's in Ward D, reset tomorrow.
Okay. Ward B, all right, reset for tomorrow. All right.
This is the regular ballot.
Okay.
Ask if corrections has gotten that.
Is Mr. Griffin, there yet? Or is he still en route, en route? He's still en route?
Yes, Judge, he's still en route. We're at the top now. Back to the top of the calendar. This is Ms. Ross present.
No, thanks. I was told to ask. Thank you. All right, Colleen Ross. You're charged with F3, felony third degree, grand theft. Any probable cause argument? No probable cause argument?
Your Honor, I would just note that an iPhone 11 is quite old. I believe the value is actually around $150 now, and it does indicate some mental health issues. This clearly should have been in Baker Act rather than an actual arrest for a felony. I would ask for a lower bond amount of $1,000.
No objection from the stage, Judge.
Okay, so the bond is $1,000?
Yeah. Standard is 25 to the departure. No objection from the state.
Okay,
1,000, Judge?
yes, $1,000 bond. Stay away order? Okay, where's the stay away order? Okay, I apologize. Can you bring the defendant back? Ms. Ross, I am ordering you prohibited from having any contact with the following named person hereinafter: the victim, Francisca Ross, directly or indirectly, in person, in writing, by telephone, pager, fax, or through third persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and or school at all times. Also, electronic contact such as emailing, texting, Facebook Messenger, or by Twitter is prohibited. Thank you. I think this is Colleen Ross. All right, Christina Moreno. For the felony as well, or? Oh, yes, understood. All right, count two is $1 bond, right? I gave it to, yes. I'm just notating here. You're here, Ms. Moreno, for count one, controlled substance possession, crack cocaine. Public Defender's Office has been appointed. Any argument on probable cause?
Your Honor, defense stands mute as to PC. I understand that you gave her an ROR on her other case. I'd ask that you match the bond for that case, for this case as well.
Which case got RR?
Gave $1 bond on the other case. a
Yeah, it
misdemeanor.
wasn't RR, $1.
Right, Your
Benchmark.
Honor, we'd be asking for standard bond.
The standard bond for this charge.
2,500.
Any argument against that?
Yes, Your Honor, I would ask for TAP instead.
For what?
TAP, the alternative program.
If she qualifies, we have no objection.
Okay, corrections, does he qualify for TAP? Not with you? Yes, yes. I didn't know if corrections knew or who knows.
They're not here on the weekend, so if you do, they'll talk.
All right, I'll give it TAP.
Alternate.
Alternate bonds, $2,500. Thank you to all involved who asked the question. Rosa Lisette Rojas.
She does require the services of the Spanish interpreter, Your Honor.
Perfect.
And Your Honor, just for the court's knowledge, the victim in this case was trying to get on Zoom. He's been having connectivity issues. I don't believe he's on the platform. Our office provided his information to us and we tried to contact him. I don't think he's on the Zoom.
Señoría, para
Sí,
que lo sepa el tribunal, la víctima estuvo tratando de ingresar a esta reunión de Zoom. Creo que tenía problemas de conectividad. Nuestra oficina se comunicó con él.
State, were you given any information on what the alleged victim wanted to say, if anything?
No se
Unfortunately
le
not.
comunicó información acerca de lo que quería decir la presunta víctima. Desafortunadamente no.
Your Honor, I'm going to go ahead and stand mute as to PC. I do note the lack of priors, so I'd be requesting pretrial services.
Señoría,
Okay.
no voy a alegar nada en relación a la suficiencia de indicios. Observo que no hay antecedentes, por tanto, pido la fianza estándar.
All right. Excuse me?
Without activated, but if you want to order them, you can order them. We don't take that, otherwise.
Okay, so I'm finding probable cause, state.
Standard bond judge.
Okay,
Determino que hay suficientes indicios fiscal. Pedimos fianza estándar, juez.
yeah, what's the standard bond again for felony one?
For
Fianza
the
estándar.
F1 judge, it's gonna be or wait, no, this is an F3.
Yeah, with a deadly
Yeah,
weapon,
it's gonna be 5,000 judge because there was use of force here.
right? That's okay,
Serán
that's what I was asking.
$5,000 porque se usó fuerza.
Okay, count one is $5,000. I'm gonna enter a standard bond, given the use of force or alleged
En el
use of
primer
force.
cargo, la fianza serán $5,000 en vista de el presunto uso de fuerza.
Oh, we're going in order. Thank you. Appreciate that. All right, count two is a $1,000 bond.
Cargo
Right,
2,
standard.
$1,000
And
de
Your
fianza.
Honor, we're passing up a stay away order as well.
Yes,
Sería. Pedimos una orden de alejamiento también estándar.
I'll read that right now.
La leo ahora.
Oh, we did? That makes sense.
Ya lo leo.
I thought I filled the name up.
Rojas Rosa.
That makes sense. Okay, we'll take the one we just gave you back.
Yeah, no,
Count
The
two,
one-
1,000.
El
Excuse me?
cargo $2,000.
Okay, that makes sense.
Count two is 1,000.
Yes, count two is $1,000.
Y el cargo 2 son $1,000.
Okay, I'm gonna read the stay away order now. The defendant is ordered not to engage in any criminal activity.
Leo la orden de alejamiento. A la acusada se le prohíbe inmiscuirse en actividades delictivas.
Do not use or possess any illegal drugs.
No use ni tenga ninguna droga ilegal.
Do not use, purchase, possess, or carry a firearm.
No use, compre, ni tenga, ni porte ninguna arma de fuego ni arma.
Gun, weapon, or ammunition.
Pistola, arma o municiones.
You must immediately surrender any firearms.
De inmediato tiene la obligación de entregar cualquier arma de fuego que tenga.
Ammunition and any concealed weapons permits.
O municiones o cualquier permiso para portar armas ocultas.
To the nearest police department and file a receipt with the court.
A la estación de policía más cercana y presentar un recibo al tribunal.
The defendant is prohibited from having any direct or indirect contact
Se le prohíbe a la acusada que tenga contacto directo o indirecto
with the victim, Osley Fernandez,
con la víctima Osley Fernández,
including contact in person, in writing, by telephone,
incluyendo contacto en persona, por escrito, por teléfono,
through social media or any other electronic means,
a través de medios sociales o cualquier otro medio electrónico,
or through third persons.
o a través de terceros.
Defendant must stay at least 500 feet away from the victim.
La acusada tiene que mantenerse a por lo menos 500 pies de distancia del acusado, de la víctima, perdón,
The victim's home, place of employment, and/or school at all times.
o de la casa de la víctima, del centro de trabajo de la víctima o de la escuela de la víctima en todo momento.
Does the defendant live with the alleged victim?
La acusada vive con la presunta víctima.
Yes, Your Honor.
Sí, su señoría.
The defendant may return to the victim's residence
La acusada podría regresar a la residencia de la víctima
one time only
únicamente una vez,
within 48 hours of the entry of this order,
en un plazo de 48 horas a partir de que se dicte esta orden,
accompanied by a police officer,
acompañada por algún policía,
to retrieve his or her personal clothing,
para recoger las pertenencias o la ropa personal de ella,
personal health items, medication,
cosas para su salud o medicina,
personal and business related paperwork, and work tools.
documentación vinculada a su situación personal o de negocios y herramientas de trabajo.
Going to the home or remaining at the home without the police
El ir a la casa o permanecer en esa casa sin la policía
will subject the defendant to arrest.
podría resultar en que la acusada sea arrestada.
The police officer shall request all keys and garage door openers to the home.
La policía tiene la obligación de pedirle que entregue todas las llaves de la casa y cualquier dispositivo para abrir el estacionamiento del vehículo.
From the defendant and turn them over to the victim.
Se los debe pedir a la acusada y entregárselos a la víctima.
That concludes the stay away order.
Eso termina la lectura de la orden de alejamiento.
Mr. Griffin is present, Judge.
We skipping, oh, Mr. Griffin, sorry.
Number 44 on page 13, Your Honor.
Okay,
Remaining on the stay away order, Your Honor.
okay. We have individuals in the courtroom. I don't know if the public defender can see.
And Your Honor, just for the court's knowledge, we were informed by our office that the victim's mother was going to be present on Zoom for this on behalf of her son.
Okay, is she on Zoom? Is the victim's mother on Zoom?
He's present, Your Honor.
Oh, okay.
Hello.
She specifically requested a stay away order and she asked to not speak unless the court wishes for her to speak.
Okay, just making sure I'm confirming. You would not like to speak, madam?
Hello.
She's on behalf of the defendant, Judge.
Oh, so who's the victim's mother that's here in court?
No, on Zoom, on Zoom.
Oh, on Zoom. Okay, my apologies. Okay. All right, so,
Hello.
okay, there you go.
That's her problem. The victim's mom.
Okay, I'll give you an opportunity to speak in a moment, but for now, this is felony 3rd-degree assault, aggravated with a firearm.
Defense stands mute as to PC. Your Honor, I'd be requesting standard bond of $5,000.
All right, probable cause is found. State, any argument on the bond?
Yes, Judge. We would ask for a $7,500 bond, given his priors. He's had priors for other firearm related offenses. And in this case, it's an aggravated assault with a firearm to a minor. The facts warrant a higher bond amount than the standard. We would ask for $7,500 as the bond amount.
Okay, And at this moment, I'll hear from the victim or the victim's mother.
Hello.
Yes, ma'am. This is Judge Perez Santiago, called Mr. Griffin's case. I understand you're the victim's mother.
Yes, sir.
We're discussion now is about the bond amount. Is there anything you want to say about what we're doing in this proceeding?
Okay, so my son, he's 16. His name is Reginald Jones. He's right now currently afraid of him. He's afraid of him and he don't want him nowhere near us. So I'm here to see if you guys can proceed with putting a stay away order.
We will
in
be entering
process.
we will be entering a stay away order.
Yes.
Okay. All right. Public defender, any argument on the elevated bond given the accusations in this case?
No, Your Honor, I stand on my previous request.
Okay. Going to issue a standard, not a standard bond, okay.
Our class stay away order because he has kids in the same facility and her son comes on that side, so. He still has to see his kids, he got absolutely.
Okay, so state any issue, any argument or anything you can tell me about that?
I mean, Judge, the stay away order is from the victim. As long as he just doesn't come into contact with the victim who's a minor in this case, he shouldn't be coming into contact with the minor, period. So as long as he just doesn't come into contact with him, it's not an issue.
So is it okay, because I want you to understand how the
What-
facility is set up. Is it okay for her son to come on that side while he's visiting his own kids?
What facility are they at and what is the setup of the facility?
Okay, so they stay on the whole other side. He can go up other stairs and so on. But he does come up those stairs on purpose. So I'm just trying to see, I don't want no issues. It's an apartment.
So-
Yes, it's an apartment.
So, Judge,
It's an apartment.
the way stay away orders work is defendants have to stay away from the person they're noticed to stay away from. Victim can go about their life any way they wish to choose. Obviously, if it becomes a different situation where the victim is seeking out the defendant or whatever, but you're gonna give him verbal notice that he can't go anywhere near this person or contact them in any kind of way. So as long as you inform them that they are to stay
I
away
was
from
just,
the victim.
understood. I'm just making sure that's not a circumstance in which, there's just no
Excuse me.
way to see, basically a stay away order is precluding him from seeing other members of his family. That's
Excuse
what I was
me, Your
investigating.
Honor.
Yes.
Okay, this is a stay away order, but he is not allowed to be on the premises at all. He is not on the lease or anything. The rent office is aware of this. They have everything and they know. They told her, his wife, to tell him he cannot come back on the premises. He's very much aware of that. So he can't come over there no way. And he has to go past my house to get to his house in any way.
Okay, understood. So,
So if I have to contact my rent office Monday morning to get this issue squared away, I will do that most indefinitely. Because they
Okay,
have everything.
the state asked for an elevated bond, correct? $7,500. I'm going to issue an elevated bond to $7,500. And I'm going to read the stay away order now. Okay?
You're
Welcome. The stay away order is, I'm prohibiting the defendant from having any contact whatsoever with the following named person here and after the victim, RJ, initials RJ, date of birth 11/19/2008, directly or indirectly, in person, in writing, by telephone, pager, fax, or through third persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and/or at school at all times. Also, electronic contact, such as emailing, texting, Facebook messages, or by Twitter is prohibited. I'm scratching at the 6 months.
Yes, thank you, Judge. That's my mistake.
Okay? This order will travel with the case. And it's one charge, okay, $7,500 bond. Is this Alina Maria Corbato? No, doesn't seem like it's, is it Alina Maria Corbato?
She's reset medical isolation. Medical, reset medical.
Oh. Mr. Benetti, do I have to notate anything here for that?
Yeah. On the back of the A form, the page. We said we put R/F, and this tomorrow will take 8-3 medical.
Okay.
I go first.
Sorry.
So just anywhere on the side, there's RS. Tomorrow's date, medical.
Okay, resetting August 3rd, 2025, medical. Has this been previously reset?
No, Judge.
Just making sure, just making sure. Thank you. Appreciate it, thank you. Jasmine Jones.
Reset medical isolation.
Reset medical isolation. Okay.
I'm sorry, what was the reason, Judge? Over here?
Reset medical isolation. Reset to tomorrow's date. Shakia Travon Jenkins. She's on page 2.
Reset medical isolation, Judge.
Reset medical. Okay. Mr. Benet, putting it in this thing, right?
Yes.
Right here.
What's that?
Yes, make sure. Sorry.
Great.
All right. Veronica Lynn Rogers, number 2.
Bond out.
Bond out.
Yeah.
Brianna Shantavia Johnson.
Bond out.
Tiffany Chanel Bailey.
Refuse court. Reset tomorrow.
Okay. Louis Pages. Bias.
Yes, he's present, Your Honor.
Okay, he's being charged with felony of 3rd degree assault aggravated with a firearm. Any probable cause argument from the state, excuse me, from the defendant?
Defense stands mute as to PC, Your Honor. Given the lack of priors, I would be requesting pretrial services, alternate standard bond. Mr. Pages does have a different location where he can stay.
Corrections just mentioned that he does not qualify for pretrial.
Your Honor can order him into pretrial services.
Okay, and this is aggravated with a firearm. State.
Yes, Your Honor, so we would object to that because it's aggravated assault against his wife. We would just ask for standard bond.
I'm gonna order standard bond. Standard bond, where we got it?
So this is an F3 with a show.
5,000?
5,000.
Yeah, $5,000, okay, thank you. All right, I'm gonna issue a stay away order. Mr. Pages or Bajes, the defendant is prohibited from having any contact with the following named person here and after the victim. Yolelisa Pages, directly or indirectly, in person in writing, by telephone, pager, fax, or through third persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and/or school at all times. Also, electronic contact such as emailing, texting, Facebook messages, or by Twitter is prohibited. This order shall remain in effect until case is closed. Thank you.
What's the bond amount, Judge?
$5,000. And Mr. Bramblett is present, so,
This is just for the reading of stay away order, Judge.
yes. I can take Mr. Jackson if this is Jefferson Jackson first, then I can read Mr. Bramblett.
Jackson refused court, reset tomorrow.
Okay, refuse court, reset tomorrow. Who's this defendant?
This is Mr. Guzman, Your Honor, number 13 on page 5 or the bottom of page 4.
With the Guzman?
No, we're on Miles George right now.
Hold on.
Miles George is gonna be a bond out.
Miles George was a bond out, is that what the, okay, George Miles, right?
Yes.
Okay, thank you.
Okay, I'll take Mr. Guzman, and then the next person will be Mr. Bramblett, who I'll read the stay away order to. All right, Mr. Guzman, you are charged with second-degree felony of controlled substance, intent to sell or possession with intent suspected crystal meth.
Your Honor, did you already address the camping and misdemeanors this morning? I believe that's also a charge. The ordinance.
I'm not sure. It was not on the calendar this morning. The camping is on this calendar, yes, sorry. So yeah, we have not addressed it. It's also camping, I'm sorry, it's a local ordinance, camping in Miami Beach.
Hey, Your Honor, I do have a PC argument for the local ordinance. Camping requires either creating a campfire or actually sleeping. The A form only says that he was laying down. It looks like 12 p.m. yesterday. It was over 100 degrees yesterday, so there's no camping. Because of the lack of camping, I believe this would lead to suppressible issues of the controlled substance as well. That's not necessarily a PC argument, but I did want to raise that to Your Honor's attention.
State.
So Your Honor, while I understand the climate of Miami, having grown up here, it clearly states in the A form that he had bags, utilizing them as storage for personal belongings. I think there's more than enough here for probable cause for the camping argument. As to the bond amounts, we would just ask for standard bond amount of 150 on the camping ordinance, and $1,000 downward departure for the F2.
Again, Your Honor, camping does require sleeping. That's specifically listed in the ordinance. The state didn't address that at all. And having possessions is not indicative of camping at all. If I go sit down somewhere with my purse, am I camping there? No.
Right, so Your Honor,
It does.
given the time at night, it was, or no, sorry, time of day. Okay, never mind. I retract that.
Yeah, within the four corners of the A form, I don't find probable cause for the camping violation local ordinance. Okay, so let's address the felony argument. felony issue, no probable cause argument there?
Because they searched him based on this camping ordinance that Your Honor found no probable cause for, they would have no basis to search him and find these drugs, Your Honor, or alleged drugs.
State.
Your Honor, we have no objection to ROR on count 1, since count 2 is ROR.
Okay. We'll do
Sorry.
ROR.
Just to be technical, count 2 should be release outright, given that Your Honor did not find probable cause.
Yeah, all right. We're gonna do ROR for count 1. And is Mr. Guzman homeless? I know that was asked and the was said no in the A form, but is he homeless?
The jail card stays homeless, Judge.
Yeah, okay, so ROR count 1. Do we have any hearing dates for that? A homelessly hearing date, or is that not for felony?
We going to put some happy on it?
No, just ROR.
ROR?
Judge, was count 2 released outright?
Release outright count 2, yes.
Thank you.
Future court date will be on 9/2, Your Honor.
Okay, what time?
9 a.m. I'll say.
Judge James 4-5.
Are you typing code or?
Sorry.
I know, I'm just kidding. It's an old system.
Your Honor, could you repeat the?
Oh, sorry. Well, the hearing date is September 2nd, 2025 in courtroom 4-5. What judge? Judge James, Zachary James, 9 a.m. Is that the hearing time?
Yes, sir.
9 a.m. Okay, so the next hearing date, 9/2/2025, courtroom 4-5, 9 a.m. Yes. And we're gonna have a stay away order? No, because yes, that's right. Thank you. No stay away order. Thank you. Is this Mr. Mace?
Yes, Your Honor.
Okay. You're here for 2 felony charges of deadly missile, shooting a deadly missile or throwing one, criminal mischief, and misdemeanor for assault.
Defense stands mute as to PC, Your Honor. I'd be requesting tap alternate standard bond on all counts.
Okay, so the probable cause found. State the bond issue or release conditions.
Your Honor, I understand why he's homeless. He has a very extensive priors. The state would object. I believe this should just be set at standard bond for all counts.
I'll issue standard bonds for all counts, given the fact that there's a 2nd-degree felony for deadly missile, shooting one. So given that, I'm gonna go with the standard. The standards are C.
I believe for a 2nd-degree felony, Your Honor, it's typically 7,500.
7,500.
Agree at 7,500. And Your Honor, we're also asking for a stay away order from the incident location.
Sure, hold on, $7,500 for count 1. Count 2 is $2,500.
Correct.
And count 3 is $250. Okay, and stay away order. Mace. Okay, Mr. Mace, I'm ordering you to stay away from the following address area. Limousines of South Florida, 3737 Northwest 43rd Street, Hialeah, Florida, 33142. That will travel with the case until it closes. Okay.
Excuse
All
me.
right, Mr. Jose Rivera, do you need an interpreter?
Excuse
Oh,
me,
sorry,
Judge.
Mr. Bramblett. I need to call
Yeah.
Mr. Bramblett right after this one. I apologize. Oh, is Mr. Bramblett in the courtroom or in the, excuse me? in
He's
the-
on Zoom, Judge. He's ready to go. He's on Zoom.
Oh, he's on Zoom? Okay, thank you. I appreciate that. Mr. Bramblett, your attorney was previously here and waived your appearance, presence, and stipulated to a bond amount. But I have to read to you, so you're aware of the stay away order. You are prohibited from having any contact with the following named person here and after the victim. Charles E. Eddings, directly or indirectly, in person, in writing, by telephone, pager, fax, or through third persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and/or school at all times. Also, electronic contact such as emailing, texting, Facebook messages, or by Twitter is prohibited. That'll last until the case is closed. Mr. Bramblett, there was some discussion in the courtroom about what would occur given that you used to live with her or the victim, and the victim has moved out. To the extent the victim needs to collect any belongings from the apartment, the court requires either, if you are there, for a police officer to be there as well. If you are not there and she's accompanied by a family member or something, she can do that without police officer present. But if you are going to be in the area, or you're going to be at the apartment, police officer needs to be present, okay?
Yes, sir.
Thank you, Mr. Bramblett.
Thank you.
Okay, Mr. Rivera?
Is there anything?
Are you done with him, Your Honor?
Yes, I am. I apologize. Thank you.
You're welcome.
Is there a bail or bond?
They said a $3,500 bond, sir.
$3,500 bond? Okay. Thank you.
Mr. Rivera, this is, you've been charged with a first degree felony for burglary with assault or battery. I appointed the public defender's office. Any probable cause argument?
Fortunately, no, Your Honor. Defense stands mute as to PC.
Okay, probable cause is found.
Your Honor, we do have a motion for pretrial detention if Your Honor is inclined to grant it. It is somewhat redundant because he is being charged with a punishable by life felony, so it is within Your Honor's discretion to grant or deny this motion.
Punishable by life felony, but any argument you want to make on the record?
None, Your Honor. I think that the facts speak for itself. He should be held no bond. It's a punishable by life felony.
Is the state granting the motion?
If he's going to grant it.
What was your question?
So the question the clerk just posed to the state was, if the state is going to be handing up a motion for pretrial detention, and the state will do that if Your Honor is inclined to grant the motion. And as I stated previously, the motion is somewhat redundant because it's a punishable by life felony.
Public defender's office, any argument on that?
Your Honor, legally, I have no argument, but the state is correct. This is likely going to be withdrawn on Monday.
Correct.
But the state does have to file this motion legally.
Oh, okay. Thank you. Thank you, counsel.
That's fine. Pretrial detention. Granting. Okay, so the count one pretrial, no bond.
No bond. And the state is handing up a motion for pretrial detention for Your Honor.
Okay.
Are you setting a bond for count two, Your
Honor? Any argument on the bond for count two, misdemeanor, resisting officer without violence?
No, Your Honor, I have no argument. Given that he is being held no bond, I'd request $1 bond on that charge.
State?
No objection, Judge.
All right, $1 bond on the misdemeanor?
And I'm finishing the motion.
For pretrial detention?
Yes.
Your Honor, do you need anything else from Mr. Rivera?
No, thank you.
Do you keep order still as well?
Yes.
I'm so sorry. I just realized I didn't do that. I only didn't rush it. My mistake. I'm so sorry.
I'm still handling some paperwork over here, but yes, I don't need him.
Understood, Your Honor. We're bringing Mr. Diaz.
Thank you.
Just so Your Honor is aware, Mr. Diaz is present and requires the services of the Spanish interpreter.
El señor Díaz se encuentra presente, necesita el intérprete de español.
Might as well make use of your son.
Definitely, Your Honor. Free labor, so it's all about.
So the public defender is aware. The commentary now was about one of the state's children is in the presence and is passing a paper. So
Oh, that's cute.
Thank you for the clarification, Judge.
yeah, just want to make sure that the record doesn't have you.
Very necessary.
Thank you. There you go. Thank you. This you. Thank you.
They sound
Right.
like the most important worker in the room.
All right, Mr. Diaz, you're charged with 2 felonies, second-degree battery aggravated with a deadly weapon, third-degree assault aggravated with a firearm, and 2 misdemeanors, misdemeanor weapon, firearm, improper exhibition, and unlawful discharge of firearm, public place, and residential property.
Señor Díaz, se le acusa de 2 delitos graves, agresión con un arma y también agresión con un arma de fuego y 2 delitos leves o menores que son mostrar indebidamente un arma de fuego y disparar un arma de fuego.
Your Honor, defense stands mute as to PC. I'd be requesting 5,000 count 1, 5,000 count 2, 500 count 3, and 500 count 4.
Señoría, en relación a la suficiencia de indicios, la Defensoría Pública no va a decir nada. Pido que se le imponga una fianza de $5,000 en relación al primer cargo, de $5,000 en relación al segundo cargo, de $500 en relación al tercer cargo y de $500 en relación al cuarto cargo.
I'm going to find probable cause, state any argument on the proposed release conditions.
Determino que hay suficientes indicios. Fiscal, ¿alguna comentario acerca de la propuesta en relación a las condiciones de libertad condicional?
Your Honor, we're asking for a stay away order, and as to the bond amounts, we would just ask for a standard amount, but we would have no issue, Your Honor, granting the public defender's request.
Public defender's request again, sorry.
Su señoría, en relación a nosotros vamos a pedir que se expida una orden de alejamiento en relación a la propuesta de la defensa. No nos oponemos si su señoría impone la fianza estándar.
Well, again, I apologize. What were the requests from the public defender's office for the 4 counts?
5,000 count 1, 5,000 count 2, 500 count 3, and 4.
¿Qué me pidió la Defensoría Pública en relación a fianza? $5,000 en relación al cargo 1, 5,000 al cargo 2 y $500 en relación a los cargos 2 y 3 cada uno.
Okay, I will issue bonds for count 1, $5,000, count 2, $5,000, count 3, $500, count 4, $500, and issue a stay away order.
Muy bien, impongo las siguientes fianzas en relación al cargo 1, $5,000, $5,000 en relación al cargo 2, $500 en relación al cargo 3 y $500 en relación al cargo 4. Expido e impongo una orden de alejamiento.
The court orders the defendant prohibited from having any contact with the following named persons.
El tribunal prohíbe que el acusado tenga ningún contacto con las siguientes personas que voy a nombrar.
The victim, Luis Torres, directly
La
or
víctima,
indirectly.
Luis Torres, directa o indirectamente.
In person, in writing, by telephone, pager.
En persona, por escrito, por teléfono o por beeper.
Or fax or through third persons.
A través de facsímile o a través de terceros.
Defendant must stay at least 500 feet away from the victim.
El acusado tiene que permanecer por lo menos a 500 pies de distancia de la víctima,
The victim's home,
de la casa de la víctima,
place of employment, and or school at all times.
del centro de trabajo o escuela de la víctima en todo momento.
Also, electronic contact
Y también en relación al contacto mediante medios electrónicos,
such as emailing, texting, Facebook messages, or by Twitter
como por correo electrónico, textos, mensajes a través de Facebook o de Twitter,
is prohibited.
queda prohibido.
The stay away order will run through the close of the case.
Esta orden de alejamiento permanecerá en vigor en tanto dure el caso.
Keep forgetting to put PC found, so please, if you find them.
Determinó que hay suficientes indicios.
This is Mr. Paez, and does he need an interpreter?
This is not Mr. Paez, Your Honor. This is Mr. Fontanillas, number 19 on page 6.
What happened with Mr. Ricardo Paez?
He went to the bathroom.
And Nathan Ulseth? And what happened with Nathan Ulseth?
I haven't been told.
What was the other name?
17 is Ricardo Paez, 18 is Nathan Ulseth.
And what happened with Pius?
Paez went to the restroom,
Okay, never mind.
so we're passing him for now. And
They're bringing Mr. Olseth, Your Honor. We can still do Mr. Fontanillas.
okay, we got Fontanillas.
The one right after Ulseth.
Yes. Okay, Mr. Fontanillas, you are being charged with third-degree felony and shoplift, inventory device, and third-degree felony, petty theft, more than 2 convictions. Probable cause argument?
Defense states meet SPC, Your Honor. I'd be requesting standard bond both counts.
Okay, I find probable cause for both, both charges. State release conditions?
Judge, we would ask for a stay away order in addition to an elevated bond in the amount of 5,000. He has several convictions for petty theft in his past, and additional priors as well involving violence.
What are the priors involving violence and how remote in time or how close in time to the present offense?
Okay, so I apologize, Your Honor. The ag assault was no action, but the violent crimes would include resisting or no, that's without violence. Okay, that's my mistake. Okay, so Your Honor, the violent crimes have been no action on his prior criminal arrest history. He just has more than 5 convictions for petty theft or grand theft in his criminal history.
Okay, so you're arguing for elevation. What's the standard bond
The
for these?
standard here would be 2,500. Since it's an F3 judge, we would ask for 5,000 per count. He continues to do the same thing and continue to get arrested.
That's what the public defender's office are asking for, standard, correct?
That's correct, Your Honor.
All right, so count 1 and 2 both are third-degree felonies, and standard is 5,000 for both.
Standard is 25. If this doesn't have a use of force would make it 5,000. So
Sorry, you meant $2,500 times 2 is 5,000 total.
that's correct, Judge.
All right, so I'll go standard and issue a stay away order.
2,500 each?
Mm-hmm. The stay away order There it is. Mr. Fontanillas, the court orders you to stay away from the following address or area: the Nordstrom at 4310 Ponce de Leon Boulevard, Coral Gables, Florida 33146. The stay away order shall remain in effect until the case is closed. Thank you, Mr. Fontanillas.
Your Honor, we do have Mr. Olseth present now.
Perfect. Okay, Mr. Olseth. You are being charged with second-degree felony for retail theft with a prior conviction, third-degree felony for controlled substance possession, methamphetamine, and a misdemeanor cannabis possession charge. Any probable cause argument on the public defender's office?
Your Honor, I don't believe this would qualify under the second-degree felony of retail theft. I believe it would qualify under the third-degree felony of a petty theft, 2 or more convictions. He's accused of taking less than $9 worth of food, not clothes, merchandise, anything like that, Your Honor.
That's
I
correct,
know.
Judge. State would stipulate, this is not a retail theft, this is a petty theft, and it would be a felony because it is 2 or more prior.
But it's a felony 3, third degree.
Correct, third-degree felony.
Okay, so on that stipulation, we're going to be felony third degree.
Oh, yes, Judge, so yeah, standard would be 2,500. State would be asking for a stay away order here with an elevated bond of 5,000 for the theft or the theft charge. He has several, I think at least 10, Judge, from what I'm counting here, arrests or convictions for petty theft. There's at least 5 convictions for petty theft. He continues to, and these are all within the last 3 years, Judge, 5 years actually. So we would be asking for an elevated bond on the theft charge.
And defense would be asking for TAP alternate standard bond on these cases, Your Honor, given that he is homeless.
State.
No, Judge, we would object to TAP. He continues to violate the laws of our society. He continues to steal from stores, and he's not learning his lesson.
Okay, so felony third degree, the standard is $24,500, and you're asking for elevated to 5,000?
Correct, Judge.
And the standard for the third degree felony for controlled substance possession, methamphetamine?
2,500.
Public defender office, do you have anything on that?
Your Honor, I'd ask for standard on count 1 of 2,500, standard on count 2, and $1 on count 3.
I'll give $1 on count 3. I'm going to elevate count 1 to $5,000, given that this is a repeat violation, multiple violations. I think the state said there's 10 and a lot in the last 3 years. So I'm going to elevate it $5,000 on count 1. No alternate tap, and count 2, I'm going to do standard $2,500.
And
Count
count
$3.
three, $1.
Correct.
Is this tap?
No tap. No stay away order. Mr. Olseth, I'm ordering you to stay away from the following address or area: Publix, 12800 Biscayne Boulevard, North Miami, Florida, 33181. This order runs with the case until the case is closed. Thank you. I believe I had this person earlier. Is this Mr. Paz? And I had Mr. Soto Chamel earlier. And
Yes,
Mr.
Your Honor, this is Mr. Soto.
Who is this? Paz or Soto?
Mr. Soto, he does require the services of the Spanish interpreter, I believe.
Okay, immigration hold.
I
Orden de
apologize. Your
retención
Honor,
por
you said there was
parte
an
de
immigration
inmigración.
hold?
Su señoría,
That is what
alguien ha
we've been
dicho
told.
que tiene una orden de retención por parte de inmigración. Eso es lo que se me ha dicho.
Was that a yes? Was there an announcement of an immigration hold?
Yes.
Yes, it was stated earlier this
Sí.
morning on the misdemeanor calendar.
Sí, su señoría ya escuchó a este caballero en relación a los casos de delitos leves.
So Mr. Soto Shamal, we saw each other earlier, but now we're here on your felony third-degree charge for possession of cocaine.
Señor Chamel, Soto Chamel, nos vimos anteriormente, pero ahora usted se encuentra ante mí en relación al caso que usted tiene pendiente por el delito grave de tercer grado de posesión de cocaína.
Your Honor, defense stands mute as to PC, but given the lack of priors, I'd be asking for 1,000 on count 1 and $1 on count 2, especially given that there is an immigration hold as well.
No objection from the state.
Señoría, la defensa no va a decir nada en relación a la suficiencia de los indicios, pero en vista de la carencia de antecedentes penales, pido que se le imponga una fianza de $1,000 en relación al primer cargo y un dólar en relación al segundo cargo, en particular, además, por la orden de retención por parte de las autoridades migratorias. No me opongo, dice el fiscal.
Okay, so count 1, $1,000 bond, count 2, $1 bond. I think count 3 I already issued a bond. Was it a $1 bond? Count 3?
Yes, Your Honor, I'm being
$1
told
we
that's
gave him earlier.
Entonces, la fianza en relación al primer cargo son $1,000, $1 en relación al segundo cargo. Tengo entendido que ya le impuso una fianza de $1 en relación al tercer cargo, ¿correcto? Contesta la defensa, sí, así es, señoría, usted ya le puso esta fianza en el tercer
What was
cargo.
the bond for this case again, Judge? I missed him.
$1,001 for both counts. Count 1 is 1,000, count 2, $1.
Thank you.
La fianza en este caso, ¿cuánto es, su señoría? $1,000 en relación al primer cargo y $1 en relación al segundo cargo, un total de $1,001.
Thank you.
Gracias.
Is Mr. Pies okay?
Yes, Your Honor, he's present.
No. Pies. Okay. Does Mr. Pies require the services of an interpreter?
No, Your Honor.
Judge, this is Paez, right? Last name?
Yes, he's
Yes, number
Page
17 on
6.
page 6.
Did I get a statement order earlier from Mr. Pies? No, I wouldn't.
And Your Honor, defense does stand mute as to PC for this case. I believe the last mark on his record is from 2019. I'd be asking for pretrial services.
Okay, I have a message from his sister. It says he has dual diagnosis bipolar. So just for the record, qualifies for pretrial.
No objection from the state, Judge.
Okay, so we're gonna order, what's the bond for this?
Alternate bond would be $7,500. It's absolute grand theft.
Okay, PTS alternate, what was it again? Sorry.
75.
Find probable cause, obviously. Are there any mental health services if you can't bond out? For Mr. Pies in the system? That I can, or,
Judge, he will see mental health while he's here at some point.
okay, just making sure. Thank you.
You're welcome.
Again, for the record, the chat, Mr. Paz's sister is claiming he was in Jackson Behavior and New Hope Court. Is this Mr. De Loyola Suarez? I believe I saw him earlier.
No, this is not, Your Honor.
Who's this?
This is Mr. Rosales, Your Honor. The next one down.
Where is Mr. De Loyola Suarez? He was supposed to be next. At least in my
I don't-
paperwork.
No, Your Honor, he hasn't been brought.
Is he en route or refusing or something going on?
You can pass him, Judge. He'll be here shortly.
All right,
He's
thank you.
coming in.
All right, thank you. All right,
They brought him, Your Honor, never mind.
all right, whoops. Okay, we have Mr. De Loyola Suarez. Do you need the services of interpreter?
Usted, señor de Loyola Suárez. Caballero, ¿usted necesita los servicios del intérprete?
Yes, Your Honor.
Sí, señoría.
I believe we saw each other earlier, if I'm not mistaken, but we're here now for a third-degree felony, controlled substance possession, crystal meth.
Nos vimos anteriormente, pero en este momento estamos viéndonos aquí en relación a un delito grave de tercer grado, posesión de metanfetamina.
Any, obviously, public defenders representing you, anybody, any probable cause argument?
Naturalmente, la oficina de la defensoría lo representa a usted, pero ¿hay algún alegato en relación a la suficiencia de indicios?
Defense stands mute as to PC, Your Honor. Given the lack of priors, I'd ask for pretrial services, alternate standard bond.
La fianza guarda silencio, pero en relación a la suficiencia de indicios, pero en vista de la carencia de antecedentes penales, la Defensoría Pública pide que se le ponga una fianza estándar.
Okay, correction says he qualifies. Okay.
Se nos indica la Departamento de Prisiones que él califica para servicios previos a juicio, por tanto se otorga.
Would Your Honor consider applying that to the misdemeanor as well? I believe you only gave it a straight bond.
Señoría, podría decidir que eso también se aplica en relación al delito no grave, porque tengo entendido que usted solamente le impuso la fianza estándar.
Excuse me, I'm sorry, what was the response? I can't do it because the misdemeanor clerks aren't here?
No lo puedo hacer, ¿por qué? Porque los actuarios de los casos leves no se encuentran.
Your Honor, I believe the jail card would just need to be updated. Correction still has that.
Señoría, tengo entendido que la tarjeta de la cárcel debe ser puesta al día. Tengo entendido que
They
el
gotta be in the
Departamento de
system as
Prisiones lo
well.
tiene. También se tiene que colocar en el sistema.
Okay, I'm receiving no's from everyone who has a heck of a lot more experience than I do with criminal and corrections and pretrial services, so I assume it cannot be done right now.
Understood, Your
Estoy
Honor.
recibiendo notificaciones por parte de personas que tienen más experiencia que yo del Departamento de Penitenciario, por tanto, estimo que no se puede hacer.
Okay, so again, pretrial services in the alternative $2,500 bond for count one.
Entonces será servicios previos a juicio y como alternativa en relación al primer cargo, la fianza son $2,500.
The count two, did we give?
It's on the calendar.
It's on this calendar, okay, and count two is pretrial services, alternative $500.
Y en el segundo cargo, servicios previos a juicio y una fianza alternativa de $500.
Okay, and I also find probable cause, in case I hadn't said that already.
En caso de que no haya dicho antes, determino que hay suficientes indicios.
All right, thank you very much.
Muchas gracias.
What was count one alternate bond, Judge?
$2,500, the standard.
Thank you.
La fianza alternativa, ¿de cuánto fue, juez? $2,500, eso es lo estándar. Gracias.
Mr. Rosales Gonzalez? All right.
Do you need Mr. Rosales or Mr. Loyola for anything else, Your Honor?
No,
¿Se
no, ma'am.
necesita al señor Loyola para algo más? No, señora.
Okay, Your Honor, Corrections is asking to take a client out of turn, number 26 on page 8, Mr. Young.
I'll find it. I'm sorry. That as much, I can do that. I can
Can we
read.
have the first name for Mr. Young, Joe?
Desmond Jamal.
Okay.
Sorry. All right, Mr. Young, you have several charges, you're being brought to me before today, felony life murder, first degree with a deadly weapon,
Your Honor, I believe that is an attempt.
attempt, third degree felony assault aggravated with a firearm, and a second degree felony for firearm discharge from a vehicle, and a misdemeanor, unlawful discharge firearm, public place, residential property.
Your Honor, defense stands mute as to PC.
All right, let me take a quick look at this. All right. Probable cause found. Release conditions state.
Judge, we're gonna be asking a stay away order from the victim as to bond amounts for count 1. He should be held no bond. It's a life felony. As to charge number 2, which is 3 counts, we would ask that each bond be set at the standard amount of $5,000 because it is a show of force. So it'd be 5,000 per count times 3. And then on the F2, we would ask for a standard bond of 7,500.
And Your Honor, I'd ask for a dollar bond on counts 2 through 6 because he's being held no bond on count 1.
And the state is also handing up a motion for pretrial detention.
All right, I'm gonna grant the motion for pretrial detention, no bond for count 1. I'm gonna go standards down the line.
5,000 count 2, 3, 4. 7,500 for count 5, and 500.
What's count 5, Judge?
75.
7,500.
And count 6 was
$500.
Thank you.
You said you didn't ask for stay away order, did you?
Yeah, Judge, we asked for a stay away order from the victim.
Or stay away? Okay.
A
Yes.
stay away, yes.
Or stay away order.
There are, 4 victims in this case. 4 stay away orders.
Yeah, it's that. I a couple of times I thought about it and forgot. Appreciate it. All right. So I'm gonna read a stay away order. There are 4 separate orders, but I'm gonna read them all at once. The court orders the defendant prohibited from having any contact with the following named persons hereinafter the victim: Zachary Wilson, Vernon Johnson, Desire Johnson, Jakaya Johnson. Directly or indirectly, in person, in writing, by telephone, pager, fax, or through third persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and/or school at all times. Also, electronic contact such as emailing, texting, Facebook messages, or by Twitter is prohibited. These orders run until the case is closed. Thank you. I don't know if I said probable cause is found.
Your Honor, Corrections is asking to skip to page 14, number 49, Jesse Thompson.
Yes, he's the last defendant in the pile. At least in my pile. Okay, this is Mr. Thompson. You were here earlier, I believe, in misdemeanor calendar, and now you are here for a second-degree felony escape. Public Defender's Office is appointed. Any probable cause argument?
Your Honor, I stand mute as to PC, but given the lack of priors, I would ask for a reduced amount to $1,000.
Find probable cause.
Judge, we're asking for standard bond here. Despite the lack of priors, he tried to escape from a correctional facility. Standard bond.
All right. What's the standard bond for this one?
$7,500. It's a second-degree felony.
Standard bond, $7,500. Obviously intent to flee. And he is homeless, so there's a apparent difficulty if he does make bond. So that's my finding. Thank you.
What was the bond amounts?
$7,500 for the second degree felony, which is the only one on this affidavit. No further discussion with Mr. Thompson. Thank you.
Your Honor, we do have number 46 on page 13, Mr. Laney present before the court.
Last name was Laney.
Yeah.
Laney, number 46.
We're looking. Added charge, okay. Page 13, Mr. Devin Laney, Devin Eugene Laney.
Yes, Your Honor.
Okay, so Mr. Laney, you are being charged with third degree battery by detainee on visitor or other detainee. Is there any probable cause argument?
Defense stands mute as to PC, Your Honor. I'd request standard bond of $2,500.
Okay, the probable cause is found, state.
No objection as to standard bond, Judge.
All right, standard bond, and the bond for that is that 5,000? 2,500? Thank you all. I was just checking to see if you're paying attention. Thank you. Right. See, we're getting creative with the out of turns. Not an issue, just. Rosales Gonzalez? Okay, and is there any need for interpreter services?
He requires the services of the Spanish interpreter, Your Honor.
Necesitamos un intérprete de español.
Okay, Mr. Gonzalez, Rosales Gonzalez, you are being charged with second degree battery with a second degree aggravated battery with a deadly weapon.
Señor González Rosales o Rosales González, se le acusa de el delito grave de agresión con un arma mortífera. Es un delito grave de segundo grado.
And a third degree felony for possession of cocaine.
Y un delito grave de tercer grado, posesión de cocaína.
Any argument from Public Defender's Office on probable cause?
Defense stands mute as to probable cause, Your Honor. Given the lack of priors, I'd ask for pretrial services, alternate standard bond.
La defensa tiene algún alegato en relación a la suficiencia de indicios. Su señoría, en relación a la suficiencia de indicios, guardaremos silencio. Pedimos que, en vista de la carencia de antecedentes penales, que se le imponga la fianza estándar como alternativa a servicios previos a juicio.
Okay, probable cause found, state.
Judge, we're asking for standard bond, 7,500 for count one, 2,500 for count two. The facts are extremely concerning here. This is a show of violence. Arguably could turn into a lot worse.
Señoría, pedimos una fianza estándar, $7,500 en relación al primer cargo, $2,500 en relación al segundo cargo. En este caso se mostró mucha violencia. Estos hechos nos causan gran desazón.
The judge shares your concern. He's putting a knife to the abdomen is a very serious alleged crime.
Este juez
All right.
comparte su preocupación. El colocar un cuchillo contra el abdomen de alguien es algo extremadamente serio.
All right, so count one, standard bond of $7,500. Count two, standard bond,
$2,500.
$2,500.
Entonces, en relación al primer cargo, la fianza estándar, $7,500. En relación al segundo cargo, la fianza
And
estándar,
additionally, we're asking for a stay away
$2,500.
order from the victim.
And I will be entering a stay away order.
Y además pedimos una orden de alejamiento y dictaré una orden de alejamiento.
Mr. Benetti. This one I wrote on here. I don't know if we're supposed to go anywhere else.
No, I guess they can.
Thank you.
Yellow for you.
Okay.
The defendant is prohibited from having any contact with the following named person.
Se prohíbe que el acusado tenga cualquier contacto con la siguiente persona que voy a nombrar.
The victim, Elinda Palma Fernandez, directly or indirectly.
La víctima, Elinda Palma Hernández, directa o indirectamente.
In person, in writing, by telephone, pager, fax, or through third persons.
En persona, por escrito, por beeper, por fax o por teléfono.
Or through third persons.
O a través de terceros.
Defendant must stay at least 500 feet away from the victim.
El acusado tiene que permanecer por lo menos a 500 pies de distancia de la presunta víctima.
The victim's home, place of employment, and/or school at all times.
De la vivienda de la presunta víctima, de su centro de trabajo o de su escuela en todo momento.
Also, electronic contact, such as emailing, texting, Facebook messages, or by Twitter, is prohibited.
También todo contacto mediante dispositivos electrónicos como correos electrónicos, textos, o cualquier otro tipo de correo de comunicación electrónica también queda prohibido.
Facebook messages or Twitter.
Y también es prohibido a través de mensajes de Facebook o de Twitter.
All right. Thank you.
Gracias.
Christopher Short.
Shorter, Your Honor.
Excuse me, Shorter. My apologies. Christopher Shorter. You're here for 3 charges. Second degree possession with intent to sell cannabis within 1,000 feet of a school. Third degree felony for possession of cannabis with more than 20 grams. And a first degree misdemeanor for drug paraphernalia, possession of drug paraphernalia with intent to use. Any probable cause arguments?
Defense stands mute as to PC, Your Honor. I'd be requesting pretrial services, alternate standard bond.
I find probable cause. State.
Judge, we would object to pretrial services. He does have prior criminal history. Most recently, as 2021, he was convicted and sentenced to a year of probation on a felony criminal mischief. So we would object to pretrial services.
What are the facts of that criminal mischief? Do you not the specific facts, but any context to what that entailed?
Judge, I simply can't provide any context. I just see he took a conviction on that January 23rd of this year. And he's currently serving probation for that.
Okay.
Your Honor, that probation is terminated.
Oh, okay. Oh, that is correct. I apologize. That's my mistake. I do see that probation was terminated on July 17th, 2025. Your Honor, given that he just got off of probation for a felony charge, we would ask for standard bond.
Okay. And I'm gonna go standard
Darn.
bonds.
I would just note this isn't fentanyl, cocaine, methamphetamine.
I understand, but it's also possession with intent and within 1,000 feet of a school. So I'm gonna go standards.
So,
So
Judge, for
quickly.
count one, it's gonna be 7,500 standard amount for second degree felony. Count two, it's gonna be 2,500 standard amount for a third degree felony. And then for the misdemeanor, it will be 500.
Okay. The additional factor that I'm considering is that this is so quickly after a prior conviction and the termination of probation. And these are, I understand it's cannabis, but still intent to sell. Okay. Thank you. Is this David Macedo Vallejo?
Yes, Your Honor, he's present.
Okay, and he needing interpreter
No, Your Honor.
services? Okay, Mr. Marcelo Vallejo, you're here on a third degree felony charge for violation of CCW, CCF license. I'm not sure. Carrying concealed firearm without a license around a secondary school, an elementary school. First degree violation, first degree possession with intent to sell and within 1,000 feet of a school, cannabis, more than 20 grams. And misdemeanor, second degree weapon openly carrying. And I'm not sure he was here earlier, but driving while license suspended knowingly. I did see him earlier. Okay. All right, any probable cause arguments?
Yes, Your Honor. So I would just note that the police initiate a traffic stop. So these charges are all elevated because he's near a school, but it's the police who had him be near a school to initiate the traffic stop. That's not necessarily his choice of being within 1,000 feet. So, again, the police had him go.
I understand.
locate
I understand the argument. They pulled him over next to a school and
Yes,
now
Your Honor,
charging him
trying
with-
to enhance the charges. Furthermore, there's nothing establishing that he doesn't meet the criteria of CCF. As Your Honor is aware, having a license isn't necessarily required in Florida anymore. They still have to meet the criteria of the license. There's nothing in this A form that establishes he doesn't meet that criteria. He's over the age of 21. I can go through the entire list, but there's nothing establishing he wouldn't qualify for that. And the weapon in question is said to be, I believe, underneath or on the floorboard, Your Honor. That wouldn't be an open carry. And given that there's nothing establishing he doesn't qualify for CCF, there's no probable cause for that charge either.
So Judge, as to the concealed carry of a weapon without a permit, the state has no objection to finding no PC for that. As to the cannabis cell within a school, we have no issue bumping that down 1 degree. However, he's still armed, so it would only bump it down from first degree to second degree. I'm not sure how that would work. And then as to the open carry, it does meet the definition of open carry. It was readily accessible, unholstered on the floorboard of the vehicle. So that would meet the definition of open carry. I'm
I leave it to your honor's discretion as to count one and two.
Okay, so just for the records, for clarity, you are conceding that there's no probable cause for count one.
That's correct, Judge.
Okay, count two, you are, you're arguing about a lesser included.
Right, Judge. I'm stipulating to the fact that he was obviously pulled over in the school zone, so he wasn't actively posted up in the school zone trying to sell to other people. He just happened to be pulled over in that area, so I agree with the public defender on that fact.
Okay. And three, you are.
I disagree, and it is open carry.
Okay, so one, obviously, we are release outright on one, no probable cause. Two, lesser included. Do you want to make an argument on that, public defender, on what the bond should be for that one?
Your Honor, given the lack of priors, I would be asking for pretrial services alternate 2,500.
Does he qualify? Corrections? Okay, doesn't qualify. In the state,
Standard bond then, Judge.
what's the standard for that one? 2,500?
What degree felony would it be?
Second degree, you argued for less included?
7,500.
Did you argue, so you argued for second degree, correct? With armed?
The state, yes, the state argued for a second degree.
Public defender, you argued for 2,500?
I asked for pretrial services, Your Honor. I believe he qualifies.
The corrections just said he doesn't.
What disqualifies him, corrections?
Because he's armed. We don't think armed charging.
Armed, the armed charge.
Your Honor, I would ask that you can order him into pretrial services. And I would just note there's no, like the state said, there's no indication that he's trying to actively sell to anyone. He just happens to have a gun in the vehicle and it's not on his person.
It's on or about his person, Your Honor.
That's for the carry, open carry,
Right.
correct? I agree with the state on open carry. Okay?
No, I'm not asking about
No,
speaking
right.
to open carry. I'm just saying armed for count two. It's not on his person at all.
Isn't that a factual determination? For another judge?
It's in the A form, Your Honor, that it's not on his person.
Okay, well, that's, all right. Probable cause for counts 2 and 3, obviously, but let's go with, I'll
Well,
do.
Your Honor is finding probable cause for a lesser included for count 2. Is that correct?
Yes, sorry. The state conceded that one anyway.
That's correct.
And 3 probable causes, like I said, from earlier. The second degree felony, I will do $7,500. Not gonna order them to pretrial services. And number 3, count 3, state, I don't think I heard argument on that one.
Judge, yes, that was the open carry. We just asked for standard bond for open carry, which I believe is it is 150.
Okay, 150. Yeah, and count 4, did we already dispense with that one from a prior?
Yes,
Yeah,
Judge,
okay.
we're done.
All right, thank you. Okay, PC found on lesser included. Count 2. And PC found count 3. Thank you. Mr. Benetti, we're receiving a message from MDCR. If you would please call corrections.
I have no way of calling them here. I have to call them when I get upstairs after court.
Okay. We will call MDCR after the proceedings conclude. Or not we, Mr. Benetti. Is this Mr. Rosencrantz?
Yes, Your Honor.
Okay, I saw him earlier, and now we're here, Mr. Rosencrantz, on the felony charges, felony second degree firearm weapon ammunitions possession, a convicted felon, third-degree felony, driving while license suspended, habitual, and third-degree felony, lost property or abandoned failure to report property. Probable cause arguments?
Your Honor, I stand mute as to PC and I request standard bond on all counts.
Okay, stand mute. All right, so let me look at this. All right, find probable cause. State release conditions. Public defender's office.
Standard bond, we have no objection to standard bond.
Okay. All right, standard bonds for all three felonies. 7,500 for count one. So all three $7,500.
Count 2 and 3 are 2,500, and I believe count 1 would be 500.
Count four.
Yes, Your Honor, count 4. My
All right, that was I think did I already do that before? The misdemeanor?
He has
No,
4 counts on this case.
It's 4 counts.
Okay, sorry. All right. I see the 5th on the second page. Sorry, thank you. All right, and probable cause found and everything.
What are the bond amounts again, Judge?
5 count 2 and 3, and 500 for count 4.
I can't hear. Can you repeat the bonds, Judge, please?
$7,500 for count one, $2,500 for count two, $2,500, excuse me, $2,500 for count three, and $500 for count four.
Thank you.
Jose Luis Velis Rodriguez.
Yes, he requires the services of the Spanish interpreter, Your Honor.
Okay.
Necesita intérprete de español, su señoría.
Okay, Mr. Velis Rodriguez, you are here on a charge for a third-degree felony, battery on a person 65 or older.
Señor Beli Rodríguez, usted se encuentra aquí en relación a un delito grave de tercer grado, agresión contra una persona mayor de 65 años o de 65 años.
Any probable cause arguments?
Yes, Your Honor, nothing within the 4 corners of the A form establishes the age of the alleged victim, and I would just note Mr. Velez Rodriguez is also 78.
¿Algún alegato en relación a la suficiencia de indicios? Sí, su señoría. Nada dentro del documento del arresto indica la edad de la víctima y además el señor Beli Rodríguez tiene 78 años de edad.
Judge, it's hard to disagree with that because it doesn't state it anywhere on the A form. Typically, the age of the victim is stated on the last page of the arrest form for whatever reason. The police officers did not provide that. It should be noted, as the public defender stated, this defendant was born in the year 1946. It states that the victim is his girlfriend of 7 years. I would imagine they're close in age, but we're more than happy to reset this for a PC hearing tomorrow to see if the police officers can come on.
Su señoría, no es muy difícil no estar de acuerdo con esto. Normalmente la edad de la víctima se coloca en la última página del formulario de arresto, pero por alguna razón el policía no lo puso. Aquí sí se dice que la presunta víctima es la compañera o la novia del acusado y que han tenido una relación por unos 7 años, pero es cierto que no aparece la edad de la presunta víctima y con todo gusto pedimos que nos dé otra cita para establecer el elemento de la edad.
Age gap relationships exist, Your Honor, especially here in Miami. I'd ask that you find probable cause for a misdemeanor battery and set bond for that.
Señoría, es común que haya diferencia de edades en relaciones, especialmente aquí en el sur de la Florida. Y por tanto, yo le pido a su señoría que determine que hay suficientes indicios para establecer el delito leve de agresión y que ponga la fianza en base a eso.
Well, Your Honor, we can find out. I would believe the defendant would know the age of his girlfriend of 7 years if he would like to educate the court.
Señoría, yo creo que podemos averiguarlo. Yo me imagino que el acusado sabría la edad de la novia que tiene por hace 7 años y que él podría iluminar al tribunal en torno a eso.
I know the state wouldn't ask the defendant in his violation of his constitutional rights to remain silent.
Yo pienso que la fiscalía nunca le haría una pregunta así al acusado, infringiendo al derecho que tiene a guardar silencio constitucionalmente.
All right, so let's reset for tomorrow for additional hearing on probable cause.
Fijemos una audiencia mañana para una audiencia adicional en relación a la suficiencia de indicios.
These are serious allegations of a battery, domestic violence.
Estos alegatos son serios. Es una agresión de violencia doméstica.
Obviously, the evidence will have to come from someone other than the defendant.
Obviamente, la evidencia tendrá que venir de alguien que no sea el acusado.
This is Mr. Bell.
Yes, Your Honor.
Okay, so Mr. Bell, you're being charged with third-degree concealed carry firearm and the first-degree misdemeanor of possession of cannabis less than 20 grams. Any probable cause arguments?
Yes, Your Honor. Similar to an argument I previously made, as you and the state are aware, there's no requirement for a license with CCF. There's nothing within the four corners of the A form that establishes Mr. Bell does not qualify for the lack of a license. I'd ask that Your Honor find no probable cause for count one. I stand mute as to count two.
Judge, we have no objection to no PC for count one. We would just ask for a standard bond on count two.
All right, we're gonna do no probable cause for count one.
Release outright?
Release outright in count one. Count two. I don't know if the public defender, did you make an argument about the bond?
I did not make a PC argument. I'd ask for, given the lack of priors, I'd ask for pretrial services alternate, or excuse me, I'd ask for ROR on count two.
Judge, we would ask for pretrial services at a minimum. I mean, while I understand prior arrests that are no action aren't considered, he did have an aggravated assault with a firearm and a deadly missile throw that were part of the same case, no action back on December 2nd. We would ask
December 2nd this year?
of 2024.
2024?
Right.
Okay, and you said I'm not supposed to consider that?
Typically when judges ask for priors, it's as to withholds and adjudications. The rest for that case was no action or no prost ultimately. So it's up to Your Honor whether you take it into consideration or not.
Public defender, may I consider that?
Your Honor, I don't believe you can. That's like the state said, it's not a withhold on his record. It's not a prior conviction. I don't know the circumstances of why that was dismissed, but you cannot consider it. There are no priors on Mr. Bell's record.
Can I consider that this is marked on the A form as gang related?
I would note that although they say these gentlemen are registered gang members, there's nothing else establishing that, and there's nothing saying that this is about an argument over gang territory or anything violent happening, Your Honor.
Okay. Look, without a lot of information, this is just a marijuana possession charge. And no probable cause for anything else, so I'm gonna do an ROR on this one. When, would you be set the, well, never mind. All right, thank you.
Your Honor, I would just note that Mr. Burns is the co-defendant on the previous case, just to save time. All of the exact same arguments, I'd ask for the exact same bond on this case.
No objection, Judge.
All right, no probable cause on the concealed carry. And count 2 ROR. Thank you. Probable cause found, but ROR. Sir Ramirez, Michael Eduardo Ramirez, do you need interpreter
No, Your Honor.
services? Okay. All right, this is a third degree felony charge, possession of a controlled substance, suspected THC or THC oil / wax. Any probable cause arguments?
Your Honor, I would just note within the four corners of the A form, it doesn't say what type of THC it is. This could be hemp, this could be a legal form of marijuana.
Judge, we have no objection to ROR.
All right.
Judge, he's a fugitive from Attorney General. He is Pennsylvania.
That is my mistake, Judge. I don't have the information in front of me. That is a fugitive of Pennsylvania.
Okay, so he's a fugitive from Pennsylvania. All right, so what are we gonna do with that? What does the state
Your Honor,
want
I
to do?
don't think it would affect either of our arguments. That would just be up to Pennsylvania. He's aware of this open case.
Right, Judge. So as to the bond amount, you can ROR him on the bond amount, but he should be held on a fugitive hold.
He's still gonna stay in custody for that fugitive.
Yeah.
And
so-
that case has to be closed before he gets moved.
Right, Judge. So he's not leaving Miami-Dade County's custody because he's gonna have a fugitive hold.
All right. You heard that, public defender?
Yes, Your Honor.
Judge.
Given that he is still going to be held with a fugitive, I'd ask for $1. That way he gets credit for the time that he's serving, Your Honor.
State?
No objection, Judge.
All right, $1 bond. On count 1, which is the only count. And a fugitive hold. Thank you.
Fugitive hold in Pennsylvania. You have to wait for this case to close out, and then you'll get sent back to Pennsylvania to deal with whatever you got going on there.
This case to close out the pen? Is that what you're saying?
Yeah, but it's, the pen case.
Is Devin Lamb?
Yes, Your Honor, it is.
Okay, so Mr. Lamb, you're here for a third degree felony charge for obstructing or preventing the extinguishment of a fire and a zoning ordinance hold for Department of Corrections. I see it here.
Your Honor, defense stands mute as to PC. I'd request standard bond of $2,500.
All right, probable cause found. State on the standard bond.
Judge, we have no objection to standard bond. The court should be aware, though, however, he has the same conviction back in 2017, same exact charge.
Yeah.
I'm making the court aware.
Thank you. Corrections has said he has a hold, so he will not be released. All right, so count 1. What is the standard $2,500?
Yes, Judge.
And count 2. Oh, excuse me. I'm sorry. It's just a hold. It's a reference to a hold. All right, thank you. DC found. Long day, everyone. Long day, everyone. All right.
Power through the judge.
Yeah. Frederick Davis. And Mr. Davis. What is this? Sorry, Mr. Benny. What is this?
We got two old probation homes.
Okay.
Case numbers.
Oh, the number 10, what is that for? Gammas?
Yes, that's the division.
Division number? Okay. All right.
Mr. Davis is the VFOS defendant.
That's the probation home, Your Honor.
All right. So VFOS, violation of something, felony.
He's a violent felony and matter of special concern, Judge. So Your Honor, since he's a violent felony offender of special concern, he's not eligible for bond or any other release. You should either place a felony hold, and issue or a standard bond on any misdemeanors.
Well, this is a 3rd-degree felony for,
Right, Judge. So he's gonna be held on the probation anyways, because he violated his felony probation in 2 separate cases. But either way, we're asking for standard bond because he's a violent felony offender of special concerns.
okay, public defender. Mr. Davis, excuse me, before I don't know if I said 3rd-degree felony, suspected cocaine possession. That's the charge for this case.
Your Honor, I would just note he's not on probation for any violent offenses. The violent offenses that make him a VFOS are from 2002. Given that the state is correct, he will be held pursuant to the probation hold. Given that, I would ask for a $1 bond.
What is the standard bond for $2,500? All right, $2,500 bond. And the felony hold, right?
What's the case number you're holding him on?
F-23-16990 and F-23-17413.
Did you hear that corrections?
Yes, thank you.
Thank you. Yeah, thank you.
So.
Is this Mr. Love?
Yes, Your Honor.
All right, Mr. Love, you're being charged with 3rd-degree felony petty theft, greater than 2 convictions.
Defense stands mute as to PC, Your Honor. I'd be requesting TAP alternate standard bond.
All right, this is I'll 13 miscellaneous housing splash. I find probable cause state.
Judge, we would be asking for elevated bond of $5,000. He has easily over a dozen prior grand theft and petty theft convictions combined. He's served prison time for some of these, jail time as well, probation, and he continues to steal and commit crimes.
Okay, the standard bond for 3rd degree is $2,500.
Correct, Judge, and we're asking for an elevated of 5.
All right, I'll just go with standard bond, $2,500. Probable cause found.
And a stay away order from the incident location.
And a stay away order. I apologize. What? Stay away order coming.
That's my mistake, Judge. I should have said that.
Don't worry, Judge. They brought it back.
All right, thank you. Mr. Love, I'm ordering you to stay away from the following address area. The Family Dollar Store at 904 West Palm Drive, Florida City, Florida, 33034. And that will run until the case is closed. Okay? Is this Mr. Milian?
No, Your Honor.
This is Mr. Prats Piloto.
Are we skipping Mr. Milian?
Yeah, where's the Mr. Milian? I guess he's not.
He refused court, reset for tomorrow.
Okay, refuse, reset for tomorrow.
Your Honor, I believe there is a hold. Is that correct? Corrections?
They charge.
He's an ad charge.
It's an added charge, yes.
Oh, okay, Your Honor, I'll go ahead and waive his presence, stand mute as to PC. I'd request, given that he's being held pursuant to other cases, I'd ask for a dollar bond.
Hold on, sorry, you're waiving presence
Yes, for
for
Mr.
Mr.
Miliani.
Oh, that's right, that's right.
All right, and what's the, sorry, I missed it, because I was going back and forth between defendants.
Understood.
What is the remainder of the argument after waiving presence?
Given that these are added charges and he's being held pursuant to other cases, I'm asking for a dollar bond on both counts. I stand mute as to PC.
State.
No, Judge, we're asking for elevated bond here, 5,000. He has extensive prior criminal arrest history, some theft crimes. He's been revoked from probation for other crimes as well. We're asking for a $5,000 bond.
Any of
This case
these,
was added while in custody, Judge.
excuse me?
This case was added while in custody.
Oh, okay, all right, I'll go with an elevated bond. Is it one? It's two charges? Oh, I see only one here. Okay, you have an added charge, right, for, what's the second count?
If you look on the A form.
Ah, I see, it says two counts, I'm sorry. Yeah, okay, count 1 and 2, $5,000 each. All right, Mr. Bats Piloto. You are being charged with a third-degree grand theft and third degree.
And he does require the services of the Spanish interpreter, Your Honor.
Señor Brad Piloto, se le acusa del delito de hurto de mayor cuantía. Es un delito grave de tercer grado.
This case was added while in custody.
Este caso fue, I'm sorry, Your Honor, is the interpreter requests repetition of the charge. It may be, because interpreter was caught unawares a bit.
Oh, sorry, it's the third degree felony for grand theft.
Sí, es un delito mayor, un delito grave de tercer grado.
Any probable cause argument?
¿Algún alegato en relación a la suficiencia de indicios?
No, Your Honor, I stand mute as to PC. Given that he's being held pursuant to other cases, I'd ask for a dollar bond.
No, señoría, yo en relación a la suficiencia de indicios no voy a decir nada. Pido que se le imponga una fianza de $1. Y el motivo por el cual no tengo alegatos es porque tiene retención por otros casos.
Okay, I find probable cause. State, any argument on the release condition?
Determino que hay suficientes indicios. Fiscal, ¿algún tipo de argumento en relación a las condiciones bajo las cuales quedaría con libertad condicional?
Judge, we were just asked for standard bond. He does have open felonies, which is going to be held on, and he's previously completed diversion program for petty theft back on May 12th of this year.
Okay.
Señoría,
Go ahead.
pedimos la fianza estándar. Él tiene casos pendientes todavía y él tuvo un caso anterior en el cual terminó un programa diversionario el 12 de marzo de este año, el 12 de mayo de este año.
So how many current open cases does he have for which he's being
¿Cuántos casos
held?
pendientes tienen en este momento mediante que exigen que se lo retenga?
Three.
Tres.
Okay, so three separate petty thefts.
3 casos de hurto leve pendientes.
One is a grand theft, Judge.
Uno es un caso de hurto o
I
robo
apologize.
grave. Perdón.
So three separate thefts or three charges of theft is what he's being held on, correct?
Entonces, él está siendo retenido por 3 casos de hurto.
Yes, Judge, this is an added charge.
Sí,
Okay.
pues, este es un cargo adicional.
All right, with the standard bond, $5,000, you said? $2,500? Sorry, I'm never right.
La fianza estándar, ¿cuánto es? Me dice usted que son $5,000, $2,500. Nunca tengo la razón.
And a stay away order as well, Judge, from the incident location.
Standard, probable cause found, and I will order the stay away order.
la fianza estándar. Se estima que hay suficientes indicios e impondré una orden de alejamiento.
The court orders the defendant to stay away from the following address area.
El tribunal
Burlington,
ordena que el acusado se mantenga alejado de del siguiente sitio.
I think it's Burlington Coat Factory, 10790 Biscayne Boulevard, Miami, Florida, 33161.
La tienda Burlington Coat Factory, 10790 Biscayne Boulevard, Miami, Florida, 33161.
All right, thank you.
Muchas gracias.
That is the bond, Your Honor.
Thank you. Is this Ernesto Esteban Gallardo?
Yes, Your Honor. He requires the services of Spanish interpreter.
Él es Ernesto Santiesteban Gallardo. Él necesita de los servicios del intérprete de español.
He has an immigration hold.
Tiene una orden de retención por parte de las autoridades migratorias.
All right, so you are being charged with a third-degree felony, suspected cocaine possession.
Se le acusa de un cargo de tercer grado, un delito grave, la posesión de cocaína.
Public defender, any probable cause arguments?
Your Honor,
Persona
stand
pública.
mute as to PC. Given the lack of priors in the ICE hold, I'd be asking for a reduced bond of $1,000.
¿Algún alegato en relación a la suficiencia de indicios, defensora? Señoría, en relación a la suficiencia de los indicios, guardaré silencio. En vista de la carencia de antecedentes penales en la documentación, pido que se le imponga una fianza reducida de $1,000.
No objection from the state, that's $1,000 bond.
No se opone la fiscalía en relación a una fianza de $1,000.
Okay, $1,000 bond, probable cause found.
Bien, se impone una fianza de $1,000 y se determina que hay suficientes indicios.
Mr. Rivera is coming in.
Mr. Rivera is present, Your Honor.
Mr. Rivera, do you need the services of an interpreter?
No, Your Honor.
No, sir.
This is Edwin Rivera, Doug?
Yes, sir.
Yeah.
This is Mr. Rivera, you are charged with two separate felonies. A second-degree felony for possession of firearms, weapons, or ammunition by a convicted felon, and a third-degree grand theft with, I suppose, with a firearm. Any probable cause argument, defendant? Public defender?
A defense stands mute as to PC. Your Honor, I'd be requesting standard bond on both counts.
Probable cause found on both counts.
No objection from the state, that's a standard bond.
Okay, what is
So count one, Judge, it's gonna be 7,500, count two, 25.
okay? Probable cause found again, and $7,500 for count one, and $2,500 for count two, for a total of $10,000.
I'm standing up here, it's entire sitting, Judge.
Makes two of us. All right. Mr. Blanco Gomez?
No, Your Honor, just
Blanco.
they're bringing him. Now we have Mr. Blanco present, Your Honor. He does require the services of the Spanish interpreter.
All right.
Señor Blanco se encuentra presente, él necesita de los servicios del intérprete.
All right, Mr. Blanco Gomez, you are brought before me today for in charge of third-degree felony, cocaine possession, and a
Señor
second
Blanco
degree,
Gómez, usted se encuentra también en relación a un cargo por un delito grave de tercer grado, posesión de cocaína,
and a second-degree misdemeanor for loitering or prowling.
y un delito leve de segundo grado, el deambular o merodear.
Any argument of probable cause?
Defense
Algún-
stands mute as to PC, Your Honor. Given the lack of priors, I'd ask for tap, alternate standard bond.
¿Algún alegato por parte de la defensa en relación a la suficiencia de indicios? Señoría, en relación a la suficiencia de indicios, la defensa guardará silencio. En vista de la carencia de antecedentes, le pediría que se le permita salir a un programa que se llama TAP o como alternativa se le imponga la fianza alternativa, la fianza estándar.
Okay, so, probable cause is found.
No objection, tap would be qualified as judge.
Okay, all right, tapped and the alternative standard bonds for both counts.
Yes, judge.
Entonces se determina que hay suficientes indicios y entonces en relación a TAP, si él califica, entonces se le permitirá salir a él a manos de TAP y si no, la fianza estándar.
So judge, alternate bond amount for count 1 will be 2,500, alternate bond for count 2, 150.
Entonces, su señoría, la fianza estándar en relación al primer cargo son $2,500 y la fianza que sería alternativa en segundo cargo son 150.
Thank you.
Muchas gracias.
I'll find out.
Next one.
What?
4,
Rodney Lamont Cure.
find out.
Wait, what was the last name?
Cure.
Here, thank you.
I'll let the corrections take from here.
No, find out. Avery Chavez Cabrera, find out, and go to the bond. He should be on Deleon.
Mr. De Leon is present, Your Honor.
Three. Mr. Brooks is also bond out.
Yeah.
Home stretch, judge.
That was a really intense 4 in a row. All right, Mr. De Leon, do you need the services or interpreter?
No, Your Honor.
Okay, Mr. De Leon, you're being charged with second-degree felony of possessing a firearm or weapons or ammunition by a convicted Florida felon, and a first-degree misdemeanor for resisting officer without violence to his person. Probable cause argument?
Defense stands mute as to PC, Your Honor. I would be asking for pretrial services, alternate standard bond.
All right, probable cause found. State release.
Judge, we're gonna ask for standard bond here. He does have prior criminal arrest history. He did serve 364 days of jail time for this, as well as followed by 5 years, or sorry, not for this, for resisting an officer with violence, cocaine possession, and robbery strong arm attempt. That was 11 years ago. He served time for that, did 5 years of probation. We're asking for standard bond.
And what is the standard bond for both?
Standard bond for count 1 would be 7,500. Count 2 would be 500.
All right, standard bonds for both.
Count 1.
Count 2, 500.
I couldn't hear, count 1, Judge.
Count 1, 7,500, count 2, 500.
Thank you.
Just in case that wasn't me. All right. All right, next case.
Yes.
Is Mr. Lopez Hernandez?
Yes, Your Honor, he's present. He does require the services of a Spanish interpreter.
It's an added charge, Judge.
Okay.
Necesito un intérprete. Este es un cargo adicional, pues.
And he has an immigration hold.
Y tiene orden de retención por las autoridades migratorias.
Okay,
Defense stands mute as to PC. Your Honor, given the lack of priors and ice hold, I'd be asking for reduced bond amount of 1,000 each count.
I'm gonna find,
En relación a la suficiencia de indicios, la defensa guarda silencio. En vista, su señoría, de la carencia de antecedentes y la orden de retención por parte de inmigración, la defensa pide una fianza reducida, 1,000 en cada cargo.
okay, so I'm gonna find probable cause, letting the defendant know that it's a third degree retail theft felony charge.
En vista de todo, voy a determinar que hay suficientes indicios y se lo hago saber al acusado y que se le acusa del delito mayor, del delito grave de tercer grado, hurto en una tienda.
Judge, we're gonna have to standard bond here. He's committed 3 of the same charges over a span of a month, stealing nearly $2,000 worth of merchandise.
All right,
En vista de del cargo que tenemos, de la situación aquí, vamos a pedir que se le imponga la fianza estándar. Este acusado ha cometido el mismo delito en un mes y ha causado pérdidas que son unos $1,000.
And Your Honor, we're also gonna be asking for a stay away order from all 3 locations.
Y señoría, pido que su señoría expida una orden de alejamiento en relación a los 3 lugares.
And it should be noted that 2 of his cases occurred at the same location. Stay away order was filled out for each individual case. It will reflect the same address though.
Y indico, señoría, que 2 de los incidentes ocurrieron en el mismo lugar. Se expidieron órdenes de alejamiento en relación a cada lugar y, sin embargo, se reflejarán las mismas direcciones para 2 de los lugares.
okay, so these, I'm gonna give the standard, bond,
2,500 per count.
says 3 counts,
Impongo la
correct?
fianza estándar, $2,500 por cada cargo.
Oh, okay. I
3
see,
cases.
I see what's happening here. I apologize. I thought there was 3 more defendants left. 3 cases, so each count's gonna get, what's 2,500?
Yes, Judge.
Perdón, pensaba que quedaban 3 casos. Observo lo que ocurre. ¿Cuánto es la fianza estándar? $2,500.
All right. Anything, oh, the, stay away orders.
Muy bien, las órdenes de alejamiento.
Okay, they're going to be 3 separate written orders. I'm only going to read one, and 2 different locations.
Pedirán 3 órdenes de alejamiento por escrito y solamente voy a leer una de ellas para que conste en el acta y hay 3 lugares.
Okay, the court orders the defendant to stay away from the following addresses: Marshall's at 901 East 10th Avenue,
Excuse me, Your Honor, interpret East 10th Avenue.
East 10th Avenue, yes.
Se ordena que el acusado permanezca alejado de los siguientes lugares. La tienda Marshalls, que está ubicado en el 901 de la Avenida 10 del Este.
Hialeah, Florida.
En Hialeah, Florida.
33010.
33010.
And TJ Maxx.
Y TJ Maxx.
499 West 49th Street.
De la calle 49 del Oeste.
499 West 49th Street.
499 de la calle 49 del Oeste.
Hialeah, Florida 33012.
Hialeah, Florida 33012.
Thank you.
Thank you. Gracias.
I think that concludes the calendar.
Creo que esto da por terminado los casos de hoy.
Thank you, everyone.
Corrections, you had something you wanted to discuss with me?
Eric, you still there?
What we got?
Yes,
I'm here.
Mr. Manetti's still here.
What number is it?
Number 14. We have straight bond. You have tapping seizures. It's a mace.
Yeah. Okay.
Okay, I'll fix it now. Anything else?
I didn't hear you.
I'll fix it now. Anything else?
No, that's it. Thank you.
Thank you.
Thank you, everyone.
Thank you, Your Honor. Thank you, guys.
Recording stopped.
Ah.
Great time.